it's on another level there. Miracle.
Number 7.
In the committee room, but a few moments ago, a number of the NPP MPs appeared to have been called out of the room and they've stepped out. We do not know what that means. The committee, it's yet to formally start its sitting, but some members of the judiciary, some supporters of the Chief Justice nominee are seated in the room. So are the NDC members of Parliament and some well-wishers. I can actually see from our screens where we are monitoring Justice of the Court of Appeal, Chief for that matter, Nana Yao Opon Kodie, seated right in the audience section, awaiting the vetting of that particular Chief Justice. We wait to see how the committee would be proceeding, but we will be bringing you everything that you need to know here on Channel One Television and on 97.3 CTFM. I am Omar Rusanda Amadu, and this morning I will be doing this discussion with my colleagues in the newsroom. Fred Tetejabano is our head of current affairs. Fred, you're welcome.
Thank you, Sanda.
Sami Wiafi is our news editor here at 97.3 CTFM and Channel One. Sami, how are you doing?
Hi, Sanda.
It's going to be a very big morning, is it not? Let's talk briefly about who Justice Baffoe-Bonnie is before we even go into the main proceedings for today and the thorny and controversial issues. I don't know which of you has a CV that want to share with us briefly, Fred.
So, Justice Baffoe-Bonnie was born in 1956. He went through school, entered the law school in the University of Ghana. He was called to the bar in 1983. He spent his time doing some corporate work, and in 1992 he was called to start his judicial service, or service as a judge. So he started as a circuit court judge in 1992. So served in Kumasi for a long time, then was promoted to the High Court. At the High Court, he was in the High Court till 2006, when he was promoted to the Court of Appeal. At the time, former President John Ejikunkufo was president. At the Court of Appeal, he served for about 2 years and was promoted to the Supreme Court in 2008 at the age of 52. So Justice Baffoe-Bonnie has been at the Supreme Court for 17 years.
Wow.
As we speak. He's had a number of cases, including the case, the very popular case between Nana Konadu and others versus the state. At the time, he was at the High Court. So this was not long after the NDC went out of power and Nana Konadu and some others were sent to court for some issues. When at that particular court case, Justice Baffoe-Bonnie was the High Court judge presiding over that particular matter. He presided over the matter till he was promoted to the Court of Appeal. Justice Baffoe-Bonnie was also part of the first presidential petition which was heard in this country. This was after the 2012 elections, where the MPP, led by then candidate Nana Akufo-Addo, went to court challenging the results of the election. In that particular election, you recall that the verdict of the court was, I think, was a split decision, and one person had to now give a ruling to see who was going to win that particular case.
So the tiebreaker.
Yes, so Justice Baffoe-Bonnie was the tiebreaker who ruled in favor of then President John Dramani Mahama during his first term, making John Mahama, or affirming the election of 2012, which declared John Mahama as president. So that's when he actually also came again into the limelight. Outside that, he's had so many cases in the Supreme Court, the longest serving Supreme Court judge as we speak, 17 good years on the bench.
Does it mean he's the senior most on the bench?
Yes, as we speak now, he's the senior most judge on the bench.
You have known him on a personal level during your days as a court reporter. What kind of person is Justice Baffoe-Bonnie?
He's a very affable man. He's very respected amongst his colleagues. Justice Baffoe-Bonnie is one who he doesn't discriminate. Let me put it that way. Whether you're a journalist, whether you are a representative of the court, a lawyer, or someone who works within the judicial service, he doesn't discriminate here. He's open to listen to you. He's open to explain to you. There are times when people will reach out to him to explain some of the judgments of the court, and Justice Baffoe-Bonnie would always do that. Justice Baffoe-Bonnie is one who is also seen amongst a lot of people as a very fair person, not biased. So that's what I would say about Justice Baffoe-Bonnie. Very open. He's very accessible to people. No, it's very difficult usually to reach out to judges because of their jobs, the job they do. But somebody like Justice Baffoe-Bonnie is always welcoming to give you an advice or explain certain things within his ruling to you. That's the man who is. Justice Baffoe-Bonnie, for a very long time, I've known him, was one person who actually drove himself. Okay. He actually drove himself for the longest of time I'd known him. Wow. So this is the kind of man you have as Chief Justice.
So my first encounter with him was early this year when he was appointed, when he was made acting Chief Justice, and the director of the law school, Nanaya Opon-Cordia, who is a justice of the Court of Appeal.
The director
at the time, invited him to speak to us as students, and he just walked in casually. You know, you meet him in the corridor, you wouldn't think that this is the man who has just been made the Chief Justice. So he walks in casually and then begins having a conversation with us, tells us about his life in Goso. He attended Goso LA, Goso local government, local authority primary and middle schools. And
talks about his Odumase days in secondary school.
Yes, he has a very high sense of humor. Yeah. I'm sure maybe when the vetting starts, we may see one or two of those in here. But I think he's very much respected among a number of his peers. We are told how educated or how smart he is, people who have worked with him. For him to have handled a very delicate case like Nana Kunido Ajima Rawlings' case in the Kufuor days, that's a very difficult one. And for him to have managed it the way he managed it, because at the time, I mean, we're all following the news. Rawlings would come to court to support the wife and say he's not going to sit down. I mean, as a judge, he could have asked him to be cited for contempt, but he had to manage that. That was a very charged atmosphere at the time. And again, considering that he was promoted a number of times by John Ejekum Kufuor, and today he's been nominated by an NDC president, it speaks volumes about his impartiality, if there's any proper word to use in that particular regard. Sammy, I don't know.
In 2008, when he was appointed, he was actually tipped to become Chief Justice in future. Looking at the age at which he entered, he went to the apex bench at the age of 52. That was quite young at the time. He was actually tipped to one day become Chief Justice.
Wow.
The question was when, and maybe the when is now.
The when is now, of course, the big hurdle is Parliament. I mean, his vetting has been a subject of controversy in the news. I don't know if you can summarize for us some of the key issues, the sticking points on why the minority has disagreements with him taking over this job as Supreme Court Judge, Chief Justice.
The minority is of the opinion that there's still, litigation over the removal of the former Chief Justice, Gertrude Tokono. And so until that is brought to an end, or there is a finality, it will not be right and proper to vet a new Chief Justice. For the minority, the former Chief Justice, Gertrude Tokono, is still the Chief Justice of the Republic because they vehemently oppose or disagree the processes that led to, her removal. And so for them, from day one, since the process started, they have always objected and vehemently opposed the removal of Madame Gertrude Tokono. When the issue came up in Parliament somewhere last week, I think when the majority leader read a business statement for the week, and it was announced that Justice Paul Baffoe-Bonnie will be vetted by the appointment committee, the minority leader opposed it and said that until these issues or those 20 issues are resolved, it will not be right and proper to have Justice Paul Baffoe-Bonnie vetted by the appointment committee. But the Speaker gave a ruling indicating that today the vetting would take place. My expectation is that the minority have already said that they are not going to boycott. They will be in there. From the videos and pictures that we've seen quite a number of them, line up in the appointment committee, vetting to, ask a number of questions. And surprisingly, Umar, they've lined up their, in quote, their key lawyers, MPs, who will be, I'm sure, be doing the tough questions, for the minority side, because I've seen Patrick Boama, I've seen the Baffoe Ewua, the Meshia North MP, who is also a lawyer. I've seen John Darko, the leader counsel for the minority. I've seen quite a number of, lawyers on the minority side, including their leader.
The MP for Gushau, former NPA,
but former Deputy Transport Minister Tampoli. I've seen Jerry Ahmed, also a lawyer. So you could see that the minority have lined up their squad with, lawyers, I'm sure.
So what's happening is that now with the new structure of Parliament, during vetting, there are committees, interested committee members. So for example, now that you're going to vet the Chief Justice, the Judicial Committee is an interested committee.
Okay.
So they would be there to help in the vetting. Probably the legislative, Constitutional Legislative Committee may be there. But now Parliament allows members from other committees who have interest in the subject which is being, or the person who is going to be vetted, allow them in. So the reason why you see a number of these people is because most of them represent the Judicial Committee or the Vetting Committee or the Constitutional and Legislative Committee.
And I see also on the NDC side, so Madina MP Francis Eviaso, so he's a member of the Legal Council, the General Legal Council, he's a lawyer. And Nelson Dapamapo, the whip, is a lawyer. He's also seated on the NDC side. Of course, Doyo Ganza, not a lawyer, but a leader in the House of Parliament, seated there. So it's going to be exciting, and if the minority do not work out, that will be very good. And I'm praying that they do not work out. And so it's good to hear that they say they will work out.
I pray they do not work out. I want to hear the tough questions they have for the CJ.
Because regardless of what, I mean, so they have a challenge with the fact that there's a matter pending in the courts. The man who presides over Parliament is a speaker. A motion was brought, he has shut it down. And if he shoots it down, you have to proceed and work with that until another directive comes. And so I think that for now, Speaker Bagbin has said the committee can go ahead and do its work. If at the end of the day, the Supreme Court or whichever court is sitting over this matter decides that what Parliament did was in error, it can easily be reversed. The Supreme Court has the power to reverse legislative actions and decisions that have been taken. And so we look forward to that if there's any reversal. If there's no reversal, then it holds. And so I think they should just stay through, do the vetting. Let's see what the Chief Justice nominee is made of. Despite all the controversial issues, there are a lot of matters, legal issues that we want to hear his views on. This government has promised that it's going to bring back the tribunals. Yeah. Not that they're going to bring back. The tribunal have always been in the Constitution, except that they have never been utilized since we returned to democratic rule. We want to see how his approach would be. We want to see what his plan with expanding legal education is. They just admitted a number of students into the Ghana School of Law. We want to see what he's thinking about a lot of legislative issues are. We have this controversial issue around anti-LGBTQ law. What is his personal view on this matter? We would want to hear. We want to know what his school of thought is. We want to know what he's thinking of some national matters is going to be, because in the U.S., the reason we celebrate a lot of justices of the Supreme Court is because we know what their opinions are on public matters, and we want to know what our Chief Justice says. Whatever he says here today is going to be a matter of public record, which we can refer to the Hansard in the future and say, this is Justice Baffoe-Bonnie's position on matter A, matter B. So when this issue comes before the Supreme Court, we know that this is what his decision is going to be, or this is how he's going to handle this matter or another. But let's talk about the political side of this appointment, Fred. He's politically connected, isn't he? And that's why you see MPP people making the comments that they make. Just not the election petition, but there are other connections.
You know, it's quite interesting. This has become quite controversial for several reasons. First reason is the fact that he's been nominated to succeed a removed Chief Justice. Usually what happens is that the Chief Justice retires, passes away, and there's a they nominate a new one. In his case, he's being nominated at the point where a Chief Justice has been removed. So the Chief Justice hasn't finished serving her term. She's just been removed for stated misbehavior. There's been concerns about the process for that particular removal. People believe that that process is more political, or the reasoning is more political than legal and constitutional. There are people who also believe that the former Chief Justice was not given a fair hearing, of which he's gone back to the High Court for a judicial review. So these are one of the reasons why it makes this very controversial. Secondly, people connect him to his brother or his brothers. So Justice Baffoe-Bonnie is related to a very close friend of John Dramani Mahama. At a point was working closely with him as vice president and president. And the manager of Radio Gold at the point, Babo. Usually people, Baffoe-Bonnie, people call him Babo. That's the brother of Paul Baffoe-Bonnie. There's another brother of Paul Baffoe-Bonnie, Eugene Baffoe-Bonnie, who was involved with the National Communication Authority at a point. He was the board chairman during the first term of John Dramani Mahama. Eugene Baffoe-Bonnie was put before court and sentenced during the second MPP government led by Nana Addo Akufo-Addo. So when it comes to the political lines, this is where people look and read through that political lines. A brother of Babo, who was a close friend of John Dramani Mahama, the brother of the chairman of the NCA. But others also counter that with the fact that his rise to where he is mainly came from the line of the MPP. So appointed as a circuit court judge under the NDC, he was moved to the High Court. At the High Court, he was promoted to the Court of Appeal under the NPP. Within 2 years, he was moved to the Supreme Court. This was also under the NPP. So when there are people who are for and against that notion of he's either connected through a particular line to the NDC or he's connected through a particular line to the NPP.
So for him to have been the judge presiding over Nana Konnedo's case in Kufuor's era,
yes,
the presumption then would be that he's aligned to the NPP.
So the presumption was there is that, okay, you had a very important case in this country against no other person than the former president's wife. you did a job. Following that job, you're promoted to the Court of Appeal.
Yeah.
And in 2 years,
it's a reward.
And in 2 years, you're promoted to the Supreme Court.
Yeah.
So there are people who also believe and look at it from that line as he being connected to the NPP. And there are others who also look at his brothers and the his decision during the presidential petition as he being connected to the NDC. So Justice Baffoe-Bonnie's case is quite interesting. You could look at it from the, one side and the other side. You could also look at it from where he finds himself now, having to succeed or to be nominated to succeed a Chief Justice whose removal has been so controversial and is still fighting this particular issue in court. I won't be surprised that you will have about 20-30% of the questions coming to in relation to the removal of the Chief Justice, what he makes of the process, what he makes of the fair hearing, what he makes of even this particular vetting, where the minority have argued that, look, you need to hold on. The High Court this week, which is on Tuesday, Thursday or Friday, is going to make a decision on an injunction application. Why don't you wait? What is his view on that between Parliament carrying their constitutional duty and the court also upholding the human rights of another person? These are some of the questions that Justice Baffoe-Bonnie will be facing this morning.
And even on the same score, Umaru, the minority, we had the minority leader on Friday, he even accused Justice Baffoe-Bonnie of, not empaneling certain judges to sit on some cases at the Supreme Court involving the removal of the former Chief Justice. And so for them, they do not understand why he has refused to empanel these judges to hear, these particular matters at the Supreme Court, but yet the vetting of him is going to take place. And so you expect a lot of questions from the minority on those sides, whether, the removal process was right, devoid of politics, whether there's some underlying political tone behind it. And so you expect all these questions, coming back from the minority at this vetting.
It promises to be very hot. But Fred, you're looking at the gallery there now. Who are some of the members of the judiciary that you have noticed present in this particular room who have come to support?
There are a number of Supreme Court justices here. We have Justice Jamefe, who is there. We have Justice Avril Johnson, who is also there. I think now the pictures are gone.
Nana own justice.
Yes, the Court of Appeal.
Yeah, he's a Court of Appeal. So
he's a Court of Appeal judge.
Yeah, I think I've seen Uni Kolendi, have I not?
Yes, he's just come onto the screen. Justice Uni Kolendi is also been there.
Gabriel Scott Palmer?
Yeah. Gabriel, I've not seen him. Justice Edibo Esiedu is also there.
Okay.
The former Attorney General and legal advisor to the President is also at this particular. Marietta Biopon also is there.
And Deputy Attorney General, I've just seen him.
I've seen
there.
the Deputy Attorney General is also there.
So it's a packed room actually. Not even enough space for the media personnel there. And the room is very small. I don't know, maybe the House of Parliament should consider expanding this particular committee room so that it can accommodate more people. Promise that these people will not come and join in the vandalism of the property of Parliament. But we want to see, I think I saw Justice Jones Doche. Did I not see somebody who looks like him? They have all risen, which suggests that the nominee has arrived. Already the chairman of the committee and the MPs are seated, but the members of the judiciary have risen to pay respect to the Chief Justice nominee, who is actually the acting Chief Justice. So he's wearing two hats. He's their boss and also coming to confirm his job before the members of Parliament. And the chairperson of the committee, the members of the committee have all risen up.
Say a prayer.
They are all lawyers, of course. The front bench, except Kizel Atufo, no Kizel, Rickett Hagan. He is not a lawyer, but to the left. So it's time for prayers. Let's listen to the prayers from the committee room.
Duty as in their sight, give divine guidance to the President of the Republic, endow members of Parliament and ministers of state with discernment and vision, integrity and courage, that through the labors of government, this land and people may be well and truly served, and their good purposes for the common human life be realized in our midst. O God, grant us a vision of our country, fair as it might be, a country of righteousness, where none shall wrong his neighbor, a country of plenty, where evil and poverty shall be done away with, a country of brotherhood, where all success shall be founded on service, and honor shall be given to the deserving, a country of peace, where government shall rest on the will of the people, and the love for the common good. Bless the effort of those who struggle to make this vision a living reality. Inspire and strengthen our people that they may give time, thought, and sacrifice to speed the day of the coming beauty of Ghana and Africa. Amen. Amen. Honourable members, may I use the opportunity to welcome all of us to the vetting of my Lord, the Chief Justice to be. Honourable members, following the nomination of the Chief Justice, His Excellency, the President of the Republic of Ghana, by a letter dated 17th October 2025, communicated same to Parliament. Honourable members, this was duly referred to the Appointment Committee to conduct the vetting and report to the House. In view of that, this meeting has been organized. Honourable members, the purpose clearly is to vet His Lordship Justice Baffoe-Bonnie as the Chief Justice of Ghana. Honourable members, he has been vetted and approved by this House as Justice of the Supreme Court of Ghana. He is now being elevated to a leadership level as the Chief Justice. We are therefore here to have him vetted. Honourable members, once again, you are all welcome. Honourable members, as the tradition demands, we shall proceed to call on the clerk to have the Chief Justice sworn in.
I hereby proceed to lead the nominee to take the oath.
Chairman, for the record.
Honourable members, I believe these proceedings must be orderly. When you have an issue, the practice is that you catch the eye of the speaker, and in this case, the eye of the chairman. You don't have a right to ask anybody to stop proceedings for you to say whatever you want to say. Honourable members, The idea is, why should I refer to him as a Chief Justice but not Chief Justice nominee? Chief Justice nominee, you are welcome.
Let me see.
Honorable Habib, let me hear you.
Chairman, thank you.
I hope it's not different from what I said, Chief Justice nominee.
Close to what you said. Initially, you said the clerk shall swear in the Chief Justice. And this is Parliament, and for the record of Parliament, that will be captured. So if you are correcting it, then direct that. Your earlier statement should be expunged from the record.
Unfortunately, you don't have a right to tell me what I should do. Once the correction has been made, may we proceed to administer the oath. Clerk of the committee.
I hereby proceed.
I, Paul Baffoe-Bonnie,
Swear by the Almighty God
swear by the Almighty God
that the evidence I shall give before this committee
that the evidence I shall give before this committee
touching the matter in issue shall be the truth, the whole truth, and nothing but the truth. So help me God.
So help me God.
Thank you.
Thank you very much. Honourable members, procedurally, I will ask the members of the committee to introduce themselves. It's going to be self-introduction, starting from my left. Honourable members, only members of the committee.
So members.
Nana Eji Baffoe-Bonnie, the Honourable Member of Parliament for the good people of Menchia South, and Vice Chairman, the Subsidiary Legislations Committee.
Yes.
Thank you, Mr. Chair. My name is Hassan Tampuli. I'm the Member of Parliament for the good and virtuous people of Gushegu in the Northern Region, and then Deputy Ranking for Constitutional and Legal Affairs Committee of Parliament. Thank you, Mr. Speaker.
Thank you, Mr. Chairman. I'm Honorable Anthony Mie, Member of Parliament for Odotobri in the Ashanti region. I also serve as the Vice Chairman for the Committee on Judiciary. Thank you.
Thank you, Mr. Chairman. My name is Kwame Enyimedwentri, Member of Parliament for Asante Central and a ranking member for Constitutional Legal.
Joseph Rimpong, MP Nkoko, Chairman of the Judicial Committee. Thank you.
Kwame Apiakudia, Member of Parliament for Mfantiakwa North in the Eastern Region. Subject member. Petitions. Petitions and Judiciary, sir. I'm here as a subject matter member. Thank you.
Petitions Committee.
Petitions, and I'm a member of the Petitions and Judiciary, but I'm here in the name of the Judiciary.
The rules are clear in Standing Order 1217. Strictly subject matter committee.
I'm here on the ticket of the
and
Judiciary.
then leadership of the subject matter committee. So you are either a chairman, vice chairman, ranking, or deputy ranking of the committee. Honourable members, let me use the opportunity to clarify Standing Order 217. We do not want any confusion. If you know you are not a ranking member, deputy ranking, chairman, and vice chairman of the subject matter committee, please perpetually remain silent.
Thank you very much. Patrick Boamo, Kankwe Central, member of the committee.
Jerry Ahmed Shaib, MP for Wejagbawe, leadership.
Alhaji Habib Idrisu, Member of Parliament for Tolon, First Deputy Minority Whip, Member of the Committee.
Ano Dompre, Salma Dreji, Minority Whip.
Yes, now on my right.
Thank you very much, Chair. My name is Beat Anwatasmo Zieden. I am the MP for Laura and ranking for Judiciary, subject matter representative.
Al Hassan Umar, MP for Zabzugu in the Northern Region, a member of the Appointment Committee.
Thank you, Chairman. My name is Shaibu Mahama, MP for Daboya Mankargo, Chairman for Constitutional and Legal Affairs Committee of Parliament, and a member of the committee.
Thank you, Chairman. MP for Adan leadership. Thank you.
Ladi Ayayamba is my name, MP for Pusiga, ranking for Chieftaincy and Culture, and a member of the Appointments Committee.
Chairman, thank you. CJ Nominee, you're welcome. My name is Roxanne Nelson Dapamako, MP for the good people of Southern, member.
My name is Mahama Ayariga, Member of Parliament, Boku Central Constituency, leadership.
Thank you. My name is Kweku Ricketts-Hagen, Member of Parliament for Cape Coast South and the Vice Chairman of the committee. That's the Appointment Committee. Thank you.
Afenyo Makin, MP for Efutu and ranking for the committee.
Bernard Ahiafo, Chairman of the Appointment Committee. People also call me the Kingmaker. So, honourable members, commencement. Yes, I see you pulling the microphone. Do you have an issue?
Chairman, with respect, thank you for the opportunity, and I shall proceed with my opening remarks, which remarks I make for and on behalf of the minority caucus of this committee.
Honorable Minority Leader and the ranking member of the committee, I shall accord you every respect and the time to raise your issue. My only hope and prayer is that whatever issue that we are going to raise must be raised within the rules that governs this committee as well as the entire Parliament. The floor is now yours.
Chairman, thank you very much. I shall proceed my remarks with a quote from Shakespeare's Macbeth, Act 1, Scene 7. First, as I'm his kinsman and his subject, strong both against the deed, and as his host, who should against his murderer shut the door, and not bear the knife myself. Besides, this Duncan has borne his faculty so meek, has been so clear in his great office,
and his virtues will plead like angels, trumpet-tongued against the deep damnation of his taking off, and pity like a naked newborn baby, striding the blasts of heaven's cherubim, housed upon the sightless couriers of the air, shall blow the horrid deed in every eye. Tears shall drown the wind. I have no spare to prick the size of my intent, but only vaulting ambition, which overleaps itself and falls on the other. Chairman, this morning, on behalf of the caucus, we hear with a heavy heart, but an unshakable resolve to defend the Constitution of Ghana, protect judicial independence, and uphold the rule of law. We gather to vet a disputed nominee for office of Chief Justice of Ghana. This should be a moment of national pride and institutional renewal.
I have an issue.
Instead, it has become a test of whether Ghana's judiciary will remain independent or fall under executive and political control.
Honorable Minority Leader. Honorable Minority Leader, just hold it a second. Yes, Honorable Ayariga.
Mr. Chairman, we are here because our rules say we should be here. And the same rules indicate exactly what we can do or not do when we gather here. Order 122 and 123. I want you to focus on those two orders. 123 talks about content of speeches, whereas 122 provides the grounds on which debate can be interrupted. So I come under order 122. But my objection is founded on content of speeches. I've heard the ranking member of the committee refer to, I believe, the nominee as a disputed nominee to the post of Chief Justice. 123 says, a member shall not raise any question. 123(5). A member shall not raise any specific question upon which the House has come to a conclusion during the current session, except on a substantive motion for rescission. I recall that just a couple of days ago, I think Thursday, the same member brought a motion to the House trying to stop this committee from sitting to vet the nominee. The matter was exhaustively debated, and you, Mr. Speaker, gave a ruling. Subsequently, the Speaker himself, because you sat as a Deputy Speaker, the Speaker himself came and recounted the motion and also gave a ruling. So this issue about the propriety or otherwise of whatever happened has been raised on the floor, debated extensively, and a ruling given. Apart from that, Order 1237 says that the conduct of the Speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. You cannot raise anything about the conduct of a member of the Superior Court of Adjudicature of this country in Parliament except by a substantive motion. No substantive motion is before us, and so the ranking member has no right, no lawful authority to raise anything about what happened in court, the processes leading to a removal of anybody, and the nomination of anybody. You have no right, pursuant to our rules, to raise those issues. So be guided, because if you raise them, I'm going to object. So I am objecting to the use of the term disputed nominee, because there's no dispute before us regarding the nomination.
Yes, Honorable Habib, there is an issue raised.
Yes, that's what I'm...
And I must give the floor first to the person who raised the issue in relation to which objection is being taken to respond. Yes, Honorable Minority Leader and the ranking member of the committee. This is the issue raised to part of the submission that we have started raising. What is your response to it?
Chairman, first of all, the majority leader is clearly acting in bad faith, seeking to obstruct the rather peaceful processes we have started, and as it were, try to use his numbers to intimidate. Let me ask, the rule he relied on has to do with debate on the floor of the House. There are dark clouds indeed in this country where freedom of speech by mere operation of a supermajority, you cannot even as a member of parliament make your comment. I am not moving a motion. I am not debating. Please, Chairman, the rule he relied upon. Is it this situation where people move from here and there to create confusion and create their own jurisprudence must come to an end, with respect. Interruption of debate. That is, if you go to page 70 or the 122, the title there, the subtitle, interruption of debate. Debate may be interrupted by a point of order. And then he says that I am debating. Who is debating here? Mr. Chairman, if the majority leader has anything to say in opposition to my opening remarks, he has a right bona fide as a leader of government business and as a leader of the House to also state his submission. I have seen him with his written submission, be it for his opening remarks or see that to you as a chair of the committee to read it for answered. But this process where, as it were, try to use it to deny you, don't say this. So every line that I read, he will censor it and say, you use this word. Mr. Chairman, we are not going to make any progress with that. Again, the 1, 2, 3 that he relies upon. He says that the conduct of the Speaker, the Chief Justice, members and Justices of the Superior Court of Judicature shall not be raised in Parliament except upon a substantive motion. With the greatest respect. Have I raised any issue that is situated within the context of 123.7 to warrant this so-called objection. Chairman.
Honorable members, can we have some order?
Chairman.
Honorable members, can we have some order and listen to the minority leader in silence?
Chairman, we are here to discharge a civic duty and responsibility. We are political actors who have our political views on matters of national interest. The matters giving rise to the nomination is purely political, and every Ghanaian adult knows this. Your side raised it as a political issue during the campaign. You are going to remove Justice Tokonu as Chief Justice, and that has happened. If in my statement I contextualize to say that disputed nominee, it is our view we hold as a minority caucus. Right, we have to express it. And that is why I added by saying that this should be a moment of national pride and institutional renewal. Instead, it has become a test of whether Ghana's judiciary will remain independent or fall under executive and political control. Can't I have these bona fides also that have to be obstructed by the majority leader when you have every unfettered right to raise your issues? Chairman, humbly, please control proceedings. Please take charge. Let our respected leader of government business understand that after speaking, after making my comment known on behalf of the minority, he can seek your leave to also make his opening remarks. By the way, by way of conclusion, this is not the first time a leader in the minority is having this opportunity to make opening remarks. It predates me. From J.H. Mensah's era, he and J.H. Owusu Achampong, all the way to Alban Bagbin, MP for Naudole Kalio, and minority leader as he then was. The videos are there. Hansard is there. Honorable Bagbin had unfettered opportunity to make his political statement on behalf of the minority, and they were not stopped on point of order. It got to Chair Mensah Bonsu, it got to Harun Edrusu, and recently, my own respected colleague, Dr. Kasiel Atufosen. The records are there. Let's not create a certain impression as if all it is you are majority, so we cannot even say a word. We must have our rights. These are far right. We will state them, and you would also have the opportunity to state them for the record. Please, let us have some more.
Honorable Minority Leader, your point is made.
Yeah,
yes, you have listened to the response.
Right, Honorable.
Honorable members, it's not every issue that will necessarily call for the chair making a ruling. But honorable members, I indicated as a preliminary issue that let us all operate within the rules. Honorable members, may I add that we need to also observe the principle of brevity. Yes, what do you have to say?
Chairman, if you read rule 1233, where in the opinion of the speaker, the words of a member used in a speech, and it doesn't matter whether the speech is at plenary or at committee, a speech is a speech in Parliament. So where in the opinion of the speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives, or impugns the integrity of a member or any other person, the Speaker may order that the member withdraws those words or withdraw and apologize. Mr. Speaker, when we came into this chamber, this committee meeting room, and you started, you referred to the nominee as Chief Justice. When you refer to the nominee as Chief Justice, the minority objected to the reference to the nominee as Chief Justice and said that he is not a Chief Justice, he is a nominee to the post of Chief Justice, and so you must refer to him appropriately. Or acting Chief Justice, because he's also an acting Chief Justice. And an acting Chief Justice is a Chief Justice. Now, he has referred to the nominee as a disputed nominee. Disputed nominee. Disputed nominee. You are in court what? Are you in court litigating his nomination? No. Are you in court disputing his nomination? You are not in court challenging his nomination. So to the extent that you are not in court challenging his nomination, there is no dispute about his nomination. If there is a dispute about some other action. So you have no right to look him in the face here before this committee and refer to him as a disputed nominee and expect me to sit here and not respond. So, Mr. Chairman, pursuant to our own rules, he has to withdraw and apologize to him for referring to him as a disputed nominee when he is not a disputed nominee.
Chairman, let me.
Honourable members.
Chairman, he has had two opportunities to make a point. Let me respond to
Honourable members, Honourable Minority Leader, listen to what I will have to say.
Okay.
Please proceed and raise your issue. Avoid the use of disputed Chief Justice. Once I do not have a right to refer to him as a Chief Justice, but Chief Justice nominee, let us all observe that rule and refer to him as such.
Let me be unequivocally clear. The minority in Parliament objects to and unequivocally condemns the coordinated campaign to subjudicate Ghana's judiciary to political domination. Chairman, the facts speak for themselves.
I object again. I object again.
On the 22nd
I object again.
April,
I object again, Chairman.
On 22nd of April,
I object again.
2025.
Chairman, I object again. I object.
Hold on. Honourable members, I think at this particular point, I must place on record that I have admonished that we should all operate within the ambit of the law. Honourable Minority Leader, be guided by Order 103D, and then let's make progress. And Order 103D, if I may read, to serve as a guide to all of us. It states that a motion shall relate to a definite issue and not revive the consideration of a matter which had been considered in the same meeting unless new matters have arisen. Honourable members, by necessary implication, whether a motion or not, the principles of res judicata will not permit us that a matter that has been raised on the floor resolve to its finality would be permitted to be raised at a committee meeting. So, Honourable Minority Leader, refrain from anything that is relating to sub judice rules and let's make progress, with all due respect. Because Speaker has dealt with this matter, I have also personally dealt partly with this particular matter, with all due respect.
Chairman, the facts speak for themselves. On April 22nd, 2025, Chief Justice Gertrude Araba Isaba Tokonu was suspended as a result of a prima facie determination by the Council of State as contained in the public announcement made by the executive. We, the minority, hold the view that the subsequent committee that was set up under the chairmanship of His Lordship Gabriel Scott Poama to trial the Chief Justice amounted to a travesty of justice.
Chairman.
The removal
our rules are clearly offended.
In the language
our rules are
of
clearly
judicial
offended.
accountability.
Because the rules I just read clearly offend that.
But
the rules clearly are offended. Chairman, the rules say that the conduct of the speaker, the Chief Justice, members and justices of the Superior Court of Judicature shall not be raised in Parliament except on a substantive motion. He has just raised the question of the conduct of a Supreme Court judge who chaired the committee. And he describes it and the conduct and what the Justice did as a travesty of justice. He has raised the conduct of that judge. He has. And the rules are clear. And I can assure you that I will not allow you to breach any inch of the rules today. No inch of the rules will I allow you to breach.
Let me respond to him. Chairman, let me respond to him. Chairman, let me respond to him.
I cannot go and be giving you the opportunity when the person who is speaking is in the process of responding to the issue.
It doesn't fit in the rules.
Yes, Honourable Minority Leader, you have the floor.
Mr. Chairman.
Honourable members, order. Honourable Oman, order.
Mr. Chairman, let me make these preliminary comments before I address.
In response to.
Yes, before I address, I've made an observation. The learned Attorney General knows how much I respect him. He knows how much I respect him. And this must be reciprocated by him. When the respected learned Mahama Yariga, leader of government business, was raising his objection, I remained quiet to listen to him because I know that decency requires that we listen to each other in silence. We are lawyers, and in the East, we must demonstrate that practice in Adaba for people to know that we listen and respond. So please, unless there is another plan that I don't know, but whatever that is happening today, history is watching. Now let me respond to my respected colleague, the majority leader. Chairman, it is his contention that my reference to the committee's work amount to attacking the conduct of its chair. With the greatest respect, I need to be listened to, and he has to pay attention to language as used in context. For the avoidance of doubt, I am repeating that the minority holds the view that the committee's work resulting in the removal of Her Ladyship, the Chief Justice, amount to travesty of justice. It is a view we hold. It does not offend Order 1237. Order 1237, with avoidance of doubt, provides the conduct of the Speaker, the Chief Justice, members of Parliament, the Chief Justice, and Superior Court Justice of Judicature shall not be raised in Parliament except a substantive motion. Now, the distinction must be made. Respected Ayarga, please, bear with me. I've listened to you. The distinctions must be made. Your work in the regular official duties and a critique thereto must be distinguished from personal conduct that one would consider as misbehavior or stated misbehavior. I am not, with the greatest respect, impugning the person of the reputation of my Lord Puaman, who I voted for under the influence of Honorable K.T. Amon. When all the odds were against him, I have nothing personal against him. Because even where there were personal issues that people were attacking his reputation, I was one of the few who stood.
Mr. Chairman.
So I'm not here to attack him.
Mr. Chairman.
And he knows I won't attack him. The caucus is talking about, please, Honorable Ayarga, let me finish. You were allowed to make your point.
Yes, but Honorable Minority Leader, just be brief.
Very well. The committee's work is what we are expressing an opinion on. And we are using very civil language to say that what it did amount to travesty of justice. It's as simple as that. So let me proceed. Chairman, unless the majority leader intends to frustrate everything that the minority has to say by way of its opinion, when did Parliament reduce to this? Where you have the right to say your own, you are the leader of the House. You have unfettered right to rebut. That is the debate we even have on the floor. When there's a debate, you take note. Where you think you disagree, when it gets your turn, you should also say that the committee's work did not amount to travesty of justice. Simplicity. But this issue of one line, point of order, next line, you are marking, don't say this, don't say that. Where are we heading to? The judiciary criticizes the government and members of the public where they disagree in their ruling. We
Honorable Minority Leader, kindly conclude for me.
The work of even
Please
the
conclude for me. Conclude for me.
I beg you, leader.
Conclude.
We all agreed, Chairman.
Conclude.
Right. So let me proceed.
Honorable members, I have listened to the majority leader.
Travesty of justice is now.
I have listened to the minority leader. Honorable members, we should be guided by the principles that if there is an issue on the floor of Parliament which has got to do with another who may not have the opportunity to respond to it, such a thing should not be made on the floor. Now, though Justice Gabriel Poma is here in person, at no point will he have the opportunity of responding to any issue raised about him. None of the committee members will have the opportunity here and then to make comment. Therefore, for you jumping into a conclusion to say that their report amount to a travesty of justice without any of them having the opportunity to respond offends our rules. I will consequently order that anything in relating to the committee and Justice Poma should be expunged from our record. That is my ruling.
Chairman,
kindly proceed.
Chairman, let me protests, the rather unacceptable, consistent attempt by the majority leader to obstruct our side's remarks in this process. I know he's your leader, but Chairman, this is unacceptable. That's it. I will proceed. Yeah. We hold a view that the removal of Her Ladyship Justice Gertrude Araba Isaba Tokonu was cloaked in some opaque circumstances unacceptable to the jurisprudence of our country.
Mr. Chairman. Mr. Chairman.
Mr. Speaker, Mr. Chairman.
Honorable Minority Leader, you know the rudiment of the game. If you don't want interruptions, let's go by the rules. Other than that, the chairman will be compelled to listen to the person and make ruling.
This one is friendly, opaque. It's friendly, opaque.
Yes, Majority Leader.
Mr. Chairman, please. Mr. Chairman, if the minority, led by the minority leader, were to walk out here and invite all the journalists, they could describe the work of the committee in any language. In any language. Nobody. Freedom of speech. But before this Committee of Parliament, the rules are clear. What you can raise and what you cannot raise, and how you can raise it. I'll be surprised if after all these years in this Parliament, you don't understand those rules. I'll be surprised. Yes, I intend to be offensive because he has told me that I am here to deliberately obstruct the minority. What did he say about that? To describe my conduct here as deliberately obstructing the minority when I'm trying to keep him to the rules. When you say the conduct of a judge, we're not talking about the personal conduct, who he slept with and who he didn't sleep with. We're talking about his work, how he conducted his work. You are saying that the committee conducted its work in an opaque manner. That's what you are saying. In darkness, that's what you are saying. And that the outcome of their work is a travesty of justice. That's what I'm saying. And you are not in court challenging the conduct of the committee. You are not. You as a person, you are not in court challenging the conduct of the committee. You know the rules in the Constitution regarding the work of the proceedings. You haven't shown at any stage that the rules in the Constitution governing the work of the committee have been breached in any way. How can you come and sit here and describe the work as opaque, travesty of justice, and improper removal, and etc., and expect me to sit here and allow you to do that? You are clearly violating the rules. And when I try to guide you how to go about your work, then you say that I'm trying to obstruct you.
Honourable Majority Leader, you've made your point. And again, if I'm called upon to do a ruling, the rules are clear that we should refrain from the use of offensive language. We are here for the purposes of vetting. A situation where the process will be used to describe the work of a committee to be opaque, meaning it was done in darkness, is offensive. Therefore, I would order that same be expunged from the record as if it doesn't exist. Honourable Minority Leader, proceed.
Chairman, with respect. Chairman, with respect, he raised the objection. You didn't give me the opportunity to respond. And you're saying that you have ruled. I mean, what is the fairness in this? He just raised the objection. He didn't refer to any rule this time. This time, he didn't refer to any rule. And then he says that we should go and do press conference.
Honourable Minority Leader, kindly proceed.
It is our contention that the process leading to the removal of Her Ladyship Justice Araba Isaba Tokonu was unfair, it lacked due process, it did not adhere to any constitutional procedure.
Chairman,
we
I
continue.
I hope, Chairman,
to say,
I hope, Chairman, that persistently violating the rules of this House is a breach of privilege. You know that. Persistently violating the rules of this House.
Chairman,
Honorable
Minority
Leader.
He's made a point. Let me make a point with respect to you.
Honorable
Chairman,
Minority Leader, if you can hear me out,
yes,
maybe the point that you want to make, you may realize that it is not necessary. Honorable members, let's have it in mind that we are not sitting here as a committee over any decision made by another committee or a court of competent jurisdiction. So bringing same or making same as a subject matter of discussion, with all due respect, this is not fair to members of those committees and those who presided over those cases. So if we are playing by the fair principles, please, let's refrain from all those things and be guided by our rules in raising our issues. Minority Leader, you just spoke about fairness. So is it fair that a committee that is not before us, their rulings are brought here and described in a manner unwarranted by our rules? So with all due respect, this will clearly be in breach of natural justice. We don't have the opportunity of the people being heard. So why are we commenting on them? So please, let's proceed. You can give your remarks, but be guided as such. Yes.
Thank you, Mr. Chair. Permit me to enter this discussion. I think that, Mr. Chair, you have to look at this, the context within which the minority leader is making this speech. You have to recognize that there is a background to the nomination of the nominee. And it will look very odd that we can have this conversation, the vetting of the nominee, without reference. It appears that there is a gag order. Mr. Speaker, the minority will have its say, but the majority would have its way. So, Mr. Speaker, what is wrong? We've spent almost 1 hour going back and forth on this simple matter. And I think that it is important that the minority leader is given his opportunity to speak. Then the majority leader can set the record straight if he thinks that he has said something that is. So I think that we should allow the discussion to flow. Mr. Speaker, it's been 1 hour.
Order.
We are still going back and forth.
Honorable Tampuli.
Let's with respect.
Honorable
Mr.
Tampuli.
Chairman, thank you very much.
In this House, we play by the rules. Now, tell me, at vetting, in raising a preliminary issue, and preliminary issues are not questions for the nominee to provide an answer. Then you bring the work of another committee entirely to vetting, describing it in all sorts of ways. Should this be permitted or it should not be permitted? So if we are all operating within the ambit of the rules, we will not have any problem. That is where the problem is coming from. The whole world is watching us. So I believe you agree with me that it is not proper, by way of preliminary issue, a work done by a committee should be brought at a vetting and be raised as a preliminary comment.
Mr. Speaker, with respect, I'm not sure the leader is relitigating any issue. what the leader is doing, with respect, as far as I'm concerned, is that he is making commentary. That is his view, his judgment. And it is the view of the minority. And I think that it should be allowed to land. Then the majority leader can speak. Mr. Speaker, I think that, look, if we are going to be too, more or less fastidious about what he's saying, we can't make progress. With respect, Mr. Speaker. Thank you, Mr. Speaker.
Honorable Tampoli, if you want to make progress, I think we can make progress. But if you deliberately don't want to make progress, we are deliberately trying not to make progress. Honorable Tampoli, guide me by the rules that govern the House. The actual rules that allow that in making your preliminary comment, you should be allowed to describe a work of a committee in a language in which the minority leader is describing them.
Mr. Speaker, in this standing orders, Mr. Speaker, may I refer you to Order 5?
Yes.
Order 5 with respect, Mr. Speaker. Order 5.1, subject to the provisions of this Constitution and any other enactments. Where there is doubt, these rules shall be interpreted by Mr. Speaker. 2, in any case not provided for in these orders, Mr. Speaker shall decide on the procedural question. And finally, 3, in exercising the power conferred under this order, Mr. Speaker shall act in accordance with the Constitution. So we think that what you are doing, it may not be provided for expressly.
No, but so what you are saying...
What you are doing amounts to being guided by Order 5.
Rules, yes.
You understand?
Yes.
So, Mr. Speaker, even under the Constitution...
So you agree with me that I'm operating within the ambit of the rules?
With respect, Mr. Speaker, under Article 297, the Constitution even contemplates an instance where something will not be provided in the Constitution or any other law. And they say the Parliament. So, Mr. Speaker, there are penumbra areas, there are gray areas where you fill in. And I think that you have to exercise your discretion to allow the minority leader to land. Because what he's saying doesn't amount to raising issues. Mr. Speaker, he's not here with a substantive motion to raise questions about whatever it is.
Honorable Tampoli.
We are dealing with...
Honorable Tampoli, I thank you very much for reading Order 5. I think Order 5 is clear as to why I am behaving the way I am behaving. But I can assure you that most of the things that the minority leader has said that I rule again, they are specifically and expressly provided for in the rules. In the rules. So minority leader can go ahead and make all his comments without touching on anybody who is not before us. He knows. Yes.
Thank you. Thank you, Mr. Chairman. Chairman, I want to draw your attention to Order 24B and D. Mr. Speaker, with your permission, I read Order 24B, that the Speaker shall promote concessions on matters under consideration in the House, and D, protect and preserve the rights of members. Mr. Speaker, I'm drawing your attention to this because the minority leader under Standing Order 24B, D, have a right, and which you have given him the permission to make his opening remarks. So I'm appealing to you to protect and preserve that right as it is in our standing order. And also, Mr. Chairman, the Order 24B, that you should promote concessions on matters. If majority leader think otherwise, minority leader think otherwise. Majority leader, after majority leader's statement, can also make statements if there are things, and you correct some of the things that he thinks is wrong. Then we can make progress, Mr. Speaker. Thank you.
Honorable Minority Deputy Whip, it is not only the right of the minority leader that is supposed to be protected. The right of everybody is supposed to be protected. The right of those committee members are also supposed to be protected. So don't take it that I am violating the rights of the minority leader in any manner whatsoever. That will be a very wrong impression. And let me state that anybody who wants to enjoy his rights should know that the beginning of your rights would mark the end of somebody's right. Thank you.
Chairman.
And keep to the rules because I will object to anything that violates the rules.
But when we do this, it's not okay. Mr. Chairman,
minority leader, don't be preemptive. Majority leader, don't be preemptive. So go ahead.
Chairman, 7 separate proceedings across 3 jurisdictions. Our own Supreme Court, the High Court, and the ECOWAS Court of Justice now challenge the constitutional validity of that removal. Not one has been heard on its merits.
Mr. Chairman.
Yet, while these cases remain pending, while the very question of whether a vacancy exists remains subject, there is a nomination to replace.
I object.
Can have the floor. Honorable Minority Leader, hold it. Majority Leader, you said you object. What are you objecting to?
Mr. Speaker.
Order.
Our rules are very clear on pending matters. Our rules are very clear on pending matters. And it says in Order 103F that a motion shall relate to definite issues and not be the subject of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interest of the parties to the action. Mr. Speaker, you see, when you keep saying motion, these rules guide proceedings in chamber and mutatis mutandi, they apply to the work of committees as well. The rules are clear. What you can't do in the chamber, you cannot do in committee. So the rules are clear on pending matters. So you can't come here and comment on pending matters in a way that will prejudice the interests of the parties. So we stay away from random commentary on pending matters. We even don't refer to them. It's clear. And I'm saying that you are a senior lawyer, you know. You've been in this house, you've been a majority leader, you've been a minority leader, you have lived through all the rulings in these matters. Pending matters, we should stay away from them. The conduct of judges, we should stay away from them. You have so far not impugned the process of nominating the nominee and submitting the nomination to this House, and the process of referral by Speaker of the nominee to this committee for the committee to do its work. Those are the legitimate matters that you can raise, and you haven't raised them. So all the questions about what happened, if you had waited and we started proceedings, and you throw a question to the nominee to get his views on the matter, I may not object. But you can't just be allowed to run down everybody and get up and walk because you are a friend of marking. Why? It will not be allowed. I am going to look, this whole issue about you making a preliminary statement, show me a rule that says that you have a right to make a preliminary statement. Show me in our standing orders anything that says that you, a friend of marking, have a right to make preliminary statements. You don't. Listen, we developed it as a practice. We developed it as a practice where normally the two leaders may make welcoming statements and general open statements, but you have converted it into a platform to do a press conference where you attack and impugn people and walk away with it. I'm saying that today you will not attack anybody and walk away whilst I sit in this committee.
Yes, Minority Leader, what do you have to say to it?
I haven't spoken. At least if I catch you.
If he gives you the opportunity, because he is on the floor. Tell him, when he said I should hear Tampuli, I heard Tampuli. Should I hear another play? Should I hear another play?
Yeah. You can hear him after that. I come and respond to him. I know if you have anything.
Yes, Honorable Anodonpre, what do you have to say on the issue raised by the majority
Speaker,
leader, Honorable Mahama Yarga?
Well, initially I didn't want to comment. We thought we should. Speaker, we in leadership have a role to play in helping you shepherd and guide this process. How does it look that the Chief Justice nominee is before us and this whole process is being reduced into a banter between the majority leader? It's been reduced into this. It's most unfortunate. And I'm surprised at some of the issues being raised by the majority leader, saying that, show us the rules that says that when there is vetting, you should be allowed to make comment. We are not only guided by rules, we are also guided by practice. Show me the rules that tells us that every Friday you should be standing behind the dispatch box and presenting petition. There are no rules on that. But it's part of our practice. And majority leader will respect you. You know this. So don't keep referencing that, saying that, show us the rules, show us the rules. It's not just about the rules. It is also about our practice. Now, the very rule you referred to, 103, when you said it could be applied mutatis mutandi, I think majority leader, you are wrong. The rules were made with specific functionality, and the 103 you quoted is on admissibility of motion. No, it's motion. And it's giving us conditions for admissibility of motion. So when you read the heading, so you are interpreting the rule to suit your understanding. A while ago, Tampuri just referenced Order 5 and says that interpretation will be done by the speaker. Allow the speaker to lead the process. Allow the speaker, the chair, to lead the process. All of us are here to support, to make sure that these things are done. But the way you are positioning yourself is giving a wrong impression, and the public is watching. You will not even allow the minority leader to speak. And you are marking every sentence, and we are here saying that that is normal. Why don't you take your note when he's done, then you can present your version of the truth.
His law teacher started marking his sentences long ago. I'm not the first person to mark his sentences. His law lecturers marked his sentences for years.
Anytime
conclude.
It appears to me, I'll conclude because you are pushing me to conclude. I'll conclude. But interestingly, the majority leader catches your eye every time. It is surprising that he always catches your eye. When we also draw your attention, let us also catch your eye. We also have something to say. Parliament is not just about the majority leader. For heaven's sake, I'm representing the good people of Insama Dredji. And when I have a view and I catch your eye, you must allow me to express him. I want to tell the majority leader, anytime he obstructs the minority leader, we will also obstruct him. No? Let him make his point. If it is a case that your strategy is that you are going to obstruct him, we will also obstruct you. And you won't make your point. But the begging question is, to what end? Are we going to conclude this vetting? What are we telling Ghanaians as representatives of the people? Speaker, I think you should rule on this matter. The majority leader should put down his points. Honorable, can I finish? For heaven's sake, can I finish? The respected majority leader I saw him taking copious notes. He should write down his points. And regardless of the fact that he's a majority, he's a member of parliament like anybody else. Let him write down his points. When the minority leader is done, then he can come in. Then we can make progress. This whole strategy of any sentence... I would have been asking questions, but sometimes when I ask questions, they take it that I'm being sarcastic. I will give the floor to Honorable Roxanne Dafamoko.
Chairman, thank you for the opportunity. Chairman, given where we are I seek your guidance on this matter. And here it is. Within the terms of Order 103, Rule D, Rule E, and F, the minority leader led a team of its members. They filed a motion. The terms of the motion, Mr. Chairman, reads as follows: that this Honorable House, having regard to Articles 110, Clause 1, 125 to 127, 144, Clause 1, and 146 of the 1992 Constitution and Standing Orders 57, Rules 1 to 3, Order 93.
Is that the motion Speaker rule on?
Yes. For the records, I'm reading the terms of the motion they filed. Yes. Order 103, Rule F, Order 216, and Order 217 of our standing orders resolves to suspend forthwith all further proceedings, both at the Appointments Committee and a plenary, on the nomination of Justice Paul Baffoe-Bonnie as Chief Justice until all pending suits and applications directly bearing on the removal of her ladyship Justice Gertrude Araba Isaba Tokonu, Saki Tokonu, including ECOWAS Court, suit number ECW/CCJ/APP/32/25 on provisional measures, multiple Supreme Court proceedings, and High Court applications are finally determined or withdrawn, and that in the interim, the Business Committee reprograms the business of the House. Accordingly, the Appointment Committee stands down any scheduled vetting related to the nomination, and that the Attorney General and Minister for Justice be summoned pursuant to Article 103 of the Constitution to appear before this House or before such committee as the House may designate, to provide a comprehensive briefing on the status of all pending litigation relating to the removal of her ladyship Justice Gertrude Araba Isaba Saki Tokonu, including but not limited to A, the identity, jurisdiction, and procedural status of all such proceedings; B, any provisional measures, interim orders, or conservatory orders sought or granted; C, the relief sought in each proceeding and their potential implications for the office of Chief Justice; D, Ghana's international obligations under regional treaties relevant to the ECOWAS Court proceedings; E, the government's assessment of potential legal and constitutional implications of proceeding with the appointment of a successor Chief Justice while such litigation remains pending; and F, any other matters relevant to Parliament's informed exercise of its constitutional functions under Article 1141. Applicants of the motion.
Well, hold on. Let me hear you, Honorable Habib. What are you objecting to?
Chairman, Parliament and parliamentary proceedings and practices. A member is not to address the House. What Honorable Roxon is doing is addressing us. Whatever he's reading, Mr. Chairman.
Honorable,
Mr. Chairman, but
you are completely out of order.
To us, Mr. Speaker.
You are completely out of order.
So, Chairman, no, he should stop.
It is only when a supplementary question is being asked.
A motion that the Speaker has ruled.
Would you listen to me,
the
Honorable
motion
Habib?
on the floor.
Would you listen to me? It is only when a supplementary question is being asked that you don't address the House. So you are completely out of order. Honorable Minority Leader, may I have your response?
Chairman, I'm not done.
Okay, hold on. Then conclude.
Yes.
Conclude.
No, I'm not done.
Then conclude.
So, Mr. Chairman, these were the terms of the motion the minority leader and his group filed. In the course of considering admitting this motion, Speaker determined that the motion cannot be admitted. Now, the minority leader, as ranking member of this committee, is using a backdoor approach. He has rehashed the terms of this motion contained in a speech, and he seeks to read that speech before this committee.
Honourable member,
it cannot be done.
You've made your point. Yes, minority leader, let me hear you.
Chairman, with respect, thank you for the opportunity. Let me first respond to the issue raised by the respected majority leader, which issue he anchored on Order 103F. For the avoidance of doubt, I would repeat the provisions in the said order. A motion shall relate to a definite issue and not be the subject matter of an action on which judicial decisions is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. These are my views on this. First of all, we are not dealing with emotion. But granted that, as he put it, this provision that deals with conditions of admissibility of motion should be read and construed within the context of my preliminary comment, then I would even yield to that and then ask a question. Was he not the same person who, when the minority brought a matter up on the floor regarding the mass dismissal of public sector employees, he came out with the preliminary objection to the fact that the matter was in court. Henry Nana Boakye has filed a suit at the Supreme Court. Therefore, Parliament should not even discuss it. Whereupon, the Speaker upheld his objection, in spite of explanation to the fact that the matter had nothing to do with the suit in court. Now, even today, now he says that my reference to cases pending at the ECOWAS court, at the Supreme Court, at the High Court, amount to prejudicing the outcome. Really? But we have a nominee before us. The nominee with the power to empanel. In fact, the empaneling of the court for the determination of injunction application was done swiftly. As we speak, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it. Recently, we heard the Attorney General even applying to the court for leave for extension of time to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it rather even applies to the case of the minority that this matter should be placed on ice, because the nominee is likely to be conflicted, especially when he is the one to empanel. Two, that the substantive matters have not been dealt with.
Minority
let
leader,
me finish.
with all
Chairman,
due respect,
you allowed the minority leader. I'm responding
not
to his
asking
objection.
the minority leader to raise an issue. Order.
I am responding
Order.
to his, I'm responding.
Honorable minority leader.
Let me respond.
Honorable minority leader, hold it. Honorable minority leader, hold it. May your microphone be off, minority leader.
Chairman, just a second. Bear
Minority
with me.
leader, let your microphone be off. Hear me out.
Very well. I will hear you.
Yes, I'm supposed to play the fair game here.
If you make your point, we respond.
Honorable minority leader,
what is wrong?
Please, just observe me.
The former boss spoke.
Hear what I will want to say. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly empaneled, acted in conflict. I mean, all those things have not
You've said that. You've said that. You've said that. You've said that. You said that. You said that the nominee swiftly empaneled a court.
So, honorable members, on this note, I would want him to conclude. I will rule on the matter, then we take a short break and come back and continue with the vetting.
Chairman, with respect, it is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority's concerns to be heard. Here is he suggesting that nothing should be raised that is likely to affect the outcome of a pending suit. That is what he says. He says that my reference to matters that are pending before court amount to a situation where I will be offending Rule 103F. If that is the case, then the matter before us is rather more fitting than the argument he's making against me. Because, with respect, we have pending suits for over 6 months.
Chairman.
I have the floor. You've not called
Chairman, the rules.
You have not called him. Chairman,
the rules.
Chairman, he puts on the rules.
The rules are clear.
No, it's not.
The rules are clear. The rules are clear. Chairman, the rules. Though when you
just comes in. But you just put on your microphone and speak. Leader, you just put on your microphone and speak. That's all right.
Honorable members, I have stated clearly, the whole world is watching us. You will not have the floor until I ask you to do so. I will consider a situation where you put on the microphone without the speaker asking you to say something as disorderly, and I will invoke the rules appropriately. So we should all take note. Minority Leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the majority leader is invoking supports the contention of the minority. And I'm responding to him by saying that the cases that are pending, that he has a problem with my earlier statement, if we consider this motion, they shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the floor.
Honorable Minority Leader, hold it there.
For him to come in?
Yes, hold it. Okay, not for him to come in. I am coming in personally. Severally, I admonish you that a matter that has been dealt with on the floor of Parliament, this vetting committee cannot be constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any of those issues to be read. Now, I accommodated the majority whip, and he read in extenso your motion. So anything that relate to your motion would not be entertained before this particular committee. Because for me, that matter, procedurally and legally, is mute. It cannot be raised. So, Minority Leader, kindly conclude.
Chairman, there are two issues that have been raised, and each of them must have a response.
When your leader is speaking, and you're asking me to give you the floor.
The Majority Leader has raised his issue. And then the Fiamakpo also brings in a different issue. So I'm done with him. Let me now address the Fiamakpo's issue, the Majority Chief Whip. The Majority Chief Whip is contending that the minority's motion was ruled upon. Mr. Speaker, Mr. Chairman, we are not here to rehash our argument. We have not brought any argument before the House. We filed an administrative motion, which motion was declared inadmissible. It's as simple as that.
You have to catch the attention.
Now, it does not stop us from stating our views on an important national matter. It doesn't stop us. We are not challenging the Speaker's ruling at this committee. We know what to do. The minority, even when we disagree with the First Deputy Speaker, filed a review application which was admitted, and we started a debate. We are not in any way against any ruling and against any rules. We will use the rules to express our views. So the Majority Chief Whip is completely wrong to introduce that matter. What we are rather saying is that the rule that the Majority Leader is seeking to invoke to rather stop the minority from exercising its right of opinion on a matter of national importance rather supports the very reason why we had come with a motion to say that let all the matters be determined to bring clarity, because Her Ladyship Justice Arabe Esaba Tokonu has rights, far right. And what becomes of her when eventually the court determines that all her beliefs are upheld, and then what becomes of us?
Yes.
What
Honorable Majority Leader. Honorable Majority Leader.
You are hearing him?
No, I am the one speaking.
What do you want?
You understand?
Yes.
Please, let's take a cue. Severally, I admonished
him or me
that everybody, that anything that has to do with a matter raised on the floor and a ruling delivered by the speakers, including me, would not be entertained. So that one, strictly, any attempt to go into that particular area, I would ask you to stop your submission and maybe go to another area. And probably we may have to take a decision if persistently you've decided not to listen to the chairperson of the committee. So I am pleading with you. You see, with Jerry Ahmed, you catch the eye of the speaker at the right time. You don't expect me to interrupt the minority leader to give you the floor to speak. It is not done in any parliament. So, minority leader, if you are done and you want me to make a ruling, I will make a ruling. Then we take a break.
Chairman, with respect, the minority on this committee is ready to assist you through this process. It is clear to us, however, that consistently there is a grand design to obstruct us, deny us of our right to express opinion on a matter of national discourse. We are clear on our minds what the majority is up to. And Chairman, although we know, and it's a fact, that all of you are of the same stock, we, however, think that we should be heard. All these objections that they are raising here and there has one aim, that the minority must not be heard for posterity. They know that if these views get into Hansard, it will come back and haunt them Sunday. That is all that they are doing. Chairman, it's not a matter for ruling. I hold a view on behalf of my colleagues that you should restrain the majority leader, because it is one too many, very consistently, the statement that I made as part of my remarks that he is invoking Order 103F is neither here nor there. I didn't make any prejudicial comment. I didn't say anything that offends Order 103F. It is very clear what he is up to. Let us be very fair. Let us allow democracy to be at play. They are in the majority, no doubt. They are in majority, no doubt. But they should allow us. I'm responding to, you see, Chairman, Chairman, what the majority leader is doing, is not fair. He raises his issues, you don't have to respond. When you are responding, he now determines how you should respond to him. The chief whip has spoken. You have spoken. When you are talking, you don't calculate the hours.
Because Honorable members, order.
When you are talking,
order.
When you are talking, you don't talk about the
on this note, we will break for cocoa. So it's time for cocoa break.
A lot of talking that has not really ended anywhere, and so the Committee on Appointments has had to break for cocoa, to quote the chairperson, the Honorable Deputy Speaker of Parliament, who is chairperson of the Appointments Committee. So they've taken a cocoa break after having sat for more than an hour debating on whether or not Alexander Afenyo-Markin should say some of the things he was saying in the statement he was saying by way of opening statements. And, well, let me just say that if you're just joining us, you haven't missed the vetting, because the vetting hasn't started yet. This is just preliminary, and it's taking us so much time. Guys in studio, gentlemen in studio, we anticipated that it was going to be a long day, but we didn't think it was going to be long based on preliminary debates. Were you expecting that the fight was going to be on Afenyo-Markin's opening remarks and not even the questions that would be asked of the CJ? Fred?
Not at all, not at all. We're expecting a long day in terms of questioning the Chief Justice nominee, but it looks like the day is getting longer because the minority leader wants to make his preliminary comments. The majority leader has decided that he's going to mark every sentence of his to ensure that he is going by the rules. The chairman of the committee is also has taken a stance where he says that he's going to ensure that the rules are followed. For me, this is quite disappointing for both sides. Why a preliminary comment should drag this long when you have a nominee, you have respected justices of the court, from the Supreme Court to the Court of Appeal, all the way down, all seated, waiting for the nominee to be questioned, to be vetted. I don't see why just a comment, a preliminary comment, should drag this way. And this brings me back to this very appointment committee of Parliament for this particular Parliament. Their work has been very disappointing.
Yeah.
Very, very disappointing. From the very beginning of the vetting of President Mohammed's ministers to deputy ministers, now to the Chief Justice.
To the fighting, the breaking of tables and chairs.
It's been very disappointing. We expect a lot more from these honourable members than what we are seeing. I'm still shocked that we are wasting so much time as to people going to make political statements.
I mean, we were expecting to see the vetting of the Chief Justice nominee happen. Even the use of the word Chief Justice was subjected to debate, whether or not the chairman of the committee can refer to Justice Baffoe-Bonnie as Chief Justice. And so he was asked to withdraw that particular word. And then the issues that were raised in the House of Parliament earlier about whether or not he should be vetted, the minority holds a view that the Alexander Afenyo-Markin, the chairperson or the minority leader, is trying to reintroduce the same motion he brought, which motion was dismissed. And so it's been a lot of time wasting, I think, on nothing. I was going to say much ado about nothing, but I do not think I want to use that phrase or that term. Sami, this was advertised to start at 11 a.m. It is 1:18 p.m. or 1:15 p.m. where the chairman, clearly out of frustration, says they are taking a break. It's not as if he had advertised that they would go on a break, but you would see that this break was taken out of frustration so that perhaps they can do a lot of backroom consultations, which I thought they would have done already.
I feel the leadership of Ahafo as chairman of the committee has come, to be questioned again. As Fred mentioned, when we saw the vetting some months ago on the president's nominees, we saw chaos, for want of a better word. And this is how it started. And we are likely seeing this as far as the vetting of the Chief Justice, is concerned. I am not surprised at what you are seeing, because when you realize the mood of almost every individual seated in there, you anticipate that, we are going to expect something like this. From the word onset, and when the prayers were being said, when you look at the position of Afenyo-Markin, you realize that, there's something cooking. And so I'm not surprised that we are seeing what we are seeing now. And Sandra, believe you me, when they come back from the break, we are still going to have what we are seeing at the moment, because it looks like the two leaders have all taken entrenched positions. And Afenyo-Markin is determined to say whatever he wants to say. Mahama Yariga on the other side also wants to rebut everything Afenyo-Markin also wants to say. And so, even when they come back from the break, after meeting and trying to do backroom, negotiations, we are still going to see what we saw a while ago. I'm not going to see any change. We are not going to see any changes as far as this year, because Afenyo-Markin is determined to register the minorities' protest. They tried to do it on the floor of the House. It didn't work. And so they feel that there's an opportunity. Everybody's watching. The world is watching. All the media houses are kind of like, so it's an opportunity to register their protest. Even whilst he was making that statement, his political party, the NPP, has also issued a statement.
I'll let you read that statement for us. So if you could just find that statement and read it for us, because I want to see whether the position of the party is what the committee, the minority side is espousing in the House of Parliament. But Fred, Sami thinks that even if they return, this may still not go anywhere. But what I'm happy about is the fact that the chairman would make a ruling. And when he makes the ruling, everything is settled. So there are two options after he makes the ruling. Either the minority side agrees, that's if it's not in their favor, or they walk out. Either way, I think the vetting can come up. And I think, again, it reminds me of the early days of the Ahafo-led committee, The early days, if you monitor social media, a lot of NDC people were disappointed in him. They say, oh, you sit there and watch Afenyo Markin to run the show and all of that. And then a few days later, he comes and then he was cracking the whip. I don't know what happened, whether he's trying to be lenient in this first part of the sitting, only for him to possibly show his powers, because the committee chair has a lot of powers. He's the chairman of the Speaker's Committee. He can order for someone to be removed from the committee room. You heard him prevent some people from introducing themselves and all of that. So I do not know. Do you get a sense that this chaos would continue? It's not chaotic in the sense of the word, but this the obstruction that we keep seeing, this back and forth that is ending nowhere, do you foresee this coming up when we return, or you think that things may simmer down? The only ruling which will stop this is when the chairman of the committee says, okay, there's not going to be preliminary comments. Let's go straight into the vetting. But preliminary comment has been done already. No, I think he hasn't concluded. He hasn't concluded. He's still in the middle of that preliminary comment. Oh, okay. What is happening is that they are still debating and over certain comments he's made within his preliminary comment. For example, he referred to the nominee as a disputed nominee. Yeah. That was challenged. Yeah. There's been others. He went to talk about the process of the committee which had the Justice Tokonu case as being opaque. That was challenged. So he's not concluded his preliminary comment. It's just that there are challenges on every comment he makes on his preliminary comment. Which is what Ayaga promised to do. He said every inch. Yes, what Ayaga has promised to do. So for me, I think what the chairman of the committee should do is to come, rule, and say, enough is enough, no preliminary comment, let's move on to the vetting. Don't forget that the Chief Justice is the administrative head of the judiciary. Yes. Across the nation, courts are supposed to be sitting. Some of the judges sitting there, I've seen my own lecturer in advocacy, Justice Akabuafo. He has a lecture that he has to be at 2 p.m. at the Ghana School of Law. He's sitting there supporting his boss. There are other judges who would have been sitting in various courts. Now, if these people have come to spend the whole morning only to watch this whole spectacle unfold without anything being said, the head of prison service, who is the wife of the nominee, is sitting there with a number of her lieutenants. All of these people have come to waste how many hours? 2 hours, 3 hours, listening to a back and forth. The vetting for which reason they have come has not happened. I find that very disappointing. And I think that the chairman of this committee has to start, using some I don't know whether to use, he should crack the whip and ensure things move smoothly. Because clearly what these people are doing, the MPs on both sides, is to obstruct the process and delay the process. And he should see that and be able to quickly, deal with it. I'm not sure if Speaker Bagbin was the one who was sitting there today. These things, this back and forth will be happening. Or if it was Dua Jaho who was sitting there at the time when he was chairing the appointments committee, I'm not sure these things would be happening. Or even Freddie Blay, or not Freddie Blay. I'm trying to remember the
Joe
Osewusu was the one sitting. I'm not sure that these things would be happening. And I think that the leadership of Ahiafo has been questioned once more, and he has to come back and show that he has the appropriate kahunas to deal with matters like this. Sami, give us the NPP statement.
And just a quick comment. And when they come back, it's not going to change, because it looks as if the leaders are bullying the chairman. And this whole thing,
which should not be the case.
Which should not be the case. As the chairman, you must stamp your authority. Yeah. You are the chairman of the appointment committee. Yeah. And all these ranking and leadership people all come under you. And even at that, Sanda, you are the first deputy speaker. Yeah. Yeah. And so you should hold some, authority and command. You are a speaker, actually. So, aside being a chairman of the committee, you are a speaker. And I feel that he should stamp his authority. But let's be fair. There are too many things. Let's be fair. And I feel, Fred, I feel the two leaders, maybe for want of a better, do not regard the committee chairman in the setting. Because in several instances, you've seen the chairman trying to stamp his authority, and yet the two leaders more or less try to disobey him in doing so. And you don't expect these things to happen.
That happens on the floor of Parliament. That happens I don't think it is. Floor of Parliament. I'm saying that let's be fair to the chairman of the committee. And you realize that in all his decisions, he makes reference to the rules.
To the rules.
And if the rules allow that people would interject and raise concerns, he needs to be fair to them to interject and raise whatever concerns they have to raise. The issue is, when these things keep on dragging, now the question is, are you going to continue with a preliminary comment which is causing problems, or you are just going to move on? Yes, the minority leader has the right to make that preliminary comment, but if it's becoming an issue, then it should just end and let the vetting go on. But in terms of he stamping his authority, I think he should stamp it more, but then he's following the rules, and we should allow him to follow the rules.
Anyway, so if you're just tuning into Channel One Television 97.3 CTFM, the Appointments Committee of Parliament was scheduled to vet the Chief Justice nominee, Justice Baffoe-Bonnie. It was advertised to start at 11. The committee sat, the nominee appeared before them, but he has not been asked a simple question. After he was sworn in, the preliminary statement that was supposed to be made by the minority leader has been the subject of debate and controversy, and now the committee has had to adjourn. The chairman said they are going on a cocoa break. We don't know when they are going to return. But while all of that was happening, the New Patriotic Party issued a statement. Sami, share with us what the NPP said.
So it's a 3-page statement. I'll just read a few portions of the statement, especially the area of conflicts of interest. They accuse the current CJ, who is before the Appointment Committee, of conflict of interest. And the statement said the specific circumstances surrounding the nominee, Justice Baffoe-Bonnie, Elizabeth, are concerned. Public records indicate that the nominee presided over proceedings in the Asafo Attorney General, a case central to determine the status of the Chief Justice office and, by extension, his own elevation to the position of acting Chief Justice. Furthermore, he was part of the majority on the Supreme Court bench that voted to allow fundamentally flawed removal process to continue. The statement further says this situation engages the timeless principle that this individual is not fit to hold the office. The appearance of a conflict of interest and undermines public confidence in the judiciary and his stewardship. His subsequent acceptance of the nomination to the office, whilst the legality of the very vacancy he will fill is contested in multiple courts, demonstrate the troubling disregard for the rule of law and the principles that the courts, not political actors, must resolve judicially. So it is basically the... So
they have not said that they want their members to boycott the sitting?
No, it's not in there.
And that's why the members are still sitting there.
Yeah.
And I don't know. Let's since the Committee on Appointments has taken a cocoa break, we are going to take a fufu break, and we will be back when they return to continue bringing you proceedings from the House of Parliament. This is Channel One Television. This is 97.3 CTFM. I'm Omar Rusan Damado in studio with Fred Tete Jabano and Sami Biafi.
Welcome to the Africa Prosperity Dialogues, where business and political leaders meet to drive Africa's single market.
Distinguished guests, this is our moment to make history. We must act not in isolation, but together as united Africa.
Under the patronage of His Excellency John Mahama, President of the Republic of Ghana, and in partnership with the Africa Continental Free Trade Area Secretariat, the Africa Prosperity Network presents the Africa Prosperity Dialogues 2026 under the theme Empowering SMEs, Women and Youth in Africa's Single Market. Innovate, collaborate, trade.
Ghana is proud to be the home of this important dialogue series, and it will continue to enjoy my utmost support to make subsequent summits even greater.
Register now at africaprosperitynetwork.com or call or WhatsApp at +233 536 098 325.
Musika upenti Ghana and say satete. I'm saying, queer Dutch. And I've one sorry, I'm walking what thing. Oh, when I open to stop what I'm saying now. Say what I'm let's stop what I'm saying now. Stop what I'm saying now. Say what I'm girl, I'm saying about somebody. Yeah, losing our motherland, Ghana. Yes, you know, say, I haven't seen it. Oh, sick and Ghana, say, can come home into a woody pharmacy. Hey. I want to for very hour come now I say can I get it Galam says busy obi it I say can I say so Galam say now say what I got now let's stop Galam say now stop Galam say
the removal of Her Ladyship Justice Araba Isaba Tokonu was unfair, it lacked due process, it did not adhere to any constitutional procedure.
Chairman,
we continue.
I hope, Chairman,
to say,
that persistently violating the rules of this house is a breach of privilege. You know that. Persistently violating the rules of this house.
Chairman, he's made a point. Let me make a point with respect to you.
Honorable
Chairman,
if you can hear me out,
yes,
maybe the point that you want to make, you may realize that it is not necessary. Honorable members, let's have it in mind that we are not sitting here as a committee over any decision made by another committee or a court of competent jurisdiction. So bringing same or making same as a subject matter of discussion, with all due respect, this is not fair to members of those committees and those who presided over those cases. So if we are playing by the fair principles, please, let's refrain from all those things and be guided by our rules in raising our issues. Minority Leader, you just spoke about fairness. So is it fair that a committee that is not before us, their rulings are brought here and described in a manner unwarranted by our rules? So with all due respect, this will clearly be in breach of natural justice. We don't have the opportunity of the people being heard. So why are we commenting on them? So please, let's proceed. You can give your remarks, but be guided as such. Yes.
Thank you, Mr. Chair. Permit me to enter this discussion. I think that, Mr. Chair, you have to look at this, the context within which the minority leader is making this speech. You have to recognize that there is a background to the nomination of the nominee. And it will look very odd that we can have this conversation, the vetting of the nominee, without reference. It appears that there is a gag order. Mr. Speaker, the minority will have its say, but the majority would have its way. So, Mr. Speaker, what is wrong? We've spent almost 1 hour going back and forth on this simple matter. And I think that it is important that the minority leader is given his opportunity to speak. Then the majority leader can set the record straight if he thinks that he has said something that is so. I think that we should allow the discussion to flow. Mr. Speaker, it's been 1 hour.
Order.
We are still going back and forth.
Honorable Tampuli.
Let's with respect.
Honorable
Mr.
Tampuli.
Chairman, thank you very much.
In this house, we play by the rules. Now, tell me, at vetting, in raising a preliminary issue, and preliminary issues are not questions for the nominee to provide an answer, then you bring the work of another committee entirely to vetting, describing it in all sorts of ways. Should this be permitted or it should not be permitted? So if we are all operating within the ambit of the rules, we will not have any problem. That is where the problem is coming from. The whole world is watching us. So I believe you agree with me that it is not proper, by way of preliminary issue, a work done by a committee should be brought at a vetting and be raised as a preliminary comment.
Mr. Speaker, with respect, I'm not sure the leader is re-litigating any issue. What the leader is doing, with respect, as far as I'm concerned, is that he is making commentary. That is his view, his judgment. And it is the view of the minority. And I think that it should be allowed to land. Then the majority leader can speak. Mr. Speaker, I think that, look, if we are going to be too, more or less fastidious about what he's saying, we can't make progress. With respect, Mr. Speaker. Thank you, Mr.
Honorable Tampuli, if you want to make progress, I think we can make progress. But if you deliberately don't want to make progress, we are deliberately trying not to make progress. Honorable Tampuli, guide me by the rules that govern the House. The actual rules that allow that in making your preliminary comment, you should be allowed to describe a work of a committee in a language in which the minority leader is describing them.
Mr. Speaker, in this standing orders, Mr. Speaker, may I refer you to Order 5?
Yes.
Order 5 with respect, Mr. Speaker. Order 5.1, subject to the provisions of this Constitution and any other enactments. Where there is doubt, these rules shall be interpreted by Mr. Speaker. 2, in any case not provided for in these orders, Mr. Speaker shall decide on a procedural question. And finally, 3, in exercising the power conferred under this order, Mr. Speaker shall act in accordance with the Constitution. So we think that what you are doing,
yes,
it may not be provided for expressly.
No, but
so
what you are saying,
what you are doing amounts to being guided by Order 5.
Rules. Yes.
You understand?
Yes.
So, Mr. Speaker, even under the Constitution, and
so you agree with me that I'm operating within the ambit of the rules?
With respect, Mr. Speaker, under Article 297, the Constitution even contemplates an instance where something will not be provided in the Constitution or any other law, and they say the Parliament. So, Mr. Speaker, there are penumbra areas, there are gray areas where you fill in, and I think that you have to exercise your discretion to allow the minority leader to land, because what he's saying doesn't amount to raising issues. Mr. Speaker, he's not here with a substantive motion to raise questions about whatever it is.
Honorable Tampoli.
We are dealing with
Honorable Tampoli, I thank you very much for reading Order 5. I think Order 5 is clear as to why I am behaving the way I am behaving. But I can assure you that most of the things that the minority leader has said that I rule again, they are specifically and expressly provided for in the rules. In the rules. So minority leader can go ahead and make all his comments without touching on anybody who is not before us. He knows. Yes.
Thank you. Thank you, Mr. Chairman. Chairman, I want to draw your attention to Order 24B and D. Mr. Speaker, with your permission, I read Order 24B, that the Speaker shall promote concessions on matters under consideration in the House, and D, protect and preserve the rights of members. Mr. Speaker, I'm drawing your attention to this because the minority leader under Standing Order 24B, D, have a right, and which you have given him the permission to make his opening remarks. So I'm appealing to you to protect and preserve that right as it is in our standing order. And also, Mr. Chairman, the Order 24B, that you should promote concessions on matters. If majority leader think otherwise, minority leader think otherwise. Majority leader, after majority leader's statement, can also make statements if there are things, and you correct some of the things that he thinks is wrong. Then we can make progress, Mr. Speaker. Thank you.
Honorable Minority Deputy Whip, it is not only the right of the minority leader that is supposed to be protected. The right of everybody is supposed to be protected. The right of those committee members are also supposed to be protected. So don't take it that I am violating the right of the minority leader in any manner whatsoever. That will be a very wrong impression. And let me state that anybody who wants to enjoy his rights should know that the beginning of your right would mark the end of somebody's right. Thank you.
Chairman, and keep to the rules because I will object to anything that violates the rules.
But when we do this, it's not okay. Mr. Chairman,
minority leader, don't be preemptive. Majority leader, don't be preemptive. So go ahead.
Chairman, 7 separate proceedings across 3 jurisdictions, our own Supreme Court, the High Court, and the ECOWAS Court of Justice, now challenge the constitutional validity of that removal. Not one has been heard on its merits.
Mr. Chairman.
Yet, while these cases remain pending,
Mr. Chairman,
while the very question of whether a vacancy exists remains subject,
I object.
There is a nomination to replace.
I object.
Can have the floor. Honorable Minority Leader, hold it. Majority Leader, You said you object. What are you objecting to?
Mr. Speaker.
Order.
Our rules are very clear on pending matters. Our rules are very clear on pending matters. And it says in Order 103F that a motion shall relate to definite issues and not be the subject of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interest of the parties to the action. Mr. Speaker, you see, when you keep saying motion, these rules guide proceedings in chamber, and mutatis mutandi, they apply to the work of committees as well. The rules are clear. What you can't do in the chamber, you cannot do in committee. So the rules are clear on pending matters. So you can't come here and comment on pending matters in a way that will prejudice the interests of the parties. So we stay away from running commentary on pending matters. We even don't refer to them. It's clear. And I'm saying that you are a senior lawyer, you know. You've been in this house, you've been a majority leader, you've been a minority leader, you have lived through all the rulings in these matters. Pending matters, we should stay away from them. The conduct of judges, we should stay away from them. You have so far not impugned the process of nominating the nominee and submitting the nomination to this house, and the process of referral by Speaker of the nominee to this committee for the committee to do its work. Those are the legitimate matters that you can raise, and you haven't raised them. So all the questions about what happened, if you had waited and we started proceedings and you throw a question to the nominee to get his views on the matter, I may not object. But you can't just be allowed to run down everybody and get up and walk because you are a friend of Martin. Why? It will not be allowed. I am going to look, this whole issue about you making a preliminary statement, show me a rule that says that you have a right to make a preliminary statement. Show me in our standing orders anything that says that you, Afanyo Martin, have a right to make preliminary statements. You don't. Listen, we developed it as a practice. We developed it as a practice where normally the two leaders may make welcoming statements and general open statements, but you have converted it into a platform to do a press conference where you attack and impugn people and walk away with it. I'm saying that today you will not attack anybody and walk away whilst I sit in this committee.
Yes, Minority Leader, what do you have to say to it?
I haven't. At least if I catch you.
If it gives you the opportunity, because he is on the floor. Tell him, when he said I should hear Tampuli, I heard Tampuli. Should I hear another play? Should I hear another play?
Yeah. You can hear him after that. I come and respond to him. I know if you have anything.
Yes, Honorable Anodonpre, what do you have to say on the issue raised by the majority
Speaker,
leader, Honorable Mahama Yarga?
Well, initially I didn't want to comment. We thought we should. Speaker, we in leadership have a role to play in helping you shepherd and guide this process. How does it look that the Chief Justice nominee is before us and this whole process is being reduced into a banter between the majority leader? It's been reduced into this. It's most unfortunate. And I'm surprised.
It's pending at the ECOWAS court, at the Supreme Court, at the High Court, amount to prejudicing the outcome. Really. But we have a nominee before us. The nominee with the power to empanel. In fact, the empaneling of the court for the determination of injunction application was done swiftly. As we speak, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it. Recently, we heard the Attorney General even applying to the court for leave for extension of time to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it rather even applies to the case of the minority that this matter should be placed on ice, because the nominee is likely to be conflicted, especially when he is the one to empanel. Two, that the substantive matters have not been dealt with.
Minority
let
leader.
me finish.
With all
Chairman,
due respect.
You allowed
the
the minority leader. I'm
I'm
responding
not
to his
asking
objection.
the minority leader to raise an issue. Order.
I am responding
Order.
to I'm responding.
Honorable
Let me
minority
respond.
leader.
Let me respond.
Honorable minority
Let me
leader, hold
respond to
it.
him.
Honorable minority leader, hold it. May your microphone be off, minority leader.
Chairman, just a second. Bear with
Minority
me.
leader,
Chairman.
let your microphone be off. Hear
Chairman.
me out.
Very well. I will hear you.
Yes,
and
I'm
then
supposed
continue my
to
argument.
play the fair game here.
If you make your point, we respond.
Honorable minority leader,
What is wrong?
please, just
I don't have to
observe
respond.
me.
The Fiamma Post spoke.
Hear
for
what I will want
20
to say. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly empaneled, acted in conflict. I mean, all those things have not
You've said
been-
that. You've said that. You've said that.
Why?
You've said that. You said that. You said that the nominee swiftly empaneled a court.
So, honorable members, on this note, I would want him to conclude. I will rule on the matter, then we take a short break and come back and continue with the vetting.
Chairman, with respect, it is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority's concerns to be heard. Here is he suggesting that nothing should be raised that is likely to affect the outcome of a pending suit. That is what he says. He says that my reference to matters that are pending before courts amount to a situation where I will be offending Rule 103F. If that is the case, then the matter before us is rather more fitting than the argument he's making against me. Because, with respect, we have pending suits for over 6 months.
Chairman.
No. I have the floor. You've not called.
Chairman, the rules.
You have not called him. Chairman, you see, Chairman, he puts on the rules.
The rules are clear.
No, it's not.
The rules are clear. The rules are clear. Chairman, the rules. Though when you just comes in. But you just put on your microphone and speak. Leader, you just put on your microphone and speak. That's all right.
Honorable members, I have stated clearly, the whole world is watching us. You will not have the floor until I ask you to do so. I will consider a situation where you put on the microphone without the speaker asking you to say something as disorderly, and I will invoke the rules appropriately. So we should all take note. Minority leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the majority leader is invoking supports the contention of the minority. And I'm responding to him by saying that the cases that are pending, that he has a problem with my earlier statement, if we consider this motion, you shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the floor.
Honorable Minority Leader, hold it there.
For him to come in?
Yes, hold it. Okay, not for him to come in. I am coming in personally. Severally, I admonish you that a matter that has been dealt with on the floor of Parliament, this vetting committee cannot be constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any of those issues to be read. Now, I accommodated the majority whip, and he read in extenso your motion. So anything that relates to your motion would not be entertained before this particular committee. Because for me, that matter, procedurally and legally, is mute. It cannot be raised. So, Minority Leader, kindly conclude.
Chairman, there are two issues that have been raised, and each of them must have a response. The majority leader has raised his issue. And then the Fiamakpo also brings in a different issue. So I'm done with him. Let me now address the Fiamakpo's issue, the majority chief whip. The majority chief whip is contending that the minority's motion was ruled upon. Mr. Speaker, Mr. Chairman, we are not here to rehash our argument. We have not brought any argument before the House. We filed an administrative motion, which motion was declared inadmissible. It's as simple as that.
You have to catch his attention.
Now, it does not stop us from stating our views on an important national matter. It doesn't stop us. We are not challenging the Speaker's ruling at this committee. We know what to do. The minority, even when we disagree with the First Deputy Speaker, filed a review application which was admitted, and we started a debate. We are not in any way against any ruling and against any rules. We will use the rules to express our views. So the majority chief whip is completely wrong to introduce that matter. What we are rather saying is that the rule that the majority leader is seeking to invoke to rather stop the minority from exercising its right of opinion on a matter of national importance rather supports the very reason why we had come with a motion to say that let all the matters be determined to bring clarity, because Her Ladyship Justice Arabe Esaba Tokonu has rights, far rights. And what becomes of her when eventually the court determines that all her reliefs are upheld, and then what becomes of us?
Yes.
What
Honorable Majority Leader. Honorable Majority Leader.
You are hearing him?
No, I am the one speaking.
What do you want?
You understand?
Yes.
Please, let's take a cue. Severally, I admonished that everybody, that anything that has to do with a matter raised on the floor and a ruling delivered by the speakers, including me, would not be entertained. So that one, strictly, any attempt to go into that particular area, I would ask you to stop your submission and maybe go to another area. And probably we may have to take a decision if persistently you've decided not to listen to the chairperson of the committee. So I am pleading with you. You see, with Jerry Ahmed, you catch the eye of the speaker at the right time. You don't expect me to interrupt the minority leader to give you the floor to speak. It is not done in any parliament. So minority leader, if you are done and you want me to make a ruling, I will make a ruling. Then we take a break.
Chairman, with respect, the minority on this committee is ready to assist you through this process. It is clear to us, however, that consistently there is a grand design to obstruct us, deny us of our right to express opinion on a matter of national discourse. We are clear on our minds what the majority is up to. And Chairman, although we know, and it's a fact, that all of you are of the same stock, we, however, think that we should be heard. All these objections that they are raising here and there has one aim, that the minority must not be heard for posterity. They know that if these views get into Hansard, it will come back and haunt them someday. All that is all that they are doing. Chairman, it's not a matter for ruling. I hold a view on behalf of my colleagues that you should restrain the majority leader, because it is one too many, very consistently, the statement that I made as part of my remarks that he is invoking Order 103F is neither here nor there. I didn't make any prejudicial comment. I didn't say anything that offends Order 103F. It is very clear what he is up to. Let us be very fair. Let us allow democracy to be at play. They are in the majority, no doubt. They are in majority, no doubt. But they should allow us. I'm responding to, you see, Chairman, Chairman, what the majority leader is doing, is not fair. He raises his issues. You don't have to respond. When you are responding, he now determines how you should respond to him. The chief whip has spoken. You have spoken. When you are talking, you don't calculate the hours.
Honorable members, order.
When you are talking,
order.
When you are talking, you don't talk about the
on this note, we will break for cocoa. So it's time for cocoa break.
Isaba Tokonu was cloaked in some spending at the ECOWAS court, at the Supreme Court, at the High Court, amount to prejudicing the outcome. Really. But we have a nominee before us. The nominee with the power to empanel. In fact, the empaneling of the court for the determination of injunction application was done swiftly. As we speak, per his own words, the court has not empaneled the Supreme Court to determine the substantive matters before it. Recently, we heard the Attorney General even applying to the court for leave for extension of time to file a defense. We have a nominee before us with the power to empanel. He has not empaneled. If we are now interpreting 103F properly, then it rather even applies to the case of the minority that this matter should be placed on ice, because the nominee is likely to be conflicted, especially when he is the one to empanel. Two, that the substantive matters have not been dealt.
Honorable Minority
Let
Leader.
me finish.
With all
Chairman,
due respect.
You allowed
Hold
the Minority Leader. I'm responding
I'm
to
not asking the Minority Leader to raise an issue. Order.
I am responding.
Order.
I'm responding.
Honorable Minority Leader.
Let me respond.
Honorable Minority Leader, hold it. Honorable Minority Leader, hold it. May your microphone be off, Minority Leader.
Chairman, just a second.
Minority Leader, let your microphone be off. Hear me out.
Very well. I will hear you.
I'm supposed to play the fair game here.
If you make your point, we respond.
Honorable Minority Leader.
What is wrong?
Please, just observe me.
The former post spoke.
Hear what I will want to say. Honorable members, can there be an order? Order. I don't want to hear anybody's voice again. Honorable members, when an objection is raised, I listen to the objection. So I expect you to respond to the objection that is raised. I don't think in all the objections raised, there is anything in the objection that suggests that the nominee before us swiftly empaneled, acted in conflict. I mean, all those things have not
said that. You've said that. You've said that. You've said that. You said that. You said that the nominee swiftly empaneled the court.
So, honorable members, on this note, I would want him to conclude. I will rule on the matter, then we take a short break and come back and continue with the vetting.
Chairman, with respect.
It is my view. It is my view that if the order 103F that the majority leader made reference to at all is applicable, then it is the more reason for the minority's concerns to be heard. Here is he suggesting that nothing should be raised that is likely to affect the outcome of a pending suit. That is what he says. He says that my reference to matters that are pending before court amount to a situation where I will be offending Rule 103F. If that is the case, then the matter before us is rather more fitting than the argument he's making against me. Because, with respect, we have pending suits for over 6 months.
Chairman, no. Chairman, I have the floor. You've not called. Chairman, the rules. You have not called. The rules. Chairman, the rules. Chairman, he puts on the rest. The rules are clear. No, it's not. The rules are clear. The rules are clear. Chairman, the rules. No, when you just comes in. But you just put on your microphone and speak. Leader, you just put on your microphone and speak. That's all right.
Honorable members, I have stated clearly, the whole world is watching us. You will not have the floor until I ask you to do so. I will consider a situation where you put on the microphone without the speaker asking you to say something as disorderly, and I will invoke the rules appropriately. So we should all take note. Minority Leader, kindly conclude.
So, Chairman, what I am saying in short is that the very rule that the Majority Leader is invoking supports the contention of the minority. And I'm responding to him by saying that the cases that are pending, that he has a problem with my earlier statement. If we consider this motion, you shouldn't forget that what Parliament is doing, the vetting of the nominee, eventually will lead to the report being moved on the floor.
Honorable Minority Leader, hold it there.
For him to come in?
Yes, hold it. Okay, not for him to come in. I am coming in personally. Severally, I admonish you that a matter that has been dealt with on the floor of Parliament, this vetting committee cannot be constituted into a court of appeal to reverse any decision. Therefore, I will personally not tolerate any of those issues to be read. Now, I accommodated the majority whip, and he read in extenso your motion. So anything that relates to your motion would not be entertained before this particular committee, because for me, that matter, procedurally and legally, is mute. It cannot be raised. So, Minority Leader, kindly conclude.
Chairman, there are two issues that have been raised, and each of them must have a response. The Majority Leader has raised this issue. And then the Fiamakpo also brings in a different issue. So I'm done with him. Let me now address the Fiamakpo's issue, the Majority Chief Whip. The Majority Chief Whip is contending that the minority's motion was ruled upon. Mr. Speaker, Mr. Chairman, we are not here to rehash our arguments. We have not brought any arguments before the House. We filed an administrative motion, which motion was declared inadmissible. It's as simple as that. Now, it does not stop us from stating our views on an important national matter. It doesn't stop us. We are not challenging the Speaker's ruling at this committee. We know what to do. The minority, even when we disagree with the First Deputy Speaker, filed a review application which was admitted, and we started a debate. We are not in any way against any ruling and against any rules. We use the rules to express our views. So the Majority Chief Whip is completely wrong to introduce that matter. What we are rather saying is that the rule that the Majority Leader is seeking to invoke to rather stop the minority from exercising its right of opinion on a matter of national importance rather supports The very reason why we had come with a motion to say that let all the matters be determined to bring clarity, because Her Ladyship Justice Arabe Esaba Tokonu has rights, far rights. And what becomes of her when eventually the court determines that all her beliefs are upheld, and then what becomes of us?
Yes.
What
Honorable Majority Leader.
You are hearing?
No, I am the one speaking.
What do you want?
You understand?
Yes.
Please, let's take a cue. Severally, I admonished that everybody, that anything that has to do with a matter raised on the floor and a ruling delivered by the speakers, including me, would not be entertained. So that one, strictly, any attempt to go into that particular area, I would ask you to stop your submission and maybe go to another area. And probably we may have to take a decision if persistently you've decided not to listen to the chairperson of the committee. So I am pleading with you. You see, with Jerry Ahmed, you catch the eye of the speaker at the right time. You don't expect me to interrupt the minority leader to give you the floor to speak. It is not done in any parliament. So minority leader, if you are done and you want me to make a ruling, I will make a ruling. Then we take a break.
Chairman, with respect, the minority on this committee is ready to assist you through this process. It is clear to us, however, that consistently there is a grand design to obstruct us, deny us of our right to express opinion on a matter of national discourse. We are clear on our minds what the majority is up to. And Chairman, although we know, and it's a fact, that all of you are of the same stock, we, however, think that we should be heard. All these objections that they are raising here and there has one aim, that the minority must not be heard for posterity. They know that if these views get into Hansard, it will come back and haunt them someday. That is all that they are doing. Chairman, it's not a matter for ruling. I hold a view on behalf of my colleagues that you should restrain the majority leader, because it is one too many, very consistently, the statement that I made as part of my remarks that he is invoking Order 103F is neither here nor there. I didn't make any prejudicial comment. I didn't say anything that offends Order 103F. It is very clear what he is up to. Let us be very fair. Let us allow democracy to be at play. They are in the majority, no doubt. They are in majority, no doubt. But they should allow us. I'm responding to, you see, Chairman, what the majority leader is doing is not fair. He raises his issues, you don't have to respond. When you are responding, he now determines how you should respond to him. The chief whip has spoken. You have spoken. When you are talking, you don't calculate the hours.
Because
Honorable members, order.
When you are talking,
Order.
When you are talking, you
Honorable
don't
members,
talk about the
on
time.
this note, we will break for cocoa. So it's time for cocoa break.
And make ruling.
This one is friendly. Opaque. It's friendly. Opaque.
Yes, Majority Leader.
Mr. And when I try to guide you how to go about your work, then you say that I'm trying to obstruct you.
Honorable Majority Leader, you've made your point. And again, if I'm called upon to do a ruling, the rules are clear that we should refrain from the use of offensive language. We are here for the purposes of vetting. A situation where the process will be used to describe the work of a committee to be opaque, meaning it was done in darkness, is offensive. Therefore, I would order that same be expunged from the record as if it doesn't exist. Honorable Minority Leader, proceed.
Chairman, with respect. Chairman, with respect. He raised the objection. You didn't give me the opportunity to respond. And you're saying that you have ruled. I mean, what is the fairness in this? He just raised the objection. He didn't refer to any rule this time. This time, he didn't refer to any rule. And then he says that we should go and do press conference.
Honorable Minority Leader, kindly proceed.
It is our contention that the process leading to the removal of Her Ladyship Justice
Araba Isaba Tokonu was unfair, it lacked due process, it did not adhere to any constitutional procedure.
Chairman,
we
I
continue.
I hope, Chairman,
to say,
I hope, Chairman, that persistently violating the rules of this House is a breach of privilege. You know that.
Persistently violating the rules of this House. Chairman,
Honorable Minority Leader.
He's made a point. Let me make a point with respect to you.
Honorable Minority Leader, if you can
point.
hear me out,
Yes,
maybe the point that you want to make, you may realize that it is not necessary. Honorable members, let's have it in mind that we are not sitting here as a committee over any decision made by another committee or a court of competent jurisdiction. So bringing same or making same as a subject matter of discussion, with all due respect, this is not fair to members of those committees and those who presided over those cases. So if we are playing by the fair principles, please let's refrain from all those things and be guided by our rules in raising our issues. Minority Leader, you just spoke about fairness. So is it fair that a committee that is not before us, their rulings are brought here and described in a manner unwarranted by our rules? So with all due respect, this will clearly be in breach of natural justice. We don't have the opportunity of the people being heard. So why are we commenting on them? So please, let's proceed. You can give your remarks, but be guided
as such. Yes.
Thank you, Mr. Chair. Permit me to enter this discussion. I think that, Mr. Chair, you have to look at this, the context within which the minority leader is making this speech. You have to recognize that there is a background to the nomination of the nominee. And it will look very odd that we can have this conversation, the vetting of the nominee, without reference. It appears that there is a gag order. Mr. Speaker, the minority will have its say, but the majority would have its way. So, Mr. Speaker, what is wrong? We've spent almost 1 hour going back and forth on this simple matter. And I think that it is important that the minority leader is given his opportunity to speak. Then the majority leader can set the record straight if he thinks that he has said something that is. So I think that we should allow the discussion to flow. Mr. Speaker, it's been 1 hour.
Order.
We are still going back and forth.
Honorable Tampuli.
Let's with respect.
Honorable
Mr.
Tampuli.
Chairman, thank you very much.
In this house, we play by the rules. Now, tell me, at vetting, in raising a preliminary issue, and preliminary issues are not questions for the nominee to provide an answer. Then you bring the work of another committee entirely to vetting, describing it in all sorts of ways. Should this be permitted or it should not be permitted? So if we are all operating within the ambit of the rules, we will not have any problem. That is where the problem is coming from. The whole world is watching us. So I believe you agree with me that it is not proper, by way of preliminary issue, a work done by a committee should be brought at a vetting and be raised as a preliminary comment.
Mr. Speaker, with respect, I'm not sure the leader is relitigating any issue. What the leader is doing, with respect, as far as I'm concerned, is that he is making commentary. That is his view, his judgment. And it is the view of the minority. And I think that it should be allowed to land. Then the majority leader can speak. Mr. Speaker, I think that, look, if we are going to be too, more or less fastidious about what he's saying, we can't make progress. With respect, Mr. Speaker. Thank you, Mr.
Honorable Tampuli, if you want to make progress, I think we can make progress. But if you deliberately don't want to make progress, we are deliberately trying not to make progress. Honorable Tampuli, guide me by the rules that govern the House. The actual rules that allow that in making your preliminary comment, you should be allowed to describe a work of a committee in a language in which the minority leader is describing them.
Mr. Speaker, in this standing orders, Mr. Speaker, may I refer you to Order 5?
Yes.
Order 5 with respect, Mr. Speaker. Order 5.1. Subject to the provisions of this Constitution and any other enactments, where there is doubt, these rules shall be interpreted by Mr. Speaker. 2. In any case not provided for in these orders, Mr. Speaker shall decide on a procedural question. And finally, 3. In exercising the power conferred under this order, Mr. Speaker shall act in accordance with the Constitution. So we think that what you are doing, it may not be provided for express.
No, but what you are saying,
what you are doing amounts to being guided by Order 5.
Yes.
You understand?
Yes.
So, Mr. Speaker, even under the Constitution,
so you agree with me that I'm operating within the ambit of the rules?
With respect, Mr. Speaker, under Article 297, the Constitution even contemplates an instance where something will not be provided in the Constitution or any other law. And they say that, so, Mr. Speaker, there are penumbra areas, there are gray areas where you fill in. And I think that you have to exercise your discretion to allow the minority leader to land. Because what he's saying doesn't amount to raising issues. Mr. Speaker, he's not not here with a substantive motion
Honorable,
to raise questions about whatever it is.
Honorable Tampoli.
We are dealing with
Honorable
comments.
Tampoli, I thank you very much for reading Order 5. I think Order 5 is clear as to why I am behaving the way I am behaving. But I can assure you that most of the things that the minority leader has said that I rule against, they are specifically and expressly provided for in the rules. In the rules. So minority leader can go ahead and make all his comments without touching on anybody who is not before us. He knows. Yes.
Thank you. Thank you, Mr. Chairman. Chairman, I want to draw your attention to Order 24B and D. Mr. Speaker, with your permission, I read Order 24B, that the Speaker shall promote concessions on matters under consideration in the House, and D, protect and preserve the rights of members. Mr. Speaker, I'm drawing your attention to this because the minority leader under Standing Order 24D have a right, and which you have given him the permission to make his opening remarks. So I'm appealing to you to protect and preserve that right as it is in our standing order. And also, Mr. Chairman, the Order 24B, that you should promote concessions on matters. If majority leader think otherwise, minority leader think otherwise. Majority leader, after majority leader's statement, can also make statements if there are things, and correct some of the things that he thinks is wrong. Then we can make progress, Mr. Speaker. Thank you.
Honorable Minority Deputy Whip. It is not only the right of the minority leader that is supposed to be protected. The right of everybody is supposed to be protected. The right of those committee members are also supposed to be protected. So don't take it that I am violating the right of the minority leader in any manner whatsoever. That will be a very wrong impression. And let me state that anybody who wants to enjoy his rights should know that the beginning of your right would mark the end of somebody's right. Thank you.
Chairman, and keep to the rules because I will object to anything that violates the rules. Mr. Chairman,
minority leader, don't be preemptive. Majority leader, don't be preemptive. So go ahead.
Chairman, 7 separate proceedings across 3 jurisdictions, our own Supreme Court, the High Court, and the ECOWAS Court of Justice, now challenge the constitutional validity of that removal. Not one has been heard on its merits. Mr. Chairman. Yet, while these cases remain pending,
Mr. Chairman,
while the very question of whether a vacancy exists remains subject,
I object.
There is a nomination to replace.
I object.
Can have the floor. Honorable Minority Leader, hold it. Majority Leader, you said you object. What are you objecting to?
Mr. Speaker.
Order.
Our rules are very clear on pending matters. Our rules are very clear on pending matters. And it says in Order 103F that a motion shall relate to definite issues and not be the subject of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interest of the parties to the action. Mr. Speaker, you see, when you keep saying motion, these rules guide proceedings in chamber, and mutatis mutandi, they apply to the work of committees as well. The rules are clear. What you can't do in the chamber, you cannot do in committee. So the rules are clear on pending matters. So you can't come here and comment on pending matters in a way that will prejudice the interests of the parties. So we stay away from running commentary on pending matters. We even don't refer to them. It's clear. And I'm saying that you are a senior lawyer, you know. You've been in this house, you've been a majority leader, you've been a minority leader, you have lived through all the rulings in these matters. Pending matters, we should stay away from them. The conduct of judges, we should stay away from them. You have so far not impugned the process of nominating the nominee and submitting the nomination to this house, and the process of referral by Speaker of the nominee to this committee for the committee to do its work. Those are the legitimate matters that you can raise, and you haven't raised them. So all the questions about what happened, if you had waited and we started proceedings and you throw a question to the nominee to get his views on the matter, I may not object. But you can't just be allowed to run down everybody and get up and walk because you are a friend of Martin. Why? It will not be allowed. I am going to look, this whole issue about you making a preliminary statement, show me a rule that says that you have a right to make a preliminary statement. Show me in our standing orders anything that says that you, a friend of Martin, have a right to make preliminary statements. You don't. Listen, we developed it as a practice. We developed it as a practice where normally the two leaders may make welcoming statements and general open statements, but you have converted it into a platform to do a press conference where you attack and impugn people and walk away with it. I'm saying that today you will not attack anybody and walk away whilst I sit in this committee.
Yes, Minority Leader, what do you have to say to it? It gives him the opportunity because he is on the floor. Tell him, when he said I should hear Tampuli, I heard Tampuli. Should I hear another play? Should I hear another play?
Yeah. You can hear him after that. I come and respond to him. I know if you have anything.
Yes, Honorable Anodonpre, what do you have to say on the issue raised by the majority Speaker, leader, Honorable Mahama?
Chairman, it is our view as a minority caucus that whilst there are pending cases by her ladyship, Justice Arabella Sakato, we as Parliament must not be seen to be acting sub judice of the very issues she is raising in court. We are believing that proceeding with leading to the eventual confirmation see that as there is therefore no institutional crisis. There is therefore no vacuum requiring urgent action. My Lord, Justice Baffoe-Bonnie could continue serving in acting capacity until the courts have provided clarity on whether Her Ladyship Justice
Araba Esabatokonu was lawfully removed. In our view,
all that is happening does not amount to some objectivity at play. We rather see a fait accompli. Chairman, it is also our view that for the sake of our country's democracy and rule of law, the grant of 3 weeks extension for the learned Attorney General for leave for extension of time was rather unacceptable after the long delay in filing an opposition.
Chairman, please. Chairman, this has to be withdrawn. This has to be withdrawn.
Chairman,
please, we heard what he said. You can't sit here and malign a decision of a court. It's not acceptable. It's not acceptable. Please, don't let us keep doing this, and then send the impression out there we are bad people, we are a minority trying to prevent you from. The rules are clear. You've been told the rules severally. Please.
Only punching the microphone and speaking. You are our leader, but you are a member of parliament. You are subject to the same rules as apply to all of us. So, Mr. Chair, I think you should have a word with our leader.
Thank you very much.
Your consent
Honorable Minority Leader, be guided and candidly land safely.
Chairman, please.
Yes, Honorable Ayarga.
Chairman, I raise an objection to his reference to a judicial decision and the conduct of a judge. And the rules are very clear. I really don't understand why the minority leader wants me to keep reciting the rules, because everybody knows that the rules are clear. You can't say that about a decision of a court. You can't say that. So he has to expunge that.
Honorable Majority Leader, I have heard you. Honorable Minority Leader, be guided accordingly and proceed.
Chairman, with respect, what we are saying is that we disagree with the said decision of the court, and it's our right to have a disagreement with the court, most respectfully. Especially so when we are of the view.
You see, Honorable Minority Leader,
Chairman,
you can disagree with all due respect with the decision of the court. And when you disagree with the decision of the court, you know how to do.
That's not a problem. But we are making a comment, Chairman. Chairman, I've held my calm throughout all of this. I gave you my word, proud to this verdict, and I've kept my word. Today in Ghana, you cannot even speak as a parliamentarian to express a view. You will be stopped by the majority leader. I am not attacking the court. I'm saying that the minority disagrees because we have the rules book, the CI 16. When you apply for extension of time, there's a time period. You can't go beyond 2 weeks. We have the provision, so we cannot disagree with the court. We cannot cite the court's own rulings and say, on this we disagree. What is happening here? Because somebody has supermajority? What is happening in this country?
Honorable Minority Leader, I will not have a problem. I will not have a problem.
I have not attacked any judge. We've not attacked the court.
This is by way of a question that will give an opportunity for a response. You are making a preliminary comment.
Exactly, that's exactly what.
So
that's
let's
exactly what
stick
is
to
being
the
done.
rules.
I don't
and
have
then
a
you
problem.
make your preliminary comment
Right.
as such.
Very well, Chairman. Thank you. So we expect that steps be taken by the court to expeditiously hear the cases brought before it by the respected, learned Justice of the Supreme Court, who until removed was the Chief Justice, Her Ladyship Gertrude Araba Isaba Tokono. Expeditious hearing of this matter and a final determination of this matter will reassure the Ghanaian public that the rule of law works, that we respect the Constitution. Chairman, we submit further that all the delays in the filing of defense in the matter is a strategy to ensure that these cases languish undefended, creating space for this rash confirmation to proceed unchallenged.
Chairman.
Why? To be off. Yes, Honorable Ayarga, let me hear you.
Why? No,
Chairman.
now you can
Chairman. I know now and then the minority leader will say that we are politicians and we should be allowed to do politics. Yes, we are politicians and we should be allowed to do politics. But when we sit here, our politics should be guided by rules. The rules are very clear, Chairman. The rules say that where in the opinion of the Speaker, the words of a member used in a speech are offensive, abusive, insulting, blasphemous, or unbecoming, impute improper motives. Impute improper motives. I repeat again, impute improper motives or impugns the integrity of a member or any other person, the Speaker may order that the member withdraws those words or withdraw and apologize. The Attorney General is a constitutional office created in our Constitution. And he is a member of this House. In the discharge of his functions, you have no right to come and sit here and impute improper motives. Our rules are clear. What you are saying, you are imputing improper motives. Saying that all of it is a charade and then a strategy and etc. to subvert justice. No. Mr. Speaker, how can he say that? I object and I insist that that part of his statement should be expunged. And the rules are very clear. That any reference to the conduct of persons mentioned in Rule 7 in any amendment, question, or remarks in a motion or on a debate dealing with any other subject is out of order. And then you, the Speaker, or the 123 Rule 3 says that if you make a determination that indeed he has impugned improper motives, you should order him to have it expunged from the records. And I'm saying that he has impugned, he has imputed improper motives, and therefore he should expunge that from the records.
Yes, Honorable Minority Leader.
Mr. Chair.
Honorable Minority Leader.
I'm a member.
Please put off your microphone. Please put off your microphone. Yes, Honorable Minority Leader. You have the floor.
Seal that to me. But seal that to me.
Mr. Chairman, some of my... Yes, sure. I'm saying that my colleague has a point to make. Since a point of order has been raised, I think that it was within every member's right to respond, not limited to only me.
Well, Minority Leader, with all due respect, we are a house governed by rules.
Sure, but...
I can be guided by the rules that enable the Speaker or the person presiding to take a point of order against a point of order or a response to a point of order from any other person apart from the person who raised the issue. So the rules are applied. That is why I asked the honorable member to put his microphone off, and then I'm giving you the floor to respond to the issue of the point of order raised. On the response to the point of order being raised. Yes, Honorable Animedu, let me hear you.
Yeah, Mr. Chairman, I have been quiet since morning, and I think that we must be serious as a committee. Mr. Speaker, I should think that some members of this committee have a preconceived mind, either to object to every word, every letter that is said, and we cannot continue like that. You being the chairman, Mr. Chairman, I pray after the break, Mr. Chair, you have to steer the affairs of this committee. Now, the majority leader, please, I have the floor. The majority leader is not about, but if you are quoting the standing orders, that people are imputing improper motives, you must go to the extent of proving to us that this word is an improper motive. You just don't say it. Now, even the law that you have cited, it's on motions. What motion are we dealing with here? Now, every committee ever since...
This November, something amazing is coming to Accra. Are you ever...
We made it 1, 2, 3, and now 4. Ladies and gentlemen, get ready for a night of rhythm, culture, and pure Ghanaian energy. Inchin Band is back! And this time, it's bigger.
Parts of us. And if every word is going to be objected to, then I don't think that we are ready for the vetting. Now we have been here all day. The nominee had not even spoken a word. This objection, that objection, and
Honorable
and yet we are getting nowhere.
You raised a point, but I feel you are out of order. It's not in response to the issue on the floor. So, Honorable Minority Leader.
It's not in response? Wow.
Chairman, thank you. Oh, very well. Chairman, nowhere in my submission did I impugn improper motives. Or was there an inference to such an act? Chairman, you must let the majority leader know that he is a majority leader. When you raise your objections and everybody is quiet, and you are so intolerant that you want to find a way to create chaos, I won't give you that.
Leader,
no, Chair, he was just talking.
The chair.
No, but you are closer to him, Chairman. We've all kept our calm. He is showing power, force. I am this, I am that. It's not fair. What he's doing is not fair. It's not fair.
Chairman, what the rank is doing is not right. You were given 5 minutes. We spent 15 minutes.
You have the floor. Honorable Dapamako, you don't have the floor. Honorable Roxanne Nelson Dapamako, you do not have the floor. You don't have the floor. Please, Minority Leader.
So, Mr. Chair, we've been very calm, quiet, decent. We want to discharge our parliamentary duties, yet the attacks are becoming one too many. Now, let me respond to him. I stated the fact that cases were filed as far back as May. It was only recently that the AG filed a motion for extension of time to file a defense and sought the leave of the court for that. It is a matter in the public domain that long after the time required to file a defense in that important constitutional matter had lapsed, the AG had not filed, the court itself had not issued a hearing notice to compel the AG to come to court until the AG requested, applied to the court for leave to file out of time. It is a statement of fact that we, as the minority, are raising as part of our concerns regarding the constitutional overreach. We are not saying anything less apart from what is in the public domain. So, Mr. Chairman, the majority leader must be restrained. All the confusion is being caused by him. All the confusion, I have my speech before me. I can read it again. You see?
Honorable
Chairman.
Leader.
Chairman.
With all due respect, can you conclude? If I will have to rule on the objection raised, this is what I will say. We have a constitutional mandate to vet the Chief Justice nominee. The issue before the courts, whether a defense has been filed, leave has been sought, defense has not been filed, is a matter entirely in the domain of the courts. And this cannot be a subject matter of discussion at the vetting committee. Consequently, everything said about defense or relating to that is ordered to be expunged from the record. Minority Leader, please proceed.
Chairman with respect. Chairman with respect. Chairman with respect. You are not doing justice. And I say so because everything that is happening here appears to have been well rehearsed by the majority leader with a view.
You see, Honorable Leader,
Chairman,
you have been a majority leader before.
Chairman.
Becoming a minority leader, there is nothing that is well reserved.
Chairman, this approach where they will come, force you, speak, put on a mic, then you say it is expunged. What exactly, what particular word are we expunging?
I think you heard my ruling very loud and clear. If you disagree with it, you know what to do. Will you proceed?
Don't worry. We are all aware of what this whole thing is leading to. So no problem. Chairman, we the minority hold a view that Article 1271 gives the Chief Justice authority to ensure effective administration of justice. Article 1272 requires all state organs to assist the courts. Yet, in the instant situation, there are no visible steps to compel speedy trial. We have not yet heard of any hearing for all cases challenging the legitimacy of the process leading to the removal of Her Ladyship Justice Araba Isaba Tokono. We believe that the acting Chief Justice wields the administrative power on this matter And just as the injunction applications were held expeditiously, same could have applied in this instance. Chairman, it is regrettable that our motion that was intended to have dealt upon this matter did not see the light of day. We hold a view that the judiciary is not the executive's enforcement arm. It is neither Parliament's ally in political projects. It is a guardian of our Constitution, the protector of our rights, the final arbiter of all our laws. Its independence is sacrosanct. Its integrity is non-negotiable. It is the oracle of justice emanating from the people of Ghana. Chairman, for all the reasons given, including the very actions of the majority leader, basically denying us every opportunity of expressing our opinion on an important national discourse. Be it known to you, Chairman, and the committee, and the country, that we, the minority caucus, hereby vote en bloc to reject the nominee. We would want to state on record that the majority can proceed with the questions. We do not intend to proceed with any question. We are, however, registering in the strongest terms that we reject the nomination, and the records should reflect that the report of this committee be a majority report.
Woman, comport yourself.
Honorable colleague, when we show you respect, reciprocate. So far, we have extended to you every courtesy. We've heard all those unpalatable words. We've heard the abuse. So please, for posterity's sake, listen to us. We don't need to vet a nominee before we vote against the nominee. We have preliminary issues well grounded in law. You may disagree with us. And we say that on the basis of that, we cannot be part of a process that would give right to another and deny another of her bona fide as enshrined in the Constitution. Chairman, that said, we would yield to you to proceed whilst we exit this committee room with our views well documented for the records, and on the floor we shall proceed with the debate, further stating our position and take a vote against the nominee as required by the rules of the plenary. Thank you very much indeed.
Thank you very much, Minority Leader. But how do you reject a nominee who is yet to be vetted?
Should I respond?
The report is not ready to be voted for. We are not at a stage of approval. So your conclusion is very preemptive.
No, Chairman, let me
It's
Chairman will respect. Chairman would
this is not what I want you to respond to.
No, Chairman,
so
but
I don't want your
Chairman,
response on this.
To the extent that you've raised it, I just need to. I just need to.
Honorable
Chairman,
Minority Leader,
Chairman,
you have your day.
Chairman,
You have your day. The two microphones should be off.
Chairman,
the two microphones should be off, with all due respect.
We have registered our position.
Honorable Minority Leader,
that we have rejected. We don't need to vet
agreed on your position.
We reject it. And we
agreed on your positions, yes. When it is time for voting, then you can vote against the nominee. Yes, yes. So we thank you very much, and we wish you a very good luck. Honourable members.
Why you wish us a good luck?
Yes, sir. Yeah, okay. Yes. Honourable members, those present here, we have the constitutional quorum to proceed to vet the Chief Justice nominee and present our report accordingly to Parliament. On this note, we will proceed with the vetting questions. And my Lord Chief Justice nominee, members of the committee will then ask you questions, and you are expected to give response to those questions. Be calm and provide answers to these questions. I will start the preliminary questions with you by asking you to tell us briefly about yourself.
Thank you very much, Honorable Chair. Please, before I answer the question, may I be expected to, may I be allowed to read a brief, make a brief opening remarks?
Allowed, you be allowed to do so after you have indicated to us who you are.
My name is Paul Baffoe-Bonnie. I'm a Justice of the Supreme Court. I've been a Justice of the Supreme Court since 11th of June 2008. So 17 years plus I've been a Supreme Court judge. Before the 11th of June, for 2 years I was a Justice of the Court of Appeal. Before then I was 6 years as a High Court judge and 7 years as a Circuit Court judge. I was born on the 26th of December 1956. I went to Kolongo Dumasi Secondary School in 1969, finished O-level in 1974 and A-level in 1976. I then proceeded to Legon, where I read BA Law from 1976 to 1979, entered the law school in 1979 and left in 1981. I was called to the bar in 1983, 2 years after I had graduated from the law school, because at the time we were being called to the bar, my colleagues were being called to the bar in 81. I was in Nigeria seeking greener pastures. I taught for 2 years in Nigeria before coming down to Ghana, when I was called to the bar and I started practicing law. as a practitioner for about 5 years in the chambers of Dr. Takiotu in Sekondi, 1 year in Sekondi, and 4 years in Kejetia chambers in Kumasi, where I practiced with my friend, the late Sir John, until 1988 when I joined the Ghana Prison Service. I joined the Ghana Prison Service in 1988, and I underwent 6 months military training, and I was posted to Sekondi. That's where I met my wife. At the time I met my wife, he was also a Bobno rank person. She didn't have any rank, actually. A sixth former who was then starting her career in the prison service. I was with the prison service for 2 years, till 1990, when we were told that I, as a deputy superintendent of prisons, couldn't marry a junior officer because we couldn't go to the mess together. So I opted out of prison service so that she could stay. So I joined the Internal Revenue Service, where I was the legal officer in charge of Eastern and Volta regions, also for 2 years. Then finally joined the bench in 1992 December, and the rest is history. So I was posted to Duyayankanta as a circuit court judge, brought to Kumasi. For 7 years I was circuit court judge, and I became high court judge, and then I'm now here. So I've been a Supreme Court judge for the past 17 years until 22nd of April, when I was nominated to act as the Chief Justice during the period of the turbulence. And I'm here before you as a nominee for the position of Chief Justice. Now, if I may read my opening remarks, now that I've asked the first question.
Thank you very much. So, my Lord, beyond telling us about who you are, you indicated you have an opening remark. We've also seen your credentials. In giving us the opening remark, you should briefly describe the personal values and experiences that you believe most qualify you to serve as Ghana's Chief Justice.
Thank you.
You combine it with your remark.
Okay. Honorable Chairman, it is a profound honor for me to appear before you today as nominee for Chief Justice. The judiciary of Ghana stands at a defining moment. As I appear before you today to be vetted by Parliament, I do so fully aware that this process is not merely a constitutional requirement, it's a national reckoning. My nomination comes at a pivotal moment in Ghana's democratic journey, a moment marked by public skepticism, institutional fatigue, and a growing demand for justice that is not only delivered but deeply felt. As I step into this role, subject to your endorsement, the nation will look to me not merely to preserve the judiciary's legacy, but to renew it. The nation needs a judiciary that does not merely interpret the law, but elevates the nation's conscience. With your guidance and cooperation and that of all stakeholders, I pledge to restore confidence in our judiciary and leave it stronger than I found it. If I'm endorsed by you, I pledge to lead an era of greater transparency, efficiency, and accessibility in our judiciary. I do so mindful of the constitutional role of the judiciary, not as a political actor, but as a guardian of rights, checks against abuses, and final arbiter in the rule of law. I propose to anchor our transformation on 3 pillars: procedural clarity and predictability, efficiency and accountability, and open justice. If confirmed, I will stand with every judge, every staff, every court user, and every citizen in the belief that access to justice should not depend on who you are or your connections. The Constitution entrusts the Chief Justice not only with judging cases, but with guarding the credibility of justice itself. My task, if confirmed, is to ensure that the law remains both a shield for the weak and a restraint upon the powerful. With your guidance and cooperation, I pledge to restore confidence in our highest institution and leave it stronger than I found it. Now I am ready for your questions. Throughout my career, from prison service through the Internal Revenue Service and the Judicial Service, where I've been for the past 33 years, I have integrity. I've believed that everything that I've done as a judge has been done with integrity, honesty, and impartiality. I have charted a course of adjudication that believes that the law should be the law for everybody, and that it doesn't matter who you are and what you are. Once it comes to the law, it is no discriminator of persons. That has been my abounding lifestyle. And if anybody were to go through any of my files at any of these places, this is what you come up with: that this man is honest, this man has integrity, and this man has what it takes to be a leader. And I believe that I have what it takes to lead the judicial service.
Thank you very much. That is preliminary. I will then proceed to give the floor to Honorable Roxanne Nelson Kwame Eche Dapamako to ask questions. Honorable Member, you are entitled to 3 questions. You may ask up to 3 questions.
Chairman, thank you very much. I'm guided. My Lord, you're welcome.
Thank you very much.
I wish you all the best.
Thank you.
And thank you for guiding me at the bar.
You're welcome.
My Lord, you have a very rich CV. But let me touch on a matter that is out there. What would you say to those who suggest that your nomination by the president was a reward for your holding in his favor in the 2013 election petition? It's some debate out there.
Well, I don't know. I don't know where to start from. I actually do not know. I wouldn't know what goes on in the president's mind since I'm not there. But I actually will be disappointed if my only qualification for the Chief Justice nomination is because I voted for the President in 2013. But I mean, that's on a lighter note, but I think I qualify for the position. As I said, I have been a Supreme Court judge for the past 17 years. I would not be presumptuous to say I am the best qualified person in the Supreme Court. No, I would say that. But I've been at the Supreme Court for the past 17 years. The person who has served nearest to me has been there for 10 years. Meaning I was at the Supreme Court in 2008. The next person came there in 2015. The others are from 2019 and then 2020. So I think I qualify for the position. And let me add something. I was actually, if you look at my CV and if you follow the trajectory of my career, I was actually admitted, I actually was made a circuit court judge by Chairman Rawlings. Then I was promoted in 2000, and I was sworn in together with Senator Jamefe. I was sworn in by the then Vice President, President Mills. Then I was elevated to the Court of Appeal by President Kufuor. Then to the Supreme Court by President Kufuor. So if, that was 2008. So if 17 years later, another president deems it fit to elevate me to the position of a Chief Justice, I think I cut across all political boundaries. I don't think that, I think I'll be a reason for people to say that, oh, this man is deserving of the position. Because from Rawlings, Mills, Kufuor, and then Mahama, I think I deserve the position, that's why. But as I said, the president might have personal reasons. I don't know that.
Very grateful.
Any further question?
Yes, my Lord, you have a very rich and expansive CV. I see that you've done, as part of your work as a juristic officer, you have also worked extensively in election and election-related matters, chaired a lot of committees. Now, the argument is out there regarding the duration that presidential election challenges take, all the 2 or 3 that we've had so far. Will you consider, if you get the approval of this House, will you consider introducing reforms such that, for instance, a challenge can be determined before inauguration on the 7th? Will you consider that? That is between the 7th of December and the 6th of January. Will you consider introducing?
Thank you, Honorable Chair. Thank you, Honorable Chair. You see, as part of the, as you said, I have been a member of the Election Management Committee of the Judicial Service since 2010. And then I became its chair in 2020. As a part of our engagements last year, we had a lot of stakeholder engagements with IPAC. We had stakeholder engagements with the CDD, CODEO, that is CSOs, and then the Peace Council. The main theme of these meetings was the fact that In 2013, the election petition lasted for almost, it was 8 months. The final decision came on the 29th of August. Essentially, I'm the only surviving member of that panel. Everybody else has retired. The final decision came on the 29th of August because one of the first drawbacks was we spent almost 1.5 months discussing whether to even allow the NDC as a party to join the action. In the long run, at the end of the day, by a majority of 6-3, NDC was joined to the action. It was one of the greatest mistakes we made in that particular trial. And that was one of the first things we touched on after the trial. We went into a conclave and came up with a decision that, no, there was no need to join any other party. So CI 99 came up, and that was when we decided that the trial and everything could be done within 42 days. So discussions went on, and we agreed on 42 days maximum for presidential election petitions. And so in 2020, when there was an election petition, it was a straight fight between JDM and then Akufo-Addo at the time, and then the EC. And it took 42 days to deal with that election petition. But we know that Kenya does theirs within 21 days. The only time America faced an election petition, that was between Al Gore and Bush in 2000. The election petition, whatever it was, ended with a declaration of the new president before the inauguration. So at most of these forums or fora where we discussed the elections in Ghana, we came to the conclusion that it should be possible to have the election petition concluded before the 7th of January, the inauguration day. And the first suggestion that came, which we think was a masterstroke, was that we should have the elections on the 7th or the 8th of November. If we have the elections on the 7th or the 8th of November, by the 10th, the results would have been declared. If we have the results declared on the 10th of November, we have 20 more days before even November ends. Then 31 days of December, then 6 days of January, making a total of 57 days. Assuming we want to stick to even the 42-day window provided by CI 99, we can have the election petition filed, responded to, and everything tried within the 42 days, because we have 57 days. That is number one. In addition to that, we can have, lawyers say that every originating motion or originating process has to be served personally on the defendant or respondent. But we all know that in this day and age, every form that anybody fills with the EC, you have to provide electronic address. You have to provide email, telephone, WhatsApp, and all that. So instead of saying that you file a petition and it takes 7 days to get to the respondent. Using the electronic mail, we can reduce the number of days to, let's say, 3 days. So a process that is filed, if it is served electronically, even the originating process can be filed and served electronically within 3 days. Instead of waiting for, let's say, 1 week for the response, we can reduce the number of days for the response to, let's say, 4 days. So if we adjust times like that, by the time we get to about, let's say, the 30th of November, that's granted that we had the elections on the 7th of November. By the time we get to November ending, processes would have been, pleadings would have closed. CMC, court management conference would have gone through, issues would have been settled, and then the trial will begin. And a trial like that, we can say it should take no more than 2 weeks. And once 2 weeks are there, we say judgment should be given within 1 week on the release of the results. Meanwhile, at this point in time, during December, we have a lot of holidays. But under the fiat of the Chief Justice, the registries can be made to stay open so that processes can be filed, served, exchanged, everything can be done in such a way that we can have all these things done before the end of January, so that by 7th of January, Inauguration Day, we will have our president who will take the sword and swear to his people and be able to say, because we all know in 2013, for 8 months, the president-elect was performing his constitutional duty all right, but he wasn't too sure whether he was going to be chalked off or replaced or what. Even though the 2020 election petition also lasted for only 42 days, it lasted beyond the inauguration. So these are things that we have discussed, and we shall need the input of Parliament when it comes to LIs and CIs to be prepared. So this is what I intend to pursue so that we can have our election petitions, if any, in future. And I'm sure there will be, and before the inauguration day. Thank you, Mr. Chairman.
Thank you very much. Do you have any further question?
Mr. Chairman, thank you. That is so. My Lord, I appear to be the Lone Ranger in this matter. The welfare of the judges at the magisterial level is so dear to me. But I see a disparity in the welfare, in the service of office and conditions of office for what you term professional magistrates, that's lawyer turned magistrates, and the career magistrates. And they do a lot of work, the career magistrates. In some cases, they do relieving in 2 or 3 other district courts within their jurisdiction. So the question is,
yes,
will you consider introducing the career magistrate program to absorb young men who are interested? Yes, reintroduce, because it will be a very heavy source of personnel, and also reforming them in such a way that they will have the opportunity of rising through the ranks to the level Because recently you just elevated.
Honorable member, I think
finish.
you have
Mr.
asked
Chairman.
your question.
No, Mr. Chairman.
You see, today I said we'll go by the rules. A questioner is not supposed to run commentary. You don't run argument. The foundation cannot be too long. So strictly proceed to ask questions. That is the rule. So Honorable Roxanne Nelson Dafamakpo, ask question.
Chairman, I'm guided. Thank you. So, CJ nominee, will you consider reforming the courses, the career magistrate program in such a way that they'll have the opportunity of rising through the ranks and getting to the highest level? Because they do a lot of work as the same as the professional magistrates. Presently, you have about 75 openings at the magisterial level. You just elevated some from the circuit to the high court. Naturally, you will elevate the district judges to the circuit court.
Thank you, Mr. Chairman. In the years gone by, when we started practicing, we had the grade 2 magistrates and the grade 1 magistrates. And the grade 2 magistrates were actually not trained lawyers. Most of them were social welfare workers, retired teachers, and the rest. They were grade 2 magistrates. And then lawyers who joined the bench, but were not 3 years, also had to work as grade 2 magistrates. Her Ladyship, Justice Avril Lovely Johnson, was a grade 2 magistrate in Chebi. I appeared before her when I was a lawyer with IRS in Koforidia. I used to appear before her. So that was, but when lawyers get to 3 years, lawyers who had joined the bench got to 3 years, automatically they became grade 1 magistrates. But with the grade 2 magistrates, the original ones, they never had the chance to go beyond grade 2 magistrate. They couldn't join the bench at any level because they were not lawyers. That was the situation of things until sometime, I think in the 90s, the whole concept of grade 2 magistrate was abolished, leaving only professional magistrates, that's lawyers who were magistrates. But then, around the 2000s, the millennium era, this concept of career magistrate was reintroduced. This time they were not called grade 2 magistrates, but they were called career magistrates. But they were doing the same thing. And this time, the judiciary went one step further. Whilst with the grade 2 magistrates, they were just social welfare persons who had retired or been drafted to become magistrates. With the career magistrates, these were even, they could be even as young as 30 years. But they were the very first ones were actually workers with the judicial service who were drafted to undertake 1 year or 2 year course at the law school. So they took 2 year courses and then they were made career magistrates. But they are not lawyers. So their career path carries them only to the chief magistrate level. And that was it. It doesn't matter how long you stay there, you can get to a chief magistracy, and then that will be the end. But we still maintained the 3 years for professional magistrates. So what happened? What then became the order of the day is that these lawyers, these career magistrates, then opted to go and read law. And once they went to read law, then they could transition to become professional magistrates. But here was the problem. You find somebody who has been a career magistrate for, let's say, 7 years, 8 years, 9 years, 10 years. Now he goes to the law school, he transitions to become, he's a lawyer now. And because he hasn't spent 3 years, he has to remain on the career magistrate level until he becomes 3 years. He gets to 3 years. Even though he might be more experienced than somebody who has left the law school and, been practicing for the past 3 years. So there was a problem. And then again, I know, for example, in the army, if you go through the rank of, let's say, the junior ranks, the furthest you can go is maybe chief warrant officer. But in the army, you have a warrant officer who, because of longevity, maybe even be receiving a salary higher than that of a captain at a senior officer level. But with the career magistrates, it doesn't matter how long you stay as a career magistrate. You cannot run an incremental that will make you overtake a professional magistrate, somebody who has joined just this year. All these were problems but as your honorable member was saying, only about a month or so ago, we had a send-off party for a couple of our retired career magistrates. And it was when their CVs, their citations were being read that we realized that we really need them. Because these are the people who are prepared to go to the nooks and crannies of the country. Maybe you are a magician, maybe you have been following the judicial service. But the vacancy at the district court is 116 at the district court. We are not getting lawyers to join at the magistracy, at the district court. Most of them want to come to the circuit court and to the high court. So with the current elevation of some circuit court judges to the high court and the district court to the circuit court, we are going to have an opening for 116. And I can assure you, we are not going to get, no matter how often, how much we advertise, we're not going to get lawyers to come and fill these vacancies. So it is my project that I will be discussing with the Judicial Council, the reintroduction of not only the reintroduction of the career magistrates, but we should be able to have a proper remuneration regime for them so that those who come can stay. And then, again, it should be possible that there should be a law that makes it possible for somebody who has been a career magistrate for a certain number of years, if he becomes a lawyer, then he doesn't need to wait for another 3 years to become a professional magistrate. There should be a smooth transition. This is a project that I intend to pursue.
Thank you very much. I will then proceed to give the floor to Honorable Mahama Shaibu. You are entitled to 3 questions. Strictly questions. I can assure you, my Lord, that every member of this committee may want to exhaust the 3 questions. So, strictly questions, no comment. And non-members of the committee, I plead with you to perpetually remain silent.
Chairman, let me thank you very much. My Lord, congratulations. Chairman has cautioned. But, my Lord, cost of litigation by the day has become very expensive. Legal Aid Commission came in as a stopgap. Unfortunately, they lack the resources to represent clients. So today you have in courts unrepresented litigants. Would you consider fashioning out a very simple procedure which can take care of unrepresented litigants? Thank you.
Thank you very much, Honorable Chair. The legal aid is an orphan. The legal aid board is an orphan, like the prison service. Now the prison service, they are getting some parents. But the legal aid remains in the doldrums. It is true that cost of litigation is now very high, and it's becoming very, very high. Higher as a result of the delays that are occasioned in the courts, so that even small, minor offenses in the criminal realm, small claims in the civil realm, still have to follow a long queue. So litigation is now very expensive. And when you look at the persons who patronize the legal aid, you realize that, but for the fact that they don't have the means, they wouldn't go there, because they are very much under-resourced. So it is something that I have discussed since I started acting. I have discussed with the Attorney General, and we are trying to find a way of resourcing the legal aid. As a matter of fact, with time, in the long term, we are thinking of even mobile courts, which will be able to take care of some of these things. We are thinking of, I was telling somebody that maybe the president even stole his the 24-hour economy idea from the Judicial Service, because we have planned for some time now to introduce courts around the clock so that we can have night courts. And then, see, all these are supposed to augment the legal aid situation. If there are courts around to take care of cases, definitely the cost of litigation will go down. So apart from asking for more resources, which I have discussed with the Attorney General, we are thinking so much about other things like having night courts, weekend courts. Already we have weekend courts to take care of electricity and other things. So once we do that, we hope that. And then, to cap it all, the ADR, ADR is something, an avenue that we want to highlight. Already we have court-connected ADRs, and then we have set aside weeks, 1 week in every term, to have ADR sensitization. But people are still not sensitized enough to resort to ADR in some of their claims. So we have a combination of plans to get rid of, to restore the legal aid and also reduce the cost of litigation. Thank you.
Thank you very much. I recognize a supplementary question from Honorable Mahama Yarega, the leader of the House. You have the floor.
Thank you. So, my Lord, do you have your commitment that your court will now say 24 hours when you become Chief Justice? Judiciary at 24 hours.
I said we are exploring. Already we have. No, we
want to pin you down to a specific commitment to this committee that the courts will explore and will sit 24 hours and provide opportunities to citizens to pursue justice 24 hours.
Well, it is possible, but for now, we have some courts that have morning shifts and afternoon shifts. At least for now, we have that one. And we have some courts that sit over the weekends. So it is now left to us to, so we can say we have a 16-hour economy. It's now left with time, maybe we will get to a 24-hour. I'm certain the President showed his ideas from us.
Thank you very much. Honorable Shaibu, do you have any further question or follow-up on this question?
Thank you, Chairman. A further question, not a follow-up. Yeah.
Very well. That is your question number 2.
My Lord, let's still stay within justice delivery. A very important aspect of how we live. Cases on appeal. Previously, if you're up country, Bolga, Wa, Tamale, you would have to travel to Accra for Court of Appeal cases. I note that there was a system in place that cases were heard in Ho, Kumasi, Tamale, and Cape Coast. This, for some time now, has not been working, or it has been suspended. Would you consider that Accra is not Ghana, and that many regions still will have to travel to Accra to the Court of Appeal? Would you consider reinstating and possibly expanding that service to all regions of this country? Thank you.
Thank you, Mr. Chairman. I think with all due respect to the questioner, I think the question is not factually correct. Yes, we used to have Court of Appeal sitting in certain regional capitals that are not where we don't have them now. But it is not true that all the other regions have been suspended, no. Now we have a Court of Appeal in Accra, as usual. We have a Court of Appeal in Kumasi, where we have accommodation. So they are residents there. The judges, there are 10 judges of the Court of Appeal who are in Kumasi, resident there, dealing with cases in the Ashanti region, Brong-Ahafo, and the north. We have 5 dedicated Court of Appeal judges for Eastern and Volta regions. I mean dedicated in the sense that they are assigned to only the Court of cases from Eastern and Volta regions. So the Court of Appeal sits in Koforidua. Then a Court of Appeal sits in Sekondi to take care of Central and Western regions, and then the Western North. So we have at least 4 courts of appeal. That is Accra, Kumasi, Koforidua, and Sekondi. These are the 4 places that we have our cases. But whilst because there is accommodation for the judges in Kumasi, they are resident there. The dedicated 5 for Eastern and Volta are living in Accra, but they go to Koforidua 1 week in a month. 1 week in a month. They will go and sit there 1 week in a month. Then those who are for Sekondi also go to Sekondi and deal with cases 1 week in a month. Now, Tamale and the North don't have resident judges there, but they are also served by the judges in Kumasi. But you see, because of distance and then even costs, any time the 5-member committee, judges, the panels goes to Kumasi, goes to Sekondi, the service spends 38,500 cedis or 40,000 cedis on them in terms of hotel accommodation, transportation, and all other logistics. Koforidua, if the 5-member go, it's the same thing, around 40,000 cedis. But you see, going from here to Koforidua is so easy, even though it is risky and inconvenient. It is still short. The Kumasi people found it very difficult to go to Tamale, where they would meet the judges. So they were doing virtual hearing. The virtual hearing was started at the time of COVID, and we realized that it is a very good way of doing things. So Kumasi and the North were communicating only by virtual hearing. And then, but when I started acting, I realized that the virtual hearing was not very convenient because of the interconnectivity. There were breaks in transmission and other things. So I actually spoke to the Judicial Council. We went to see the Minister for Communications, that is Honorable Sam George. And now we have the interconnectivity is so good that even now we don't go to Sekondi again. We do virtual hearing of appeals for Sekondi. So now instead of incurring 40,000 cedis in a month, we do virtual hearing. So it is something that the lawyers are very, very happy about. For now, the judges stay in Accra, and then the parties meet in Koforidua. So even if the lawyers in the case are in Accra, they still have to go to Sekondi to take part in the virtual hearing. Now, what we are aiming at is a situation where we can have persons, for example, Kofodia and Ho. We are trying to get to a situation where lawyers will not go from Kofodia Ho to Kofodia, but they can also have a hearing whilst they are in Ho, so that the judges will be in Accra, the parties could be in, some one of the parties could be in Kofodia, another party will be in Ho, or Cape Coast lawyers can sit in Cape Coast and listen in and take part in it. That is a long-term project, but for now, the regional capitals are taken care of by way of virtual hearing.
Any further question?
Yes, Chairman.
Please do.
I see my Lord is getting into virtual stuff. So let's move on to empaneling of judges at the Supreme Court. First of all, what goes into the thinking when you are empaneling judges? And given that the human element of it raises some questions, would you consider looking at an automated system of empaneling judges at the Supreme Court? Thank you.
Yes, my Lord.
Thank you, Honorable Chair. Empaneling creates a lot of anxieties among people. There are lots and lots of people, suspicions about for judge shopping, persons who are, some judges are not empaneled and other things. I think to get rid of such suspicions, we should be able to consider AI to do that. I am not very AI, but I know that those who know about AI tells me that if you are able to feed the computer or AI with information about judges, their philosophies and everything, the AI should be able to do empaneling based upon the things that we have fed it with. And I think it is done elsewhere, so we can try it. But what actually goes into the used to go, I wouldn't be able to say for some time now what. But when I joined the bench, when I joined the Supreme Court bench, we were about 16. And then when at the Supreme Court, we know everything is based upon seniority. We have persons we refer to as seniors. Then we have the middle, and we find the juniors. There is no derogatory. None of the words is complimentary or derogatory. It only shows when a person was appointed. So I will be the most senior. It doesn't mean I'm the best. Somebody may be the most junior because he was appointed to the Supreme Court only yesterday. But that is how we had this classification. So any case, we had the seniors. So any case that we wanted to empanel, you find one senior. Since we sit in panels of 5, we have a senior, we have 2 middle, and 2 juniors. And that makes a panel. And it was done randomly. There were situations where if we are sitting in 7 and we want to believe that this is a matter that we should get the seniors to sit on, then it is that can also be done. I remember in the 2013 election petition, the empaneling was done in such a way that the Chief Justice opted not to sit on it. Justice Datiba had only 4 months to go on retirement. And since we were not too sure how long the whole trial was going to take, he opted out. Then it was number 1, number 2, number 3, number 2, up to number 9. So it wasn't like somebody had been handpicked from somewhere because of this particular reason or the other to do it. So empaneling is normally done randomly, or it follows certain patterns. But because of the anxiety it creates among people, the suspicions, or people feel it's not transparent, I would not, I think we should be able to consider AI empaneling. But in our part of the world where a person can decide not to sit just about 2 or 3 hours to time because the wife is being taken to the hospital or the father has just died, it means AI will find it difficult to replace such a person. Maybe AI should be told that, okay, instead of 5, set aside 6. So when somebody opts out, you can bring the 6th person in. So AI will be a very good thing for empaneling. Thank you very much.
Yes, Honorable Shaibu, your very last question.
Yeah, exceedingly grateful. Exceedingly grateful, Chairman. I see my Lord has veered into AI. Can we apply AI again or any other method? Backlog of cases and then delays. What concrete steps and time-bound steps would you want to employ to deal with backlog of cases that are hanging and speedy trials? Thank you.
Thank you, Honorable Chair. I think to tackle the backlog, to find a way of clearing the backlog, we must first identify what causes the backlog and then the delays. In the first place, litigation, courtroom litigation the volume has increased, whether we like it or not. Now, people litigate practically over everything. In the years gone by, I'm sure if you took my picture and you displayed it in your newspaper, and so I'll be very, very happy if somebody came and, Daddy, I saw your picture somewhere. I mean, I will see it as even you promoting me. But I'm certain that if you displayed my picture in your anywhere else, maybe even in your house, and without my permission, I will sue you. So now people sue practically over everything. Intellectual property and everything. So the courts are inundated. That is number one. We've tried to solve that problem by opening more courts. But the more courts that are opened, the more the litigation comes up. Some time ago, we had courts up to Medina. From Medina, you could only go to another court on the mountains. Then we realized that we have to have a court at Adenta to take care of that enclave. Now, courts in Adenta have more cases than courts in the law court complex. The threshold for every court should be about 250 cases. At the last count, the High Court 1 in Adenta had 849 cases for one court. So the cases are many. There are more cases. So it doesn't matter how hard you work. You find you deal with one case and 2 more cases are added. Then we have situations which I will refer to as, institutional. CI 47 was actually passed in 2004. Those of us who were practicing using the older version of the rules, that was LN 140A of 1948 or 1950, 1960, 1954. LN 140A of 1954. Between 1954 and 2004, when the new CI 47 came, lawyers were always referring to the White Book of London, of England, which had undergone several editions. But we still had our LN 140 of 1954. By the time we had the CI in 2004, CI 47, it was already dead at birth. It was outmoded at birth. So we have rules in the CI 47 which make it impossible for us to move forward. In this day and age of electronic e-service and everything, we still say that when a person issues a writ, it has to be served within 8 days. Now we have the Electronic Act, which makes it possible for you to do a service electronically. But the rules insist that as far as the originating process is concerned, it has to be served personally. So in this day and age of when everybody fears for his security, we still have bailiffs going around serving processes. So if we improved the rules, we have situations where applications that are filed, applications are filed and they stall proceedings in the trial courts. All these things are catered for by the rules. So if we are able to review the rules, and that is one of the things that I intend to do, to engage the Rules Committee, the Attorney General's Department, the Attorney General, not Attorney General's Department. I will be on his neck, and then I'm not going to kill him. I'm not going to kill him. I'll be on his neck, and then with the Rules Committee, so that we should be able to amend the rules to make it user-friendly, to take care of the technicalities so that trials can be sped up. As for the cases that are already in the back, that have been clogged, what we can do is that we should be able to track. Now we have a monitoring team, which I'm going to reinforce, that should be able, that goes about tracking backlog cases that are locked up, and then we will see what we should be able to do about it. This is not to say that there are no human elements in this. Lawyers play all kinds of games to have cases delayed. They play all kinds of games to have cases adjourned. I remember when I was appointed the Supreme Court judge, and we were attached to the American Supreme Court. They were surprised that we could grant adjournments on the ground of somebody's wife, and because a lawyer says, my wife is being taken to the hospital. The judge asked us, are you a doctor? If your wife is going to deliver, you are the doctor, you don't need to be there. You have to come to court. And that is their system. But here, sometimes you have somebody coming to say, my father has died. 3 years later, he's asking for adjournment, and his father has died. 4 years later, the same father has died. How many fathers you have, you cannot really tell. So we see there's a human element to this. But we are going to work on all these so that we can have a reduction in the backlog of cases. Thank you, Mr. Chairman.
Thank you so much, my Lord, the Acting Chief Justice, and the nominee before us. We have 6 more members to ask you a question. Therefore, we will plead that the brevity rules that apply to members would apply to you, mutatis mutandis. So I will call on Honorable Haji Aladi to ask you a question.
Thank you, Chairman. Chairman, let me take the opportunity to congratulate my brother on his being nominated. From your narration, you have clearly stated that you've come a long way through so many governments, presidents, vice presidents, and what have you. That is actually a basket full of a lot of experience, and your CV tells it all. However, although you are acting, you are now going to be the substantive, inshallah. My question is, as Chief Justice, you will preside over a Supreme Court with diverse personalities and differing judicial philosophies. How will you foster collegiality and prevent personal disagreements from undermining the administration of justice? Thank you.
Thank you, Honorable Chair. Well, Honorable Chair, by its nature, the Supreme Court is collegial. When we say collegial, we mean, unlike let's say, the District Court, the Circuit Court, and the High Court, we sit in colleges, we sit in panels of more than one. So, and then we take decisions together. There is every judgment that is delivered that you read about, even though it comes under the hand of one judge, you can be sure that it has been decided by the panel members. Unless there is a dissenting opinion, it is the opinion of the judges. So that is why we say it's collegial. We go into a college, we call a conclave, and then we come up with decisions. You are right. I come from Gozo. the person who is now the president of the court comes from Navrongo. We have somebody from Wa. I went to the best secondary school in Ghana, Korongotuma Secondary School. Somebody went to one of us went to a school which is no longer even in existence. Sir Dennis went to a school which at the time was a mixed school. Now it's a girls' school. Achimamai Secondary School has now become a Fiakobi Girls' Secondary School. So he doesn't even know whether he's an old student or... So...
My Lord, he's still an old student. And the school is still in existence.
And then there is this Wa man who went to school at Koforidia, the town of the flowers. You see, so you are right. We come from different backgrounds, different schools, different philosophies. Some of us, a couple of us, about 3 or 4 of us, started from 2 of us started from the magistracy. Her Ladyship, Avril Lovely Johnson, started from grade 2. Sergio Jamefe started from the Regional Tribunal. So both below the Circuit Court, where I started. And then there were some of us who joined at the Court of Appeal, like Sir Dennis. Justice Puaman joined at the Supreme Court. Justice Yodi Kulendis joined at the Supreme Court. We have persons who have come from the academia, like Professor Mensa Bosu. So we have different philosophies. This is the Supreme Court. And so when you have all these people with different backgrounds having to come together and then agree on something, even with all due respect, you see how lawyers agree or disagree. The little that we saw from the Honorable Deputy Speaker, Honorable Minority Leader, and Honorable Majority Leader, 3 very able lawyers agreeing or disagreeing on the rules, the standing orders. It shows that once we come from different backgrounds, we will have different approaches to things. It could be our strength, but it could be a weakness. As a Chief Justice, your ability to harness all these into something concrete, that is what leadership is about. That is what you should, if you are able to do this, and you should be able to discuss things formally and informally before things escalate. You should be able to do things. Even empaneling can create problems among you when somebody feels that this man is not being empaneled. I wasn't empaneled for close to 1 year, even though I was the number 2 after the Chief Justice. I wasn't empaneled. It can create problems. But as a leader, you should be able to manage all this. And then you should be able to manage all this. And even though I'm talking about collegiality and then the need to have a consensus, that should not be the final thing. You should be able to encourage parties, judges, to air their views. Dissent should be encouraged. It is always better to have a consensus on everything. But if you can't have a consensus, you should be able to, if somebody says, I'm going to write a dissenting opinion, you should be able to write a dissenting opinion. You should be able to encourage the person to write a dissenting opinion. It is a way of fostering unity amongst yourselves. And fortunately, again, having been here for so long and having been here, having dealt with all the members of the Supreme Court bench now, I happen to have personal relationship with every one of them. Every one of them. Those who used to appear before me when I was a High Court judge, like Justice Dorothy Kulendi, Justice Poaman, they used to appear before me when I was a High Court judge. Justice Dennis used to appear before me when I was a Circuit Court judge, and he was a lawyer in Kumasi. And then Justice Ajay Frumpong was a junior to my very, 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 very good friend called O2SL, who has passed on. So when I was even sitting as a High Court judge in Kumasi, he was appearing before me. So I have this relationship with all these judges that makes it easier for me to be able to bring them all together. So I will be able to do that. Thank you.
Thank you, Honorable Haji Aladi. You have a further question?
Yes, please, Mr. Chairman.
Please do.
Mr. Chairman, there is a very big issue that is worrying a lot of us when it comes to getting maybe people who are brought before the courts so that the judges can handle them very fast. Cases are not taken up very fast. So because of that, you find our prisons choked with a lot of people, some even just because they have stolen a bunch of banana on remand. You simply can't understand. And if you look at them, when people show you such pictures, it's horrifying. Will you consider ensuring that we have at least these community courts, the tribunals, working very seriously, and you applying the 24-hour economy as you have said earlier on, so that such people can be given community kind of punishment just to deter them, rather than pushing everybody to the prisons. Because recently, just 3 days ago, just 3 days ago, I got a message that someone went to court and then was told that the judge had put to bed, so she was not in court. Now, when is she going to come out, let alone to look at it? And I don't know whether it will be passed on to another judge or that case has to wait. So will you consider ensuring that the tribunals come up basically at all the best places that you can think of, so that such cases would be handled or fast-tracked? Thank you.
Yes, my Lord, your response.
It looks like you are speaking the language of my wife. My wife has maybe engaged you to ask questions about the prison service. This is something that I know about, because as I said, I was a prison officer. And since my wife is also there, I know. For example, I am told that the inmate situation in some prisons was built, the capacity for some prisons is 851, 851. As of today, they are 3,562. A variance of 2,711. Kumasi male prisons was built for 416 persons. As of today, there are 1,727. And this is replicated all over. The prisons are choked. The prisons are choked. Remand prisoners, I mean, it is a bother. And one of the causes of the prisons getting choked is people being remanded, and sometimes indiscriminately. That is why, and then there are also some, as you said, who have committed minor offenses, who shouldn't be there, but they are there. So I think that it was particularly for these minor offenders that the Justice for All program was introduced. And for some time now, maybe because of the turbulence, this year, they have not actually even sat. It is something that I want to reignite, revamp it, so that we can have the Justice for All back on the road, so that we can get rid of some of these persons. But apart from saying this, I also want to say that, Honorable, there are some people in the prisons who have been granted bail, actually. They have been granted bail, but they are still there because they can't meet the bail conditions. And not that the bail conditions are too high. Sometimes they are too high. But in most cases, they are not. In so many cases, they are not. And so you find somebody in prison, somebody on remand, who has been on remand for 5 years, 3 years, 4 years, 5 years, and those of us outside will say, hey, if this man had even pleaded guilty and he had been convicted, he would have spent only 3 years. But because he pleaded not guilty, he's on remand, and his case is not being tried, and he has spent 5 years. But that is not the fault of the judge. If you appear before the judge and you say you are not guilty, you are not guilty. The judge says you are released on bail. But there are some people, unless you say they should sign their own bail bond, they can't get anybody to come and bail them. Unless you release them on their own self-recognizance, they will not get anybody to come and bail them. I mean, there are some of them, and as a judge, we have conditions to grant bail. The main condition a judge looks at is, this man I'm releasing on bail, is he likely to come and stand trial? The person who is making efforts to run away because he has gone to see some foreign embassies to seek asylum, he's trying to run away already. The man has been granted bail once and he didn't appear. And so if a judge decides that, no, a person like that, I'm not going to grant to bail, it doesn't matter the offense that the person has committed. The judge may not grant bail, but even if the judge wants to grant bail, he will not give you bail on self-recognizance. So persons like that, they will not get people to stand surety for them, and they will be there. So while admitting that there are some people who shouldn't be there, there are also some people who are there because they have to be there. And Honorable, we are always talking about a bunch of plantains, a crate of eggs. My mother is a Catholic, was a Catholic. I always tell this story. My mother was a Catholic. And you know, these old ladies, how when they said, in my time, the Catholic priest was a white person. So at the end of the year, my mother wants to go and then harvest a particular plantain that he has nurtured over the year. My mother was going to the farm every morning with a bent back. This young man was sitting under the shady tree. In our place, we call it in Congratulatory, playing drafts. Every day, my mother passed by him to go to the farm. Now, 1 year on, it is time for harvest. My mother wants to go and harvest the plantain to come and give to the reverend minister, the white priest, who speaks Latin. And then this young man has gone there. And you know, when they go there, they don't cut the plantain. They move it from the top. So my mother will walk all the way to the place before realizing that the plantain has been harvested. We sit in Accra here. When a magistrate at Gosu decides to send the boy to prison for 3 years, we sit in Accra here and say, the man stole only a bunch of plantains. Do you know what it means what the bunch of plantain means to my mother? It's like stealing your car. You see? So, I mean, there are so many reasons. The magistrates and the judge, they are trained. They have this, the sentencing guidelines. They have them. But sometimes they have to go beyond it. In my youthful days, I gave somebody 70 years. Atayi, I gave him 70 years. And what I told myself was that if Atayi was given 30 years and he comes back, my family will be the first family he will attack. So by the time he comes back after 70 years, I'll be dead and gone. So you see, then we are thinking about community service. Yes, there are some people who, if you give 3 years, 4 years, touch wood, if I am convicted and sentenced to 4 years in prison at Nsawam, I may not eat prison food for even a day. I will have some people bring food to me. So if you want to make me feel the prison punishment, prison sentence, then maybe you should order me to go and do community service. Maybe around the place where I stole, around the courts, that they'll see me. Because punishments are not only for the person, the victim, or the person being punished, but to deter other people. So community sentences should be introduced. But that one is in your bosom. It's a law. That one will have to be taken up by you. Another way of decongesting the prisons is through the parole system. People should be able to go out on parole for exhibiting good conduct or whatever. So if the parole system is introduced, I'm certain we can reduce the numbers in the prisons considerably. But, parole system, you cannot do that without tackling the social welfare angle of the parole system. You have to beef up, because I know in some jurisdictions, when a parolee or a person who has been granted paroles may not even be able to go beyond a certain distance because he has a tag that gives AI alarm to somebody. We don't even have these things here. So, Honorable, we are at it. We will play our part by reducing pension for imprisoning people. We will curb that pension of giving long sentences. I'll talk to my people, because any long sentence person you said to my wife, I get a knock. You allow these people to come here, and they are disturbing me. So, Honorable, that is what we are going to do. Thank you.
Thank you very much. Honorable Ladi, do you have a supplementary question, or you want to ask your last question?
Thank you, Chairman. I want to ask my last question.
Thank you very much. Proceed to ask your last question.
Mr. Nominee, during your presentation, you mentioned places where we can find courts of appeal. Unfortunately, I sat really feeling very bad, because I would say I come from the northern sector. And I have continuously heard my people crying when they have any case that needs to go to the appeal court. They would have to travel as far as to either Kumasi or Accra. I have listened to you carefully and heard you talk about infrastructure and the way monies have to be spent, which is quite a difficult one. Will you consider putting up at least one with all the amenities that are needed to take care of the 5 regions of the north, to ease problems of our people having to travel these distances?
Yes.
Honorable Chair, Honorable Chair, it is possible, it is feasible. We have done it before. We have done it before. You see, I know how sentimental people feel about such things. When I started acting, I got a letter from a community, and they said they wanted, it was written so beautifully, they wanted a district court. So I gave it to the court's services manager to advise me. And you know what? He came up with the fact that the community they are talking about, they are 500 people. 500 people. And then he mentioned the various courts that are close by. And we found that almost all those courts have cases no more than 10 a day. Sometimes the whole week. It is not, when we tried the Court of Appeal in Tamale, we realized that all the cases could be heard within a matter of 2 months. All the cases. So it is just not feasible having 5 judges stationed at Tamale to take care of the north. This is not just because the number of cases that come from the various regions put together is not up to much. So, to prevent this situation where lawyers and parties will be coming to Kumasi or Accra, that is why we are introducing the virtual, so that they will be meeting in Tamale. The lawyers don't need to, with virtual hearing, the lawyers don't need to move at all. They have to be in Tamale. So, as I said, if you have a case which is being handled by a lawyer from Kumasi, for now, the lawyer will have to travel to Tamale to go and be in the Tamale courtroom where the virtual takes place. But as I said, we are working at it. in a matter of time, we have find ourselves in a situation where some of the parties and the lawyers can be in Tamale courtroom, whilst some other lawyers will be in Kumasi, and they will be hearing cases. This is done. When international arbitration takes place, people hardly travel from here to London for international arbitration. They do virtual hearing. So that is what, if it becomes necessary for us to station judges permanently in Tamale like we have done in Kumasi, we will do that. But Honorable, you have to help us get accommodation for them.
Thank you, Honorable Adi. You have exhausted your 3 questions. On this note, honorable members, our revered guests, it is in the interest of all of us to take 20 minutes health break. Well, Hajia, you have the floor for 1 second.
Thank you very much, Chairman. So, my brother, I wish you all the best. When my colleagues were leaving, you would have heard them. It's normal of me to say, I wish you all the best. May the Almighty Allah guide and protect you.
Thank you.
So that you will be able to do your work as expected and to the best of your knowledge and to the development and progress of Ghana.
Thank you very much, Honorable.
Have a blessed job ahead of you. Thank you.
Thank you so much.
Thank you very much. We shall resume our seats exactly 10 minutes after 5 o'clock.
Well, it's 11 minutes to 5 p.m. We've been bringing you the coverage of the vetting of the Chief Justice nominee, Justice for Baffoe-Bonnie. The vote was scheduled to start at 11 a.m. Well, after a lot of back and forth, it eventually started, even though it's just by one side of the House, the NDC majority side. The NPP minority side has decided to not be part of the questioning of the Chief Justice nominee. Now, the NDC side has been doing the questioning for more than an hour now. The chairperson, Bernard Ahiafo, has just announced a short break, after which they will resume to continue vetting the Chief Justice nominee. Here on 97.3 CTFM and on ChannelOne television, we'll bring you every question and every answer until the House of Parliament decides what it is going to do with the Chief Justice nominee. We'll be back to bring you more on that. Please stay with us.
Habibi, my people, welcome to Dubai. My name is Sheikh Alkal bin Maktoum. Okay, so I am Caleb, right? Caleb Kuda is my name, and this is Beyond Borders on ChannelOne television. We are in Dubai. So join me. Let us explore the allure, the beauty, and the reality of life and living it in Dubai through the eyes and the experiences of our compatriots.
Imagine 6 people, 10 people sharing a common room together.
If you're not a na complain there in the sense, why you are share one rooms now? It doesn't smell pleasant. Or hunting no complaints now be bring to the fair no too.
Dubai is one of the most organized, highly resourced, and well-endowed countries you would find.
You've been here for 7 months.
Yes.
Without a
job. Yeah.
How is it like?
So hard.
Tell me about it.
Struggling, renting and feeding is so hard.
Every frame per second of their lives in Dubai tells a story. And we've got it all captured right here on Beyond Borders, only on ChannelOne television. So don't get told, don't miss out. Catch these compelling stories of Ghanaians in Dubai only on Beyond Borders on ChannelOne TV this and every Wednesday at 7 p.m. I catch you.
Beyond Borders is sponsored by Copen Hospitality. This November, something amazing is coming to Accra. Are you a farmer with fresh produce? Are you into fish farming, poultry or livestock? Then get ready for the November edition of the AgriFair 2025. Yes, AgriFair 2025. It's happening on Friday the 28th to Sunday the 30th of November. It's happening at the A4 Southern Children's Park and it's 10 a.m. to 6 p.m. each day. It's the ultimate weekend marketplace. From fruits and vegetables to poultry, livestock and fish to agri-inputs and processing machinery. All at unbeatable farm gate prices. Whether you're selling or buying, this is your chance to
workers, retired teachers, and the rest. They were grade 2 magistrates. And then lawyers who joined the bench, but were not 3 years, also had to work as grade 2 magistrates. Her Ladyship, Justice Avril Lovely Johnson, was a grade 2 magistrate in Chebi. I appeared before her when I was a lawyer with IRS in Kufuridia. I used to appear before her. So that was, and so, but when lawyers get to 3 years, lawyers who had joined the bench got to 3 years, automatically they became grade 1 magistrates. But with the grade 2 magistrates, the original ones, they never had the chance to go beyond grade 2 magistrate. They couldn't join the bench at any level because they were not lawyers. That was the situation of things until sometime, I think in the 90s, the whole concept of grade 2 magistrate was abolished, leaving only professional magistrates, that's lawyers who were magistrates. But then, around the 2000s, the millennium era, this concept of career magistrate was reintroduced. This time they were not called grade 2 magistrates, but they were called career magistrates. But they were doing the same thing. And this time, the judiciary went one step further. Whilst with the grade 2 magistrates, they were just social welfare persons who had retired or been drafted to become magistrates. With the career magistrates, these were even, they could be even as young as 30 years. But they were the very first ones were actually workers with the judicial service who were drafted to undertake 1 year or 2 year course at the judicial, at the law school. So they took 2-year courses, and then they were made career magistrates. But they are not lawyers. So their career path carries them only to the chief magistrate level. And that was it. It doesn't matter how long you stay there, you can get to a chief magistracy, and then that will be the end. But we still maintained the 3 years for professional magistrates. So what then became the order of the day is that these lawyers, these career magistrates, then opted to go and read law, and once they went to read law, then they could transition to become professional magistrates. But here was the problem. You find somebody who has been a career magistrate for, let's say, 7 years, 8 years, 9 years, 10 years. Now he goes to the law school, he transitions to become, he's a lawyer now. And because he hasn't spent 3 years, he has to remain on the career magistrate level until he becomes 3 years. He gets to 3 years. Even though he might be more experienced than somebody who has left the law school and, been practicing for the past 3 years. So there was a problem. And then again, I know, for example, in the army, if you go through the rank of, let's say, the junior ranks, the furthest you can go is maybe chief warrant officer. But in the army, you have a warrant officer who, because of longevity, maybe even be receiving a salary higher than that of a captain at a senior officer level. But with a career magistrate, it doesn't matter how long you stay as a career magistrate. You cannot run an incremental that will make you overtake a professional magistrate, somebody who has joined just this year. All these were problems but as a number member was saying, only about a month or so ago, we had a send-off party for a couple of our retired career magistrates. And it was when their CVs, their citations were being read, that we realized that we really need them. Because these are the people who are prepared to go to the nooks and crannies of the country. Maybe you are a magician, maybe you have been following the judicial service. But the vacancy at the district court is 116 at the district court. We are not getting lawyers to join at the magistracy, at the district court. Most of them want to come to the circuit court and to the high court. So with the current elevation of some circuit court judges to the high court and the district court to the circuit court, we are going to have an opening for 116. And I can assure you, we are not going to get, no matter how often, how much we advertise, we're not going to get lawyers to come and fill these vacancies. So it is my project that I will be discussing with the Judicial Council, the reintroduction of not only the reintroduction of the career magistrates, but we should be able to have a proper remuneration regime for them, so that those who come can stay. And then, again, it should be possible that there should be a law that makes it possible for somebody who has been a career magistrate for a certain number of years, if he becomes a lawyer, then he doesn't need to wait for another 3 years to become a professional magistrate. There should be a smooth transition. This is a project that I intend to pursue.
Thank you very much. I will then proceed to give the floor to Honorable Muhammad Shaibu. You are entitled to 3 questions. Strictly questions. I can assure you, my lord, that every member of this committee may want to exhaust the 3 questions. So, strictly questions, no comment. And non-members of the committee, I plead with you to perpetually remain silent.
Chairman, let me thank you very much. My lord, congratulations. Chairman has cautioned. But, my lord, cost of litigation by the day has become very expensive. Legal Aid Commission came in as a stopgap. Unfortunately, they lack the resources to represent clients. So today you have in courts unrepresented litigants. Would you consider fashioning out a very simple procedure which can take care of unrepresented litigants? Thank you.
Thank you very much, Honorable Chair. The legal aid is an orphan. The legal aid board is an orphan, like the prison service. Now the prison service, they are getting some parents, but the legal aid remains in the doldrums. It is true that cost of litigation is now very high, and it becomes very, very high, higher as a result of the delays that are occasioned in the courts, so that even small minor offenses in the criminal realm, small claims in the civil realm, still have to follow a long queue. So litigation is now very expensive. And when you look at the persons who patronize the legal aid, you realize that, but for the fact that they don't have the means, they wouldn't go there, because they are very much under-resourced. So it is something that I have discussed since I started acting. For now, we have some courts that have morning shifts and afternoon shifts. At least for now, we have that one. And we have some courts that sit over the weekends. So it is now left to us to, so we can say we have a 16-hour economy. It's now left to, with time, maybe we will get to a 24-hour. I'm certain the President stole his ideas from us.
Thank you very much. Honorable Shaibu, do you have any further question or follow-up on this question?
Thank you, Chairman. A further question, not a follow-up.
That is your question number 2.
My Lord, let's stay within justice delivery.
a very important aspect of how we live. Cases on appeal. I mean, previously, if you're up country, Bolga, Wa, Tamale, you would have to travel to Accra for Court of Appeal cases. I note that there was a system in place that cases were heard in Ho, Kumasi, Tamale, and Cape Coast. This for some time now has not been working, or it has been suspended. Would you consider that Accra is not Ghana, and that many regions still will have to travel to Accra to the Court of Appeal? Would you consider reinstating and possibly expanding that service to all regions of this country? Thank you.
Thank you, Mr. Chairman. I think with all due respect to the questioner, I think the question is not factually correct. Yes, we used to have Court of Appeal sitting in certain regional capitals that are not where we don't have them now. But it is not true that all the other regions have been suspended. No. Now we have a Court of Appeal in Accra, as usual. We have a Court of Appeal in Kumasi, where we have accommodation, so they are residents there. The judges, there are 10 judges of the Court of Appeal who are in Kumasi, residents there, dealing with cases in the Ashanti region, Brunga-Ahafo, and the north. We have 5 dedicated Court of Appeal judges for Eastern and Volta regions. I mean dedicated in the sense that they are assigned to only the Court of cases from Eastern and Volta regions. So the Court of Appeal sits in Koforidua. Then a Court of Appeal sits in Sekondi to take care of Central and Western regions, and then the Western North. So we have at least 4 courts of appeal. That is Accra, Kumasi, Koforidua, and Sekondi. These are the 4 places that we have our cases. But whilst because there's accommodation for the judges in Kumasi, they are resident there. The dedicated 5 for Eastern and Volta are living in Accra, but they go to Koforidua 1 week in a month. 1 week in a month. They will go and sit there 1 week in a month. Then those who are for Sekondi also go to Sekondi and deal with cases 1 week in a month. Now, Tamale and the North don't have resident judges there, but they are also served by the judges in Kumasi. But you see, because of distance and then even costs, any time the 5-member committee, judges, the panels goes to Kumasi, goes to Sekondi, the service spends 38,500 cedis or 40,000 cedis on them in terms of hotel accommodation, transportation, and all other logistics. Koforidua, if the 5-member go, it's the same thing, around 40,000 cedis. But you see, we go going from here to Koforidua is so easy, even though it is risky and inconvenient. It is still short. The Kumasi people found it very difficult to go to Tamale, where they would meet the judges. So they were doing virtual hearing. The virtual hearing was started at the time of COVID, and we realized that it is a very good way of doing things. So Kumasi and the North were communicating only by virtual hearing. And then, but when I started acting, I realized that the virtual hearing was not very convenient because of the interconnectivity. There were breaks in transmission and other things. So I actually spoke to the Judicial Council. We went to see the Minister for Communications, that is Honorable Sam George. And now we have the interconnectivity is so good that even now we don't go to Sekedi again. We do virtual hearing of appeals for Sekedi. So now instead of incurring 40,000 cedis in a month, we do virtual hearing. So it is something that the lawyers are very, very happy about. For now, the judges stay in Accra, and then the parties meet in Koforidua. So even if the lawyers in the case are in Accra, they still have to go to Sekedi to take part in the virtual hearing. Now, what we are aiming at is a situation where we can have persons, for example, Koforidua and Ho. We are trying to get to a situation where lawyers will not go from Koforidua Ho to Koforidua, but they can also have a hearing whilst they are in Ho, so that the judges will be in Accra, the parties could be in some other of the parties could be in Koforidua, another party will be in Ho, or Cape Coast lawyers can sit in Cape Coast and listen in and take part in it. That is a long-term project, but for now, the regional capitals are taken care of by way of virtual hearing.
Any further question?
Yes, Chairman.
Please do.
I see my Lord is getting into virtual stuff. So let's move on to empanelment of judges at the Supreme Court. First of all, what goes into the thinking when you are empaneling judges? And given that the human element of it raises some questions, would you consider looking at an automated system of empaneling judges at the Supreme Court? Thank you.
Yes, my Lord.
Thank you, Honorable Chair. Empaneling creates a lot of anxieties among people. There are lots and lots of people suspicions about for judge shopping, persons who are, some judges are not empaneled and other things. I think to get rid of such suspicions, we should be able to consider AI to do that. I am not very AI, but I know that those who know about AI tells me that if you are able to feed the computer or AI with information about judges, their philosophies and everything, the AI should be able to do empanelment based upon the thing that we have fed it with. But, and I think it is done elsewhere, so we can try it. But what actually goes into the used to go, I wouldn't be able to say for some time now what. But when I joined the bench, Thank you, Honorable Chair. Image of the judicial service has gone down. A lot of people have a lot of problems with the service, particularly with regard to the fact that
chaired by the Member of Parliament for Akachi North, Bernard Ahiafo, had taken a 10-minute break. They're back now, and the questioning continues, even though it is just a one-sided committee, because the MPP MPs have walked out of the committee's sitting. So let's go back to the committee room where Bernard Ahiafo is presiding over the sitting, taking questions from NDC MPs.
By a long period. All these affects people's confidence and trust in the service. But as I said earlier, some of them can be tackled because they are institutional problems. Like, we have vacancies for as many as 116 magistrates. We need to fill 116 courts. We don't have personnel. There are some courts that do not have infrastructure. I mean, you go to the courts and then the buildings are in very serious states of dilapidation. I remember last year, the District Assembly, over the past 3 years, the District Assembly Common Fund sponsored the building of about 100 courts, together with their residences. But it's still not enough. We still have some of these courts built but not occupied because we don't have the personnel. But that is not to also mean that we should throw our hands in despair and say that we can't do anything about it. Admittedly, there are some cases that do not move fast as a result of, as I said earlier, the technicalities associated with our rules and other things. But we also recognize the fact that there are some judges and magistrates who do not put up their best. all these add to the creation of backlogs. And I also mentioned earlier that people are now too eager to go to court. And so we want to, as we want to build courts to take care of the more cases that are coming up, that we also want to encourage ADR. I was at the ADR week in Koforidua, and the reports that they gave us that of about 600 cases that came, about 470 or about 480 they were able to solve them through ADR. And so we realized that but it is still not, people still do not know so much about the ADR. So if people are sensitized enough about ADR, they will embrace it and then leave the courts for more serious matters. The way it is that there are some people who, no matter what, who want to go to the regular courts. They want to have their pound of flesh. But so it's a combination of a lot of things that lead to this backlog of cases. And that is what people's confidence or trust in the judiciary going down is more as a result of the fact that their cases are not heard early. There are some people who also have lost confidence in the judiciary because they say that judiciary is corrupt. How they come by that decision, that statement that judiciary is corrupt, I have made mention of the fact that the judiciary is as corrupt as the people who man it, and the people who man it are as corrupt as the ordinary Ghanaian. The ordinary Ghanaian goes to the bank and he is told that give your money to the teller, otherwise you may have your money stolen. He goes, and instead of being in a queue for just 2 minutes, he sees somebody sitting down there, or somebody recognizes him and says, "Oh, I'm a teller." And then he takes his money to go and deposit for him. Before he's aware, the man has stolen his money. The ordinary Ghanaian goes to the courts, and I tell you, if 100 people evince the intention that they are going to see a judge because they have a case in the court, less than 3 of them will be able to go to the judge personally. They will go through his girlfriend, they will go through his wife, they will go through his friend, they will go through all kinds of people. So anybody who they think is close to the judge is game. You go and give your money to a court clerk or anybody. There are some people actually loitering around the courts who the court clerks, they know them. We have people we call bail contractors. All kinds of people patrol the courts. So you want to see why you want to see a judge because you have a case there, only you know. And then you cannot go and see the judge because you are afraid. Then somebody tells you, "Oh, that I saw the judge talking to that lady. So it is his sister, it is his daughter, it is his girlfriend. So go and see her." So people give their monies to people, and then they don't even, once they have given the money out, they have bribed the judge. They have given, I mean, they are okay. So such people go about saying that, oh, the judges have taken their money. And once the judge has taken their money and they get their judgment, they are okay. But the judge has taken their money, they lose their case, and then that's when they start talking. So that is not to say that there are no bad notes among us. There are. But these are the reasons why people's confidence in the judiciary is sinking. And I intend to, once we know the causes of the decline in then we can tackle it. So if we sensitize people about ADR, that there's not every case that should go to court, mainstream court, and we sensitize people about ADR, people will go there. The backlog will reduce. If we review the rules, as I suggested earlier, it will affect even the trajectory and the speed at which cases are heard, and it will improve. And if, as I said, since there are still some bad notes, if we catch the bad notes and they are disciplined, then it will serve as a deterrent to people, to other judges. So we are going to, as it were, reinforce the disciplinary measures. The Judicial Council is going to take up this up because we already have a complaints unit, but people don't even complain there any longer because sometimes they feel that they have complained and they don't get good responses. I'm going to reignite the whole thing, reinforce it, so that, because we should get, the judiciary should be able to get the confidence of the people back. Otherwise, we might end up having people say that, well, I'm not going to court, I'm going to do what we call mob injustice. Thank you.
Any further question?
Thank you. Having listened to you, I want to find out, will you reinstate the electronic case assignment, which was introduced to keep judge shopping and later discontinued by your predecessor?
I think I am all for it. I am all for it. It is going to be reintroduced. I think in about 2 or 3 years, for about 2 or 3 years now, we have a situation where applications that are filed do not have return dates. You go there, they say date to be fixed. Immediately so we found there were situations where a case comes before us, an application, even before the Supreme Court, an application comes before the Supreme Court, and we realize it is virtually moot, because the application, which was actually time-bound, had date to be fixed on it, and it has been fixed for the past 2 years. So immediately I came, I said that one was wrong. So every case that is filed, every application that is filed, should be brought to my attention so that we fix, because most applications are time-bound. And so I did that for some time. And now things have stabilized. So we don't have dates to be fixed again. We now have dates given to applications that are fixed for hearing. So with substantive cases, we are going to reintroduce actually the It used to be there until the machines broke down, the system went off, and then it was allowed to fall into abeyance. Now we have actually started doing the electronic.
Thank you very much, Honorable Umar. Do you want to ask your last question? Yes, please do.
Thank you, Chairman. My Lord, there are persistent concerns out there that the current process of appointing judges and chief justices give excessive influence to the executives. What reforms, if any, would you recommend to make the appointment process more transparent?
Thank you, Honorable Chair. I think I'm the wrongest person to ask this question because, as I said, I have had my elevations across political divides. But I think the current system, for us, it follows the Constitution. If the Constitution is going to be amended to give us a different mode of appointment, then that's it. But the current system with Superior Court judges up to Court of Appeal, they are appointed by the Judicial Council, by the President, in consultation with the Council of State on the advice of the Judicial Council. And the Judicial Council is made up of persons, apart from 4 nominees of the presidency. We have the JUSAG represented, we have the lower bench represented, we have a High Court representative, Court of Appeal representative, a Supreme Court representative. We have institutional representatives like representation from, let's say, the police, the army. These are all members who come from different backgrounds, and they have contributions to make. And they advise the nomination or the nomination appointment of members of the court up to the Court of Appeal. So, and when it comes to even selection of nominees for the president to appoint, we have persons who are mentioned by the Attorney General, who is a government person. But then we have the Chief Justice also bringing nominees. And then we have the Ghana Bar Association also bringing nominees. So what happens is that there is a list produced by these 3 groups. The Chief Justice normally bases his or her nominations on seniority at the bench, performance, and other things. Maybe if a person has disparate proceedings against him, that's a different matter. Then the Attorney General also nominates, and then the Bar Association have the chance to nominate persons from the bar and also from the bench. The idea is that the bench, our performance is also always reviewed by the lawyers, by the bar. So we have a situation where when these 3 lists are produced, you find a particular, let's say we want an appointment to the High Court. You will find a particular circuit court judge whose name appears in the list of the Chief Justice, in the list of the bar and in the list of the Attorney General, because the bar is the beneficiary of the efforts of the judges. So the judges make recommendations. In the same way, when lawyers appear before us, we know those who are good and those who are bad. And we also know those who have the temperament and the demeanor and everything that can make them judges. It's not every good lawyer who can be a judge. So sometimes we on our own. I have mentored so many lawyers, and I'll tell you, I can tell you that you will be a good material, so apply to join the bench. So even though the Chief Justice normally nominates from the people from the bench, the Chief Justice could also nominate somebody from the bar. So when these nominations are done, it go to the presidency, and then even though the wording is that it is done on the advice of the Judicial Council, and the Supreme Court has said that the Judicial Council's advice doesn't bind the president. Nevertheless, I have been a member of the Judicial Council, and currently I am its chair, acting chair. If 40 people go through our net at the Judicial Council, less than one or a maximum of 2 may not be taken by the presidency. So the advice, we say it doesn't bind them, but in reality they listen to us because the president knows that it is the Chief Justice and the Attorney General who deal with these people. So if they make this advice. And so with this kind of nomination from these 3 people, how people can talk about political, I can't really understand. With the Chief Justice, over the years, this is how it has been done. It is I think, well, I know in Kenya, things are done differently. The Judicial Council or Judicial Commission is very empowered. But whatever it is, the president has a say. And at least that is what our Constitution says. If Ghanaians believe that the Constitution should be changed to give power to other persons, other bodies to nominate their Chief Justice or the President, Supreme Court judges, then they can lobby the Parliament for honorable members to have a look at it.
Thank you. Honorable members, on this note, we will then proceed to take questions from members of the subject matter committee in line with Order 217. Honorable members, subject matter committee members can ask 3 questions, but they are only entitled to 2 supplementary, if any. So, Honorable Bede Asidin, you have the floor. The name is Bede Asidin.
Thank you very much, Mr. Chair. I was going to correct it because you are putting the wrong name to go into the Hansard, and I object to that. Anyway, thank you very much for the opportunity. My Lord, congratulations for this nomination.
Thank you.
And I think that you deserve this nomination. You have served this country for such a long time, and I believe that what is happening today is the icing of the cake. And
thank you very much.
We will proceed to ensure that you enjoy this cake. Let me also use the opportunity to thank you for the guidance that you provided me whilst I was in practice. I appeared before you a couple of times, and I think that I was impressed with the way and manner you guided me throughout. I didn't stay there for long and came out to my political field. But I appreciate what I got. Thank you very much, my Lord. My Lord, I have a few questions, and I will send you back to the issue of the appointment of judges to the bench. And as you have already stated, this has been provided for under Article 44 of the Constitution. And that provision gives the President the power to nominate and appoint justices of the High Court, Court of Appeal, Supreme Court. Yes, there are certain processes that go through, but ultimately, it is the President that we see. That's what the Constitution has provided for. He does the nomination and he does the appointment as part of all that. We have tried to explain that even though...
Honorable, you are violating our rules. Please ask question.
I'm asking the question. I'm laying the My mic is... My Lord, I want to find out from you, do you agree with the current arrangement in terms of the appointment of judges to the High Court, Court of Appeal, the Supreme Court, the current arrangement as provided under the Constitution? Or do you think that we can have some other arrangement? And if we can have some other arrangement, what type of arrangement should it be? Thank you, my Lord.
I do. You asked me whether I think the current arrangement is okay or it should be adjusted. I think that the current arrangement in football, we say if it isn't broken, you fix it only when it's broken. The current arrangement has served us well from 1992 till now. It's not broken. You shouldn't fix it. I believe that the current arrangement, you see, the Constitution, as we have always said, must be read in such a way. You should read every phrase and every sentence, every word in the Constitution. And then, if you look at the practice, as I said, you as you rightly said, the nomination and appointment and everything is done by the President. But I have told you what goes on in reality. And in reality, the Judicial Council plays a very crucial role. We advise, the Attorney General has a role to play, the Bar Association has a role to play. And so you may not have this laid down in the Constitution, but in practice, this is what goes on. And that's why I'm saying that, as far as I'm concerned, I'm comfortable with the current arrangement of appointing judges. And that is how I see it.
Thank you. Before allowing you to proceed with your second question, I want to remind all of us about Standing Order 88.7, and I read, a member in asking a question shall not address the House, raise any argument, or offer an opinion. So let's keep to these rules, and then we can make progress. Now, your second question, if any.
Mr. Chairman, I have a supplementary question.
Yes.
My Lord, my supplementary question is that, having heard you, and you are convinced about your position, how do we remove the suspicion or allegation that some presidents try to pack the course? How do we remove that one? Even though people go through all these processes, and yet the allegation is that
you are violating the rules that I've just read. So please, my Lord, your answer to the supplementary question.
People suspect that in the first place, what is packing the courts? Are we talking about the number of persons appointed to the court or what? Yes. I don't know how people's suspicions can be dealt with, but as far as I'm concerned, as I said, persons have been promoted on the advice of the Judicial Council. If 40 people, names of the current lists, on the advice of the Judicial Council, 41 persons' names were sent to the presidency. And only 4 out of the 41 names were taken out. And even only on the grounds that they had not finished with the background check, as at the time they were because I was sitting on I was pleading with the president that we needed to have these people sworn in so that the legal year could begin with the courts full. But the president, they had not finished with the national security clearance for all of them. In the long run, out of 41, recommended by the Judicial Council, made up of members of the bar, members of the judiciary, members of the Attorney General's representative. These 37 out of the 41 names were sent to the presidency, and only 4 were not taken. If anybody sits outside and says that the president has packed the court, how will I be able to convince such a person that it's not the president actually who put the 37 people there? We did. He only took our advice. So it is not as if people's suspicions are going about that. You cannot go about trying to assuage people. You can't do that. People will still have their suspicions. One of the questions that I got was, people are saying I got my nomination as a result of 2013. I have explained my way. If people still have that feeling, can I do anything about it?
Thank you very much. Yes, any further questions?
Yes, Mr. Chairman. My second question, my Lord, you have dealt with it partly, but I'm bringing you another angle. Under Article 154 of the Constitution, 1541, if we approve you, which we are going to do, you will become the chairman, because I'll vote for it. You become the chairman of the Judicial Council. And under Article 154, you are enjoined as a council.
What is your question?
I'm bringing the question, Mr. Chairman.
Please ask question. I've just read the rules to you. You can address us.
Very well. Simply, what reforms are you going to bring to the table outside the reforms that you have already mentioned? Because you have already indicated some reforms that you are going to do. What other specific reforms are you going to bring to the table in terms of accountability, professionalism, etc., etc.? Thank you.
The Judicial Service mandate is to adjudicate cases and then ensure that the laws, the Supreme Court will interpret the laws, and all these come as a result of adjudication. As I said earlier, and we all agree that one of the problems that we are having now, the crisis, is as a result of people losing confidence in the judiciary. And we have traced it to certain happenings, like, as I said, we mentioned the complexities of the rules. We talk about backlog of cases and all that. One of the things that that is there, but it is not really nationwide, is the e-justice system. The e-justice has been introduced. It's been going on for some time now, but it looks like the e-justice, which is supposed to help us in so many ways, is only within Accra. And also, even within Accra, it is within the law court complex. It is my hope and ambition that we will have a rollout of the e-justice to all the regional capitals by the time that my term is out, by the end of next year, all the regional capitals. The aim is to get e-filing, e-justice to all courts in the country. But that is a long-term thing. My aim is to have the e-justice rolled out in all the regional capitals. And that will be something that will help. And then we always talk about justice in terms of cases that come to the court. We don't talk about justice in relation to even the workers. It is very, very, very important to recognize that apart from the judges, the judicial system is not made up of only superior court judges. Superior court judges, by virtue of Article 71, have their salaries decided by the presidency through the committee and then Parliament. Whilst the lower bench have their salaries tied to normal civil servants. And worst of all, the JUSAC, who actually form the bulk of the judicial service. As a matter of fact, if you look at our numbers, the judiciary made up from magistrates to the Chief Justice, we are just about 511. Only 511. Out of that number, those who form the higher echelons, who enjoy Article 70, Article 71, are the High Court of Appeal and the Supreme Court. We are not known more than 230 or something like that. So if you talk about our salaries in terms of Article 71, you are talking about only a fraction of members of the judicial service. So we also have to think about reforms that should affect the lower bench in terms of salary, in terms of working conditions. Because whilst we struggle, whilst we strive to get accommodation for judges of the Court of Appeal and the Supreme Court, even some of the High Court judges, even in some regions, regional capitals, they don't have accommodation. As for the magistrates and the circuit courts, the least said about them, the better. Because you go to some places and they are renting the most beautiful house. And if before you are aware, that most beautiful house belongs to a perennial litigant, perpetual litigant. Somebody is almost always in your court. So you find it impossible to even work. You understand? So we should also be thinking about, whilst we are thinking about clearing the backlog, doing that, we should be thinking also about the staff. And that is what I mean to do. I want to have a proper discussion of the terms and conditions of the terms of engagement of the lower bench and the staff. That is something that I will make my personal project.
Thank you very much. Yes. Any more questions?
Chairman, that will be all for now. Thank you very much.
Well, thank you. You said that will be all for now. I believe you won't have the opportunity to ask questions again. We are now moving to the leadership. And I'll plead with the leadership that the 3 questions rule would apply to us as well. So, Honorable Majority Leader Mama Yariga, you have the floor.
Thank you very much. Let me also congratulate the nominee, Acting Chief Justice, for his nomination to occupy the position substantively. I'm sure you sat through and you listened to the engagements between myself and the minority side. I had no intention of preventing anyone from freely expressing themselves. I just wanted them to do so in accordance with our rules, so that there can be sanity in the way that we conduct business. I think the gravamen of their case, which I would have preferred that they sat here and asked you, because I know you are very capable of providing them with a response, is that they question whether it is proper for you to be taken through the vetting process, because there are a number of suits pending challenging the removal of the previous Chief Justice. They're asking what the implications for stability in the judiciary will be, assuming that those challenging the propriety of the removal of the previous Chief Justice succeed in their claim. What will be the nature of the enforcement of the reliefs that they are seeking, and etc. So basically, the question is do you think that it is proper for us to go through this process whilst these suits are pending?
Thank you, Honorable Chair. I think, yes, it is proper. That is the first basic answer. It is very proper. It is a constitutional duty that Parliament is performing. And as at now, there is no order from any court of competent jurisdiction stopping you from performing your constitutional duty. The President has nominated somebody for Parliament to vet the person for the appointment to the position of a Chief Justice. Vetting of the nominee is a constitutional duty imposed by you by the Constitution. It's a duty imposed on you by the Constitution. So if you have to perform it, nothing, and I think absolutely nothing, stops you from performing your constitutional duty. You see, in the years gone by, when cases like Baffoe versus the Bank of Ghana, which I authored, actually, were written, the learning was that, and the practice actually was that when an application for injunction or when there's an application for injunction is pending, then you hold your hands. So there were situations where persons will rush to court to file a writ or file an application for injunction, and if you go against, even without any order from the court, you went ahead to do what the injunction was being sought for, then you'll be cited for contempt. And cases like Baffoe versus Bank of Ghana, Cito and other things came up and said that that was right. That was it. But the learning now, particularly after the case of Vincent Assefuwa versus the Attorney General, I mean, it's an unreported case. It was done fairly recently. The learning now is that if there is a constitutional duty to be performed, until and unless there is an order from a court of competent jurisdiction, no constitutional body is prevented from performing such a duty just because somebody has filed an application for injunction or even a writ. Even the application for injunction may be handled, may be understood, but a writ, when we do not even know when the writ is going to be heard and determined, you can't do that. As a matter of fact, that is constitutional. But let us even look at an analogy. When President Kufuor was declared, President Mahama was declared, and it was sworn in on the 7th of January 2013, it never prevented His Excellency Nana Kufuor from pursuing the petition. He did. It also didn't prevent the president from performing his constitutional duty as a president. He did. These two things went side by side until the 29th of August, when the court said the matter was ended in favor of the sitting president, so he should continue. And he did continue. If the courts had come to the conclusion that it was the judgment should go the other way, and that the president should step down for Nana Addo Dankwa to take the seat. That would have been the order of the Supreme Court, and would have been enforced by Article 1 and 1(2). The same thing would have happened in 2020 when there was this petition. So a constitutional duty that is supposed to be performed, as a matter of fact, some persons are even of the view that even the Supreme Court cannot even come to the Parliament and then make an order to stop a constitutional duty being performed. But that is another matter altogether. But for as long as no order has been made by any court, a constitutional duty will have to can be performed. And I think it is right that we are going ahead with the vetting.
So in essence, there's no court order restraining the president from nominating a Chief Justice, there's no court order restraining Parliament from processing the nomination of the president.
There's no court order.
And you are here because we have summoned you to come for us to process you.
Which I couldn't refuse to.
Of course, you cannot refuse our summons. You cannot refuse our summons. But the second issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases to be heard. Is that accurate? And why would that be the case?
If this statement is made by, with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here.
If this statement is made by a person who is not a lawyer, I will put it down to ignorance. I will say that maybe the person is uninformed about legalities, so I will pardon. But if a lawyer makes a statement like this, I would think that it is populist and maybe downright mischievous. The Chief Justice does not list cases, and please, my words, the Chief Justice does not list cases for hearing. The Chief Justice empanel judges to sit on cases that have been listed. Cases are listed when they are ripe for hearing. So we have listing, we have cases getting ripe for hearing, and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed. Pleadings get closed with it. Pleadings are issuance of a writ, a response, and then even sometimes we ask you to file memorandum of issues, particularly constitutional cases. So these three things are done, and when they are done, we say the case is ripe for hearing. Then the registrar will list the case, list all the cases that are ripe for hearing, and the Chief Justice will then empanel judges to sit on them. So if it has not been brought to the attention of the Chief Justice that these cases are ripe for hearing, or they are listed, the Chief Justice does not empanel. Now, when a plaintiff issues a writ, and then he is waiting for the defendant to file a response, a defense, there is a time limit within which the response has to be filed, the defense has to be filed. The plaintiff knows this. So if within that period, the defendant doesn't file a defense, he has every right to move the court for certain reliefs. But before he can do that, he goes to the registry to make a search to find out whether a defense has been filed. If he finds the defense has not been filed, then he can go ahead and then move a motion for judgment in default or whatever. But that is what a diligent plaintiff does. So if a plaintiff issues his writ and then he's told that it has been served, and so the defendant is supposed to file his defense within this period, then he goes to sleep, waiting for the defendant to file, and he doesn't file, and then the defendant now comes with application for extension of time within which to file defense and all that. The defendant, the plaintiff, who at this point in time may be described as being indolent, cannot be heard to say that the Chief Justice is not empaneled. The Chief Justice doesn't, seriously, but for the social media phenomena in the social media where lawyers put writs in the social media, the Chief Justice may not know of any case, we may not know that any case has been filed until it is listed and he empanels. So he may not even know that somebody has filed a writ, somebody has filed a defense, or somebody has filed anything. But these days, because of social media, some lawyers, even before they file the writ, they put it in the social media. That is what, but that is not official. A Chief Justice cannot start empaneling, assuming it came into the papers tomorrow, that these cases have been, they are ripe for hearing. The Chief Justice cannot, on that strength, empanel judges. The Chief Justice doesn't deal with the social media that way. So if any lawyer, worth his salt, makes a statement to the effect that the Chief Justice is not empaneling persons to sit on a case because of something he stands to gain, it is rather mischievous. Then it is tagged with, the statement was that the Chief Justice was in a hurry to empanel persons to sit on the application for injunction. When you file an application for injunction, you are given a date. The return date is there. So it is ripe. When you file an application for injunction today and they fix it for, let's say, a week's time, what the registrar is saying is that the respondent will be served immediately and then he has to respond, all within that time. So when the Chief Justice gets the application, he starts empaneling based upon the return date. So it's not as if the Chief Justice is in a hurry to empanel for applications, but wasting time or refusing to empanel for substantive rates. The substantive rate is not ripe for hearing. It hasn't been brought back to attention, and I cannot empanel judges for that purpose.
Thank you very much. I think that I'll convey this teaching in procedure to the minority. I'm actually asking the questions on their behalf, just so that they see that we're not running away from anything and we're not afraid of anything. I mean, and that was what I kept telling him, that the same issues that you want to do press conference and not give the person the opportunity to respond. Sit here and ask the person, and he will give you answers, because I'm sure he's capable of giving you answers. And so I've asked all the questions, the critical questions that was the substance of their statement. And clearly, if they were sitting here, they would have seen that they really have no basis. And, you know, at most, clearly a populist gimmick. My Lord, you were involved in this case of Adomako Anani versus Nana Owusu Agyeman. I think you, Justice Wood, then presiding CJ, Ansa, Yeboah, and then Akamba. What is interesting is what Justice Wood said, then CJ, that the often quoted legal maxim, justice delayed is justice denied, coined by the British politician William Gladstone, is no mere cliche. The right to fair trial is in a timely manner is neither a courtesy nor a favor, but a fundamental right. Protracted delays in the administration of justice impact negatively not only on those who assess the courts, such as the victims of crime, accused persons who are acquitted at the end of their trial, parties in civil proceedings and their privies, lawyers who practice before the courts, but indeed the entire justice system. The judicial history of this relatively simple family-related land matter, which was commenced in the High Court, Kumasi, as far back as the 4th of April 1974. 1974 provides an insight into the harmful effects of systemic delays in the administration of justice. Regrettably, it has taken 40 long years, a whole generation, for this case to finally find its way into this court, the court of last appeal. We hope court business shall always be managed in ways that will not occasion a repeat of this parody of justice. So this is a case that lasted 40 years. It was a simple family land matter. And you are part of the case. Today we are still talking about delays in the administration of justice. In this age of AI, have you considered how to use technology to quicken the pace of the administration of justice and the resolution of cases?
Thank you, Honorable Chair. I have forgotten the facts in this case, but I mean, you are not even asking me about the facts of the case, actually. But were there any dissents?
There was no dissent. It was a unanimous, I think, decision of the court.
Yes, I mean...
The court was happy that they had finally resolved the matter. It was basically a land matter, but what really happened was that the judges at the High Court kept changing.
Yes.
And so the issues were whether or not, in the light of the changes in the judges, whether the proceedings of the previous judge should just be adopted or whether or not the case should start afresh. And the judges just kept being changed until finally the matter went to Court of Appeal. And so it just lasted 40 years. That's the most important thing, that this case lasted 40 years.
I get Honorable Chair. I think this is not an isolated case. I mean, it is far. I mean, I can't talk about 40 years, but what honorable member means is that it lasted for so long. Yes, I remember I had been cases like that, and I remember there was a time the honorable Chief Justice.
So basically, my lord, let me just go straight. The question is what are the mechanisms you think? You've said a lot today about how to deal with, ensure speedy trial and etc. But there are structural issues. We have about 5 layers or 4 layers in most cases when cases start from the lower courts, go to High Court, then to Court of Appeal, to the Supreme Court. That's about 5 layers, okay? Now, can we just reduce the layers? Because the layers mounting up to 5 do not automatically guarantee quality outcome.
Yes, I mean, Honorable Chair, I agree with you, but it all boils down to the rules. It all boils down to the rules. The Constitution gives a person a right of appeal all the way to the Supreme Court.
So can we change the rules and say we are giving you just 3,
Yes.
Attempts to get justice,
yes.
and if at the 3rd attempt you are not satisfied, you just have to live with that, and rather work on the quality of the courts, so that by the time you do 3, anybody looking at the outcome at the 3rd layer can confidently say that what you've really gotten is justice, so you can't waste our time and resources. Yes. Can't we just cut down the number of layers?
That with all due respect, that will be the role of it will be your mandate.
Yes, so because some of those provisions are entrenched in the Constitution. So these are issues that I've raised with the current committee that is working on the Constitution review that I think that we should cut down on. And then also, can we say that the Court of Appeal should be the highest appellate body, whilst we have the Supreme Court actually serve as a constitutional court?
Absolutely.
Because there's too much caseload at the Supreme Court level,
Absolutely.
Which has necessitated the appointment of so many Supreme Court judges. Because I'm even advocating for a panel to sit in Bolgatanga near Boku, so that I don't have to travel far to have access to justice at the Supreme Court level. Can we just transform our Supreme Court into a constitutional court like the US, like South Africa has? What's your thinking? In view of the discussions going on about amending and reviewing our Constitution.
Honorable Chair, this is a very interesting trajectory that this question is taking. In answering your question, we'll have to sway into why the Supreme Court, whether the Supreme Court even needs that number of judges. And it has been said in several fora that I have been, that whether we have a Supreme Court of 10, like 9, like America, or we can go to the minimum of 1 plus 9, that is 10, as our Constitution provides, and not go up, is dependent upon the jurisdiction of the court, the Supreme Court. As you rightly said, in South Africa, they have a Supreme Court and they have a constitutional court. In America, all the states have their Supreme Courts where civil cases or whatever, can go all the way to their Supreme Courts. But when you come to the Federal Supreme Court, it is for constitutional cases alone. Now, in Ghana, we have 7 different kinds of jurisdictions. Each one is as heavy, carries as heavy load as possible. We have supervisory jurisdiction, we have appellate jurisdiction, we have original jurisdiction, we have jurisdiction to deal, review jurisdiction, we have appellate jurisdiction as far as the chief justice matter is concerned, and we have jurisdiction to deal with presidential, and then we have supervisory jurisdiction. So we see at every point in time, and the Supreme Court is made up of very old men like us. So you see, even one of the very first things that every Supreme Court judge, one of the very first things that you say when you get to the Supreme Court is, hey, I thought I was coming to the Supreme Court to relax, not knowing that this place is even busier than the Court of Appeal. It is a statement made by everybody who has passed through the Court of Appeal. The Supreme Court is so inundated because we deal with cases, as you are aware, there is a criminal case, Ali Kasina, started in my village at Goso, and it ended up at the Supreme Court. We have cases, civil cases involving land, and it starts from the Circuit Court to the Court of Appeal to the Supreme Court. We have Magistrate Court cases from the magistracy traveling all the way to Supreme Court, and we sit on them. So this is where the problem arises. There is no way you can have, if you decide to stick to the 10 persons, you have only a panel of 2 panels, and only 1 panel when it comes to constitutional cases. So you can't deal with all these cases. And believe you me, because of the rights attached to, have been granted by the Constitution, that a person has a right to go all the way to the Supreme Court, people are prepared to, and now, see, now it's even easier. The Court of Appeals are all over. In the years gone by, people will think twice if they have to come to Accra to do appeal cases. Now the appeal courts are right in their region. So they will file their cases there. Then if you are doing a case, the slightest thing that anybody does, interlocutory appeals, you are going to the Court of Appeal. So when it comes to personnel, it is difficult to, as it were, say that numbers should be reduced when it comes to the Supreme Court. Now, your case, the case that you have mentioned, if you look at it properly, if you read it, you realize that it spent, if it was 40 years, it took 40 years for it to be finally addressed. You find that about 35 of that number of years happened in the lower trial court. When the cases that come to the Supreme Court, appeals don't take up to 1.5 years or 2 years. The Court of Appeal, they say it. The simple reason being that by the time it comes to the Court of Appeal, by the time it comes to the Supreme Court, then we already have the bulk of the record of proceedings prepared. And then at the Court of Appeal, it is written submissions, just the written submissions of parties, and then the ruling. That is added for it to go to the Supreme Court. So preparing the record of proceedings doesn't take so long. But at the trial court, one, because of the number of changes in terms of judges, and then in the years gone by, parties had the right to object, to say that no, in the years gone by, both parties and the lawyers had to agree for the proceedings to be adopted. If one of them says, no, I don't want the proceedings to be adopted, then it has to be started de novo. And then even where, funnily, even where proceedings were supposed to be adopted, you'll find that the judge might have retired, and there are some judges whose handwriting only they could decipher. I mean, some judges were writing like this, like that. So you find that they cannot, nobody can even read their handwriting to be able to type it. So in the long run, they have to start de novo. And so if a case goes through 4 judges, you know, that one alone is enough. But as I said earlier, there must be a way of tracking cases so that cases that kept so long on the way should be fished out. In the time of Justice George Wood, I remember she caused some judges, some cases to be selected. There were about 20 cases selected, and he selected some judges. I got 3 of the cases. And these were cases that had been on our books for so long. Like this. You see, when the cases were given to me, in one particular instance, a file as big as this, it was scary. But I tried to take my time. I had been assigned by the Chief Justice. I tried to take my time to, as it were, arrange the processes to filed. By the time I got to the end, the file was as thin as this. This file, which was as big as this, carried more than 100 hearing notices. More than 100 hearing notices, all piled together like that. So by the time I selected the statement, the writ, the statement of claim, the defense, and then what did they call it at the time? Application for directions. We had a very thin file to go on. Then, one of the things that also lead to delays is the lawyers. When I was in practice as a junior, if there is a case that is going on appeal, and it is time for you to settle records, your senior sends a junior to go and tell the registrar the things that should be included. But now, lawyers don't go there. They set their clerks who go and tell the registrars everything. So everything should go into the record of proceedings, the compilation. Somebody has filed a writ at the High Court. In the course of the trial, he has filed an application for injunction, to which he attached so many copies of other documents. And then there was a response. They heard the matter. There was a ruling. That was an interlocutory injunction. The case has ended. It is going on appeal. If you are prepared the record of proceedings, do you need to include the application for injunction and all its documents? But all these things will be included, making a very bulky record of proceedings. And it is the clients who pay, for the parties who pay for the record of proceedings. And each record of proceedings, each page is sold at a price. So you find somebody's record of proceedings, about 7 volumes. You decide to go through it, and you can actually reduce it to about 3 volumes. Particularly in this day and age where we file witness statements. So all these things add to the delay, transmission of records, and all that. But I must admit, 40 years is over the top. And if AI can help us trace this, we have to, whatever we do to get AI to do it, we should do it.
Thank you very much. I want to congratulate you once again for your nomination and to indicate that your responses have been very illuminating. Thank you.
Thank you very much.
Thank you, Honorable Leader. It's now the turn of my Vice Chairman, Honorable George Kweku Rickett-Hagan. You have the floor.
Thank you very much.
More than 3 questions.
Thank you very much, Mr. Chairman. My questions are actually 2, just a view. My Lordship, Paul Baffoe-Bonnie, congratulations.
Thank you very much.
Looking through your CV, I have no doubt in my mind, looking at your background, knowledge, and experience, I have no doubt in my mind, and I believe many Ghanaians, that you are the right person for the job at this time.
Thank you very much.
Now, just as I said, just a view, actually, that I want. Do you take the view that as a country, Ghana, we are churning out too many lawyers in terms of people going to law school? And if that is your view as well, because it's a view of, a school of thought, if that is your view, would you support downsizing the intake to the law school as well as those who go through the bar? Thank you.
Thank you, Mr. Chairman. Honorable Chair. I think I don't agree. I don't share that view that we are churning out too many lawyers. Actually, the word churn gives the impression that we are not training. We are doing substandard work by that the products are substandard, but that is not the case. We are also not overproducing. Actually, you see, if you go into history, throughout the whole period that we have had lawyers in Ghana, lawyers that the law school has produced, and the lawyers who have come from outside, all put together, from 18th century, Mensa Saba and all that, we're not up to 15,000. 15,000. And that is from 18th century. Out of this, a lot of them have died. A lot of them have migrated. So currently, the people in Ghana who are lawyers, despite the numbers that you see being called to the bar last year and 2 years ago, the numbers are not up to 7,000. The number of lawyers in Ghana are not up to 7,000. And out of this 7,000, less than 5,000 are in private practice. Less than 5,000 are in private practice. And what I mean by private practice is, for example, those who are on the bench are also part of it. Attorney generals, and then the practitioners. That doesn't include those who are in the banks, Bank of Ghana and other places. All those are people who are not even in practice. So you see, if you take the number 5,000 as lawyers in Ghana, and you measure it against the population of Ghana, you have a ratio of 1 to 7,000 citizens. 1 lawyer to 7,000 citizens. Nigeria, they have, I think, 1,500 or 2,500. The UN sustainable is that it should be 1 person to 250. So you see, we are way beyond. We are way above what should be the right thing. And we also have situations, the law is such that the District Assembly law, the Local Government Act, expects every local government to have a legal department. and when they say a legal department, not just a lawyer, a legal department. If a legal department, then they should at least have more than one person. Every local assembly, House of Chiefs, all the houses of chiefs. So we have lawyers. We actually need more lawyers. If you are deceived by the number of lawyers you see in the law court complex or plying their trade in Accra, you may be deceived into thinking that there are many. But go to Kumasi. Kumasi has a population as big as Accra, slightly lower than Accra. Or Ashanti region is maybe even bigger than Greater Accra. But the number of lawyers operating in Kumasi, from Kumasi, are 305. Kofori, they are 110. Secondly, and my honorable will tell you the number of lawyers who are in Tamale, Bolga, and Wa. You see, we don't have enough lawyers. So even the ones, the number that we have a maldistribution, geographical maldistribution. So if you see lawyers, and there are so many of the lawyers that came out, who were called to the bar, the people who were called to the bar very recently, there were about 800 of them. I can assure you about 200 of them may never ever step in the courtroom. They just, the headmaster of my school, the best secondary school in Ghana, is a lawyer. And he's been a lawyer for the past 6 years. I asked him why he went to read law. He says, when he retires, which will be doing at the end of November, then when he retires, then he will pick his law, he'll go and do galamsey. No, not the galamsey. The lawyers understand legal galamsey.
Are you talking about galamsey in law?
In law, yes.
Very well.
So you see, and then of the 5,000 lawyers that we have in Accra, so many of them have run to Parliament House. They are politicians now. They don't even come to court. So my honorable chair, they are not many. As a matter of fact, I believe that we need to expand. We need to expand the admission so that, because now a lot more people are doing the LLB and they are not getting the chance to go to the law school. So there is even, there has been discussion with the current Attorney General, and then we are thinking about a situation where I think there's a government policy in the offing that is aiming at farming the law school program to various faculties so that we get rid of the admission, the entrance examination, and then we find ourselves, everybody who has done LLB can go and do the law. At the end of the day, there will be an examination, and then people will pass out. People will come out as lawyers. So to answer your question, I don't think that there are many lawyers in Ghana. We actually need more lawyers.
Thank you very much. Any further questions?
Yes, Mr. Chairman. Thank you for the enlightenment, my Lord. My second one is also a view. And now let's turn to the Supreme Court itself. Ghana's population is about 34.5 million. Let's say America's population is 10 times that size. We have 19 judges of the Supreme Court here in Ghana to a 34.5 million people. We have 9 to America's 345 million. Isn't that we have too many judges in the Supreme Court? What is your view on that? Thank you.
I thought I had answered this question. I thought I had answered this question.
Honourable members, order.
I thought I had answered this question, but Honourable Chair, I have to repeat what I said. America doesn't have 9 Supreme Court judges. It's the federal state of America that has 9 Supreme Court judges. America has about 351 Supreme Court judges all over the 51 states. You see, and the American Supreme Court, that's the federal Supreme Court that you are talking about as having 9, has only one jurisdiction, and that is interpretation of the Supreme Court, the Constitution of America, of the U.S. That is, they are what we call a constitutional court. But Ghana, our Supreme Court has, as I've said, appellate jurisdiction. The case, the 40-year case that honorable member talked about, finally ended at the Supreme Court. I'm sure even if we were to go into archives, we will find that from there, from the General Supreme Court, the person might have gone or up for review. You see, so the Supreme Court has so many jurisdictions that if we decided to keep numbers at 9, we would not be able to work. We will not be able to work at all. The only thing that we have to, there are 2 things. And either we increase the numbers, 19 may be all right for now, but the way things are going, the way cases are coming up, and the way we are thinking of AI and other things, we may see now cybercrime, everything. There are modern areas that are coming up that we have to empanel judges to deal with. The way things are going, if we don't take care, we might end up with about 25 Supreme Court judges. The surest way of avoiding that calamity is for all of us to come together and maybe through the Constitutional Review Committee, reduce the jurisdiction of the Supreme Court, the various jurisdictions that we exercise. Like Honorable suggested, we could say that every appeal should end up at the Court of Appeal. There shouldn't be interlocutory appeals. There shouldn't be that. There are so many things that can be taken off. If we say that you cannot start any, because you can't start a presidential petition in any court apart from the Supreme Court. By an ingenious way of interpretation, even though all cases can end at the Supreme Court is said that parliamentary petitions can go only up to the Court of Appeal. That was very, very ingenious. And so parliamentary petitions end up at the Court of Appeal. If we could find a way of putting into the constitution that we want to craft for ourselves, so that cases can end at the Court of Appeal. Or, for example, criminal cases can only end up at the High Court or the regional tribunals or whatever. Then we can start thinking about reducing the number of Supreme Court judges. Otherwise, we should be prepared for a situation where we can have 20 or more Supreme Court judges in future.
Honourable Member, do you have any more questions?
No, Mr. Chairman. I just want to thank my Lord, and then I wish him well. Thank you very much.
Thank you very much.
Thank you, honourable members. My Lord, our revered guest, it's now my turn to ask questions. And by our practice and procedure, I don't have limit to the number of questions I'm supposed to ask. However, I have sat throughout the proceedings. I have listened to all questions asked and answers provided. I do not have any question for my Lord. Honourable members, I will then proceed to congratulate my Lord on his nomination as the Chief Justice. And before discharging him, recognize and acknowledge the revered guests, which I will do not in any order, but I will start from the guest list of the Honorable Nominee. We have Director General Prison Service, Patience Baffoe-Bonnie, a spouse of the nominee. Then the following people are the children of the nominee: Sandra Elizabeth Baffoe-Bonnie, Major Felix Baffoe-Bonnie, Engineer Eben Leslie Baffoe-Bonnie. They are the children of the nominee. Then we have brothers and sisters: Mrs. Georgina Konedu Kusi, former Council of State member. We have Peter Baffoe-Bonnie. We have Mabel Baffoe-Bonnie. Then nephews. We have Justice Baffoe-Bonnie, Enoch Baffoe-Bonnie, and Dr. Kofi Bonzi. Family. We have Mary Nikwe, Rosemary Boafo, Commodore Faustina Anoche, Kwame Asaribuedu, Jefta Apau, Esquire. Then we have the representative of His Royal Majesty Otumfo. We have Nana Sampamahini. We have Nana Amantahini and Amantahini. Anantahini. Forgive me if I don't pronounce it well. Typical Aigbe boy pronouncing three names. Then we have Nana Dr. Abura Boatin, Nyinahini in the Ashanti region. You are welcome. Then we have Reverend Father Akes, Christ the King. Reverend Pastor Tete, Assemblies of God. Then we have all students of...
Well, so from 11 a.m., it's almost 7 p.m., you could say 8 hours straight, even though there have been some breaks in the middle of for the vetting of the foremost member of the judiciary of Ghana, the Chief Justice, Justice Paul Baffoe-Bonnie. He has gone through the vetting process at the Appointments Committee of Parliament, and that's the concluding part that you've just heard there. He's been asked all the questions that have to be asked, even though it's just from the NDC side. The minority NPP side staged a walkout earlier in the day. Gentlemen, let's wrap up. Let's just take a quick comments, your key highlights before we leave. Mine, of course, would be where he said that we don't have enough lawyers, we should train more lawyers. That for me is exciting. So it means that And he even talks about expanding the law school so that many more students would be admitted. And I always make this point that why do people say we have too many lawyers? Why don't we say we have too many teachers or too many doctors? Especially when lawyers pay their own school fees to go to school. Let the person go. He has his money. He wants to go to school. Let him write the exams. If he fails, he fails. If he passes, he passes. But this issue about too many lawyers, I don't understand. So, my Lord Justice Baffoe-Bonnie, oh, you are doing my job. Sorry, you don't understand. Me say me that as in Yango Ponchirao. Fred, your takeaway.
Very controversial beginning of this particular vetting, leading to the minority working out. But then a very good vetting process.
Despite the one-sidedness?
Despite the one-sidedness. At this point, you're expecting that maybe the members of the majority side would have just let the Chief Justice go just like that by asking one or two questions, but very deep questions about how to improve the judiciary, questions about the number of Supreme Court justices on the court now and whether there were too many, and the fact that he believes that they are either going to expand it to about 2025 or get the Constitutional Review Committee to really look at the Constitution to reduce the jurisdiction of the Supreme Court. And also, one of the things I was looking for him to answer is the concerns about the minority. One of the reasons why they walked out.
Which he did.
About the ongoing cases filed by the removed Chief Justice, Gertrude Tokonu, and whether the Parliament should have gone ahead with this particular vetting. It was his view that he doesn't believe that this vetting should have been stopped. He says Parliament was carrying out its constitutional duty and nothing bars Parliament. There's no court order, there's no court ruling which bars Parliament from going ahead with its constitutional duties. And therefore, he believed that this particular vetting was right. So yes, all in all, I think that it was a very controversial beginning, but a very good process.
Sami?
Well, Sandra, I three observations. The walkout by the minority, I felt to get some shine out of the whole vetting process. I thought that if minority members were in there, the tough questions, there were going to be tougher questions than what we saw from the majority, even though those questions, as Fred has said, were good questions. But I believe that if the minority and their leadership were present at this vetting, we're going to get something better than what we saw a while ago. My second observation about his comment about why he sentenced Atai 70 years, I thought it was what word can I use? It was too harsh, for the reason that he sentenced 70 years because Atai may come back and come and attack his family.
I think you took him out of context.
So I think so in sentencing there is a procedure that a judge follows, and again you cannot sentence beyond what you can sentence. So if the law did not permit him to sentence up to 70,
no, but the explanation and the justification.
So the explanation he could have used his family, but he actually may have meant you and I, our families. That if the person was a dangerous person to society, he would come out and harm members of society, and that includes him. That's the sense I get, unless
about the congestion in the prisons, and was making that as an example, one of the examples why he thought there are numbers in the prisons and why he thought that community service should be introduced.
My third observation is about the election petition. Why there is a need to move the election to November, so at least they can have enough time. It's a call I support.
Something we've been talking about.
It's a call I really support, because the first ever petition that we saw took about 9 months. 8 months, yeah. The other one, which was the 2020 election, took a number of months. So I feel that this is a call we should all support and see how best we can drive this and change the date for the election. I'm sure the election, the Constitutional Review Committee is still collecting data on this, and I feel that if they can add it to it, it will help our democracy.
Very well. So that has been our coverage of the vetting of Justice Paul Baffoe-Bonnie, Chief Justice nominee, and he was in the committee's room with a huge number of justices of the Supreme Court and even Court of Appeal. And also his wife, who is the Director of Prison Services, also came to support, and she was also there with a number of her lieutenants. And so if you were watching without knowing what was happening, you would think that it was a conference of prison officers and judges and MPs. So all the three put together in one small room. It was a beautiful spectacle to see. We wait to see what the committee would recommend at the end of the sitting today and hear how Parliament is going to decide on this matter moving forward. This has been our coverage on Channel One Television and on 97.3 City FM. I am Umar Rusanda Amado. I did this with our Head of Current Affairs Production, Tete Jabano, and our News Editor, Sami Uyafi. We'll return with other programs on City FM and on Channel One TV.
Kevin, be a good boy. Focus on your studies and don't follow girls with longer life than their future.
Your son is under VIP security and I'm the head of domestic affairs. Johnny Mami, don't be optical. Guys, we need to boss in the man Roma. Johnny Mami, what is? Milko Dono. Boy, me more feeling what is?
Okay, Senior, thank you.
Yeah, you think it's free? Major garage and Katia, sugar, share, Mamino Yasamwati. Survivor Pass. Hey, that a beating to make a torture boss. H&N Gary. Wait now. So you Gary. For me, oh yeah, Papa. Chapomas.
You have the choice to pick and choose. So you choco Gary. Boys and girls, why I see? What are going for here? This advert is FDA approved.
Hey Ghana, so you follow me, brother man small. If you knew, it's your boy. Kill them all. But this time, I'm not only killing mosquitoes, I am killing the greats. See? This wouldn't have been possible if I didn't have the perfect mosquito-free atmosphere. Thank you, Out Insecticide. And yeah, Out Mosquito Coil. For a mosquito-free atmosphere, trust Out to... You are not serious.
Out Insecticide. So ya boa, faha.
Christmas, my favorite time of the year.
This festive season, Volta Serene Hotel invites you to experience the magic of Christmas and New Year like never before. From 20th of December to the 1st of January, step into a world of joy, music, laughter, and celebration. We begin on the 20th with a soulful carols night, filling the air with warmth and melody. Then, on 23rd and 24th of December, arrive in style as we welcome you with fresh coconut and local treats. Christmas Day brings pure delight, exciting moments for kids, relaxing escape for adults, and an elegant all-white dinner under the stars, crowned with a spectacular fireworks display. On Boxing Day, embrace culture and rhythm, from picnics and traditional dance to an unforgettable high life and old school night. As the week unfolds, enjoy movie night, live music, karaoke, and endless fun. Until we welcome 2026 with a breathtaking fireworks show on New Year's Eve. Special Christmas packages starting from 4,050 for individuals, 5,250 for couples, and 8,900 Ghana cedis for a family of 4 for 2 nights. Call or WhatsApp 0541 539 867 or 0362 025 243 to book your experience today. Volta Serene Hotel. Feel the serene touch.
Another week is here. Hello there and welcome to Trending Africa with me, Samuel Akom. On all social media platforms, I am at the Samuel Akom. Trending Africa is a show where we take you through the African continent to bring you stories making the headlines. What stories are trending? Let's go for a quick break. When we return, we'll check all of these stories out and many others. Don't go anywhere. Please do stay. Welcome back from the quick break. This is still Trending Africa with me, Samuel Akom. On all social media platforms, I am at the Samuel Akom. Let's begin the episode from Nigeria. And in Nigeria, more reactions are coming in following President Donald Trump's indication of sending in a military action to the northern part of the country to tackle insecurity. Some Nigerians have described the act as interference, and some have welcomed the decision. Here is more in this report.
Trump's warning of a possible United States military invasion has sharply divided Nigerians, both online and offline. Retired ECOWAS diplomat Ambassador Haruna Warkani says dialogue, not confrontation, should guide Nigeria's response.
Nigeria has finally been characterized as a country of particular interest for American government, and those characterizations are usually not too good for a nation. So Nigeria, therefore, now has to do something very, very urgent, and that something means the Ministry of Foreign Affairs needs to be activated properly and extraordinarily, actually, to counter this.
In Kaduna, reactions were shaped by religious and political sentiments. Islamic cleric Sheikh Ahmed Gumi urged the government to resist what he called America's high-handed approach.
They have a plan which they have already, but now they want to execute it because I think that is just the right time to do it. Otherwise, what is happening in Nigeria, nobody denies there's a lot of bloodshed, but it has no any religious or ethnic coloration. It's just a question of land and survival. So we as a nation, we have to come together and see that this negative narration does not have ground.
The first error we made was to even say, no, there's no killing. I think that's really hot. That's really unfair. Every sensible and true Nigerian who will look at Reverend Hayab on the face and say there has not been killing of Christians, that day I will know that he's not honest. Has there been a shift? That's a different conversation. But to say there is not, haba. Because for deliberate reasons, some people twisted this whole killing thing into farmers-herders conflict.
What I'm concerned is about life and property. And for me, any government that cannot take care or oversee its citizen, I don't think it's a better government. You understand? Because every government is supposed to be concerned about this citizen well-being.
In Plateau State, where insecurity has lingered for years, Trump's remarks triggered mixed emotions among residents, many questioning United States motives.
To me, it is a very much welcome idea. Lives are being wasted, properties destroyed, people becoming refugees in their land, and people are becoming so apprehensive and restless. And this is a war that has been on for more than 20 years. And if Trump's intervention will bring an end, fine.
We see it as a political witch hunt. I am not an APC member. I'm not in support of the government policy because what we are expecting or what we expected from the government is totally out of the box. But concerning the Christian genocide in Nigeria, it is something we debunk in totality. I disagree with that statement because if you look at what is happening today in our country, is an interest, it's an international interest. You cannot go outside the box of your colonial masters when you know they have a tick in the affairs of your country and said you will have no business with them henceforth.
If Trump is to send his own army to come and settle this matter of killing of Christian or Muslim or thereabouts, I think is the right thing, but it depends on how they do it. Because if they should come and start, let's say they start killing people anyhow, maybe if they find you guilty, they will just kill you to increase the problem. So my own point of view is that he should send his own people, they should come and settle the case in a peaceful way.
In Katsina, residents described Trump's position as undue interference in Nigeria's internal affairs. They argued that the United States, often seen as a model democracy, should be better informed before making such sweeping claims.
The reality on ground is that both
more Muslims are killed. If you could remember, not too long ago, the 52 people were killed in Malumbashi local government. There are so many instances of large communities being displaced, being killed, mostly Muslims.
We welcome the assistance if there is anything they can do, but not coming up with I will put it like a threat to Nigeria. Nigeria is a sovereign nation.
Only people of one faith are being killed in Nigeria. This is a one-sided narrative, and I urge Nigerian leaders to take this issue very seriously.
In Maiduguri, residents urged the Nigerian government to take charge of the fight against terrorism rather than depend on foreign threats or promises.
The Nigerian government should take decisive action against Boko Haram, banditry and kidnapping, and bring to justice those sponsoring them. The security situation affects both Christians and Muslims. We are all one. The US government should guide us on how to resolve this crisis. The suffering and hardship we face are results of insecurity. If people could access their farmlands without fear, we wouldn't be experiencing this situation.
The problem now is that, you see, somebody like Sheikh Jafar, you see, they killed this man in the mosque, in the morning prayer. He is a Muslim. He's an Islamic scholar. So the only thing is, let's come together, please. Let's forget about a Muslim or a Christian, because they bomb church, they bomb mosque.
In Kano, residents told Trust TV News that any form of American military intervention would be extreme, even if the intention is to help Nigeria overcome insecurity.
I think it's an extreme position, which from every indication does not tally with our sovereignty. We are a sovereign nation. There's other way American will have intervened. And one of the ways I think they can intervene is ensuring that you help our government to strengthen the capacity of our armed forces to actually confront these guys.
To me, I don't think it's going to happen. It's a way of blackmailing Nigeria into actually granting so many things to the United States. If you remember what Donald Trump did to Zelensky sometime early this year, when he wanted to actually send American companies to start exploiting minerals in Ukraine, the man resisted.
As debate intensifies, Nigerians remain anxious about what the standoff means for Africa's most populous democracy still battling deep insecurity that has cost thousands of lives.
Let's just stay in Nigeria and take you to the presidency, because President Bola Tinubu has indicated that his government is on the right track to restore economic freedom to Nigerians. This follows a report indicating that the country has made some strides in terms of successful Eurobonds and issuance of bonds. The president also used the opportunity to comment on President Donald Trump's threat of sending in military action to the northern part of the country. President Bola Tinubu says they are dealing with the issue diplomatically. Kendi Amudu of Trust TV News has more.
Despite the fact that its economic gains are not impacting positively on majority of Nigerians, government continues to blow its own trumpet about its successes with the economy. The latest of such gains is the successful Eurobond issuance, which Minister of Finance says is a testament to the continued investor confidence in the country. Other successes, which it says draw down from the president's bold and sometimes unpopular economic reforms, are the growth of Nigeria's GDP by 4.23% in the second quarter of 2025, which is the highest in a decade.
13 sectors recorded growth above 7%, up from 9 in the previous quarter, showing broad-based resilience. The industrial sector nearly doubled its growth from 3.72% to 7.45%. Reflecting rising productivity and investor confidence. Inflation eased to 18% in December, while, as we know, foreign exchange reserves topped 43 billion and our trade surplus topped 7.4 trillion. clear examples of macroeconomic stability.
President Tinubu's comments acknowledging the economic gains are brief, and so is his veiled response to the diplomatic back and forth with US President Donald Trump. It is his first spoken response to allegations of genocide of Christians in the country and the threat of military intervention by the US.
The task ahead is immense. We are engaging the world diplomatically, and we assure all of you that we will, defeat terrorism in this country. The task ahead is immense, but it's our resolve to move forward with unity and purpose, guided by renewed hope agenda to build a prosperous, inclusive, and resilient Nigeria. Thank you very much.
Before the meeting of the Council of Ministers commenced in full, Secretary to the Government of the Federation, George Akume, paid tribute to two members of the cabinet that had passed on. Senator Solomon Ebuga served as Minister of State for the Federal Capital Territory between 1999 and 2003, while General Muhammad Abdullahi was Chief of Staff to President Olusegun Obasanjo and briefly to President Umaru Musa Yar'Adua. From State House Abuja, Kehinde Amodu, Trust TV News.
Now, globally, journalism is one of the most respected professions. Yet, it also remains one of the most risky and challenging one. Especially in Nigeria, where some sort of insecurity continue to reign, the safety of journalists have become a major concern. And experts are advising journalists to prioritize their personal safety first. Here is more in this report.
For journalists, particularly those who report from the field, experts say taking personal responsibility for safety should always come before any assignments. They also advise that journalists must study and understand the environment they are heading to while staying alert and cautious of their surroundings. According to them, while safety can never be fully guaranteed, awareness and proper preparations can significantly increase the chances of staying safe on the job. Across Nigeria, journalists face numerous risks in the line of duty. For instance, Victoria Tokolo, a freelance reporter with Trust TV, was attacked in July 2025 in the Agege area of Lagos State, with her essential work tools seized. But safety goes beyond physical protection, as safety experts emphasize the need for media organizations to provide comprehensive insurance policies for all employees, especially those reporting from volatile areas.
The Nigerian society now is a bit volatile, just for everybody, not only the journalists. But by virtue of the kind of job the journalist does, it becomes sort of a target, and oftentimes you get casualties. Recently, a journalist jumped from the historic building and then broke her legs and died in the court. So those are kind of sad stories we hear every day.
You need to talk about the safety of you first, before the safety of what you are doing. And then before you go to the field, you must know exactly where you are going to. Beyond knowing where you are going to, you need to tell your family members where you are going to. That is the safety that you need to initiate for yourself first, before any other thing.
Again, it is very important that media houses consider insurance for the journalists, because it faces high risk, and insurance is like a cover. And when the journalists are going out there, they know that there is a cover for them, and so because to become part of what the media houses should provide for the journalists.
Another part of making sure that journalists are able to work safely is making sure that there are important insurance policies, whether that's group life insurance, whether that's life insurance, whether that's health insurance, very, very important. And these are policies, those are insurance policies that organizations can get, because they are getting it in bulk for their staff, they're able to get it, discounted, than what a private individual would get if they went to a company by themselves.
They emphasize that since no story is worth a life, every journalist must understand that beyond storytelling, their safety comes first. And for media organizations, while informing the public remains a duty, protecting those who tell the story should always be a top priority.
This is still Trending Africa with me, Samuel Akom. On all social media platforms, I am at the Samuel Akom. Let's go for a quick break. When we return, we'll check out some more stories. Don't go anywhere. Please do stay.
Hey, Ghana. So you people know Miss Brother once more. If you knew, it's your boy. Kill them all, kill them all. But this time, I'm not only killing mosquitoes, I am killing the greats. See? This wouldn't have been possible if I didn't have the perfect mosquito-free atmosphere. Thank you, Out Insecticide. And yeah, Out Mosquito Coil. For a mosquito-free atmosphere, trust Out to... You are not serious.
Out Insecticide. So ya boa, faha.
Kevin, be a good boy. Focus on your studies and don't follow girls with longer life than their future.
Your son is under VIP security and I'm the head of domestic affairs. Johnny Mami, don't be optical. Guys, we need to boss in my mother Roma. Ma, Johnny Mami, what is? Milko Drono. Boy, me more feeling what is?
Okay, senior, thank you.
Yeah, you think it's free? Major Gary and Katia, sugar, share, Mammy Nunya Samwati. Survivor Pack. Hey, that a beating to make it to Chobosu. Agent Gary. Wait now. So you Gary. For me, oh yeah, Papa. Chobomas.
You have the choice to pick and choose. So you Choco Gary. Boys and girls, why I see?
What they going for here?
This advert is FDA approved.
Welcome back from the quick break. This is still Trending Africa with me, Samuel Akom. And on all social media platforms, I am at the Samuel Akom. Let's now head over to Ghana. And in Ghana, the President of the Republic, His Excellency John Dramani Mahama, has called for a new platform to engage the Sahel state to form a joint force in tackling insecurity and terrorism in the region. He made this call during a joint press conference at the Jubilee House when the German President Frank-Walter Steinmeier visited. ChannelOne News' presidential correspondent Akusia Ochre has the details.
The German president arrived at the Jubilee House to meet with President John Dramani Mahama following his arrival in Ghana on Sunday. The two leaders held bilateral talks focused on strengthening economic cooperation, renewable energy, and industrial growth. Addressing the press after the closed-door meeting, President John Mahama discussed regional security issues. He noted that the withdrawal of Mali, Niger, and Burkina Faso from ECOWAS and their absence from the Accra Initiative had weakened regional coordination in combating terrorism.
Unfortunately, currently the AES states are not participating in the Accra Initiative. And so what I've been engaged with is seeking a new platform that can bring them on board, because the fight is not theirs alone. It's a sub-regional fight, because violent extremism is like a cancer. It continues to grow and spread. And so currently we have discussions. I was in Mali a week ago to discuss the issue of a joint platform where we can collaborate to help them, and the international community can assist in the joint fight against violent extremism.
Both countries are also advancing discussions on a labor agreement that would enable Ghanaian workers to access employment opportunities in Germany.
Bilateral agreements between us and other European countries that allow these skilled young people to go and work on fixed contracts in Europe be able to earn a decent income and bring that expertise back to our country is the better way to go. And so the discussions with Germany are ongoing, and I believe that at the end of those discussions, we'll be able to find a way where we're able to contribute to ameliorate the skills shortage that Europe is facing, but at the same time, create opportunities for our young people to be able to experience a whole new world.
The German president commended Ghana's business-friendly environment, describing the country as one of the best destinations for investment and partnership.
Ghana is already a very attractive location for many companies and a very important hub here in the region. A hub that allows you also to serve the markets in the vicinity, in the neighborhood here. And you have many advantages speaking in your favor that you wouldn't find elsewhere in Africa. The people here are well skilled. English is widely spoken, and also I hasten to add the time difference between Ghana and Europe is negligible. These are all factors that, taken together, make Ghana the ideal partner.
Let's stay in Ghana and bring you this story because in the course of the week, the Environmental Protection Agency, EPA, led by their Chief Executive Officer, Professor Nanama Brown Kluche, shut down 19 Chinese-owned warehouses which were manufacturing chanfangs used in illegal mining activities. According to officials, these warehouses were registered to be selling spare parts of some equipment, but it turns out those warehouses were being used to manufacture equipment used in illegal mining. Here is more in the following report by ChannelOne News' Doris Lonta.
The operation follows the EPA's recent nationwide directive banning the fabrication, importation, sale, and use of chanfan machines due to their harmful effect on the environment. The authority says the manufacturing of these machines is being conducted without the necessary environmental permits or authorizations, contrary to the Environmental Protection Act 2025, Act 1124, and the Environmental Protection Environmental Assessment Regulations 2025, LI 2504. In an interview, Professor Kluche says the clampdown is part of the EPA's broader strategy to tackle illegal mining and its devastating impact on Ghana's water bodies, forests, and farmlands. She emphasized that similar enforcement exercises will be carried out in other regions heavily affected by galamsey to ensure full compliance with the new environmental regulations. She warned that any individual or warehouse found violating the directive will face prosecution.
Some people have permits to operate the warehouse, but their permit condition they told us to permit them as EPA was that they are going to sell spare parts for caterpillars and big trucks. But when we see water pump, we see the mat that captures the gold. We see water hose. We see engines, radiators, and all these machines. This has nothing to do with caterpillars. So we know clearly that they are illegally operating or selling these machines and parts to illegal miners in the country. Largely, most of the shops we've been to, probably all of them, are owned by Chinese nationals. We've not seen a single Ghanaian-owned shop like this. So we are still on. Maybe we'll meet, maybe we'll not meet. But as it is illegal, we're closing down and taking them on.
Deputy Chief Executive Officer of the EPA also highlighted challenges encountered during the enforcement exercise.
The man is inside and when they saw that we started operations from the first shop, they all closed themselves into the shops. We have spent the past 10 minutes trying to break through this door. And just when the door was broken and we entered, the Chinese man was standing right at the entrance.
EPA officials have urged the public to adhere to the chanfan ban or face sanctions and possible prosecution. Reporting for ChannelOne News, I'm Doris Lonta, Ashanti Region.
And lastly, before we take leave of you, President John Dramani Mahama has cut sword for a multi-purpose solar project in Dawa Industrial Area within Agoto. According to the president, this project will drive industrialization and the growth of businesses in the country. The president also weighed in on a controversial PDS deal. Here is more from presidential correspondent for ChannelOne News, Akusia Poche.
Solar for Industries Limited launched a landmark solar energy project at the Dawa Industrial Zone in Accra. The initiative is projected to become one of the largest solar installations in West Africa, with a target capacity of 1,000 megawatts peak by 2032 and will be executed in phases. President Mahama described the project as a pivotal shift towards renewable industrial energy.
The Solar for Industries project, developed by Park Solar in partnership with Quam Investments, the International Finance Corporation, and with technical cooperation from the EPC contractors who are Chinese, marks a significant shift towards renewable industrial energy. This facility will produce clean, stable, and affordable electricity dedicated to Ghana's manufacturing and export zones. And this is the core of our 24-hour economy and industrial recovery program.
As part of efforts to integrate energy innovation with industrial transformation, the president announced further plans for the Green Digital City.
The feasibility study and the design for this city will begin by the end of this year. And the Minister of Finance is already making budgetary provision for the designs and feasibility studies.
The International Finance Corporation lauded government's fiscal discipline performance.
Ladies and gentlemen, and before I close, I must share a thank you to the current government and to the regulators in the current government for the remarkable fiscal discipline this year, in which we are all benefiting. It is precisely because of this fiscal discipline, which we're all benefiting, 8% inflation announced yesterday, stable exchange rates, reduced interest rates, currency convertibility. I could go on. But also importantly, we've seen credit ratings. So companies like LMI and other companies here in this audience can attract private capital. Or Ghana can attract more international business to relocate here. There are plenty of businesses in other parts of the world with jobs, and they have a place to go. They are now increasingly interested in Ghana. So this first principle on the investment climate is fiscal and macro discipline.
Meanwhile, the president said while the PDS deal under the previous administration was intended to inject private sector efficiency into Ghana's power distribution, collapsed due to how it was managed.
But let me also comment on what is possible if the public and private sector work together. I know that there was an attempt to involve private sector in power utility and at the distribution level. And we all remember the example with PDS. PDS was not a bad thing. It is just that it was handled wrongly and many people had personal interest in PDS, and that's why it failed.
And that's all we have for you on this week's episode of Trending Africa. On all social media platforms, I am at the Samuel Akom. See you same time next week. Bye-bye.
It's a 3-day agri fair. Started on Friday. Today is our second day and we are on till Sunday. Over 100 exhibitors of various food items. And Today when we got here, the rain did something small. So don't depend on the rain. But we have people who are doing livestock and poultry on this side, fruits and veggies here, farm equipment and support services here, and sponsors here. So you decide where you want to go first, and we'll let you visit some of the stands, and then we'll know how it goes. So he will be doing the interviews with you, and she'll be briefing you on the various stands. So this is Premier doing, I'm head of event.
Yes. This is Pop Farm. So Pop Farms, he has about 10,000 beds. Yes, and he is here. So tell us a little bit about your farms.
Nice meeting. Yeah, we are local farm that grow local birds, broilers mainly, and we process it. We don't just grow it. We process it, and the type of parts that we have, all the parts that we import here, we have it here. So we have the breast, we have the leg quarter, every part of the chicken. We're now coming to package. Yeah, we are coming to. We have plans of packaging. Yes, we do the cutting. Yeah. Mainly we supply the supermarkets, so that's where we started from.
Yes.
More acreages. Okay. So yesterday we brought some of the palm fruit here. Even at the moment our vehicle is even on the road, bringing some of the palm fruit for us to sell it. So we have even lettuce. We produce cabbage and carrot. We have rabbits, which is behind. The rabbit is produced from. The rabbits are behind. Wow. So that's why. Oh, we've been there. Even the fertilizer that you gave it to us for the feed program, we are still comparing it. Oh yes.
And then this is Baffoe, so they are into, planting in bowls and so this is how they do their farming. So they are trying to promote people from farming if you don't want to do the proper soil. So like especially those who are home, flower pots instead of
the home garden.
Exactly, instead of flowers and stuff like that, we can do this. Yeah. So tell us about Feed Ghana. We are listening. Ghanaians want to know.
Just as the name implies, Feed Ghana. The intention is clear. We want to eat what we grow. We want to grow what we eat. So every space we have in this country where you can put anything and to grow, that is what we are preaching. So that everyone, anywhere in the country, look at these things here. You put it on, on your corridor, anywhere, uncompleted building, and you are picking this. You don't go to market to buy this.
And let me talk to the man himself here. Mr. Demoji, you are here. So we know the concept now. How do we practicalize it? So if I want to come to Feed Ghana, if I want to be a beneficiary, where do I start from?
Yes, it depends upon the level. If you are a farmer in terms of cereal, you have to organize yourself into cooperatives. Because we are the modalities for benefiting from the Feed Ghana program is to organize yourself into cooperatives. So as a cooperative, you write to us either at the district level, at the regional level. We will get the information and you'll be taken care of completely.
The Ghanaian people must understand that we have to develop our nation for ourselves. We can't sit here and expect somebody from somewhere to come and develop Ghana for us. What they are doing here, they are adding value to our raw materials.
This is the horticulture business platform.
Yes. Thank you. Thank you very much. Thank you very much, Honorable. I'm very happy you are talking about us buying our own produce. That's actually one of the key things that we do. So horticulture business platform, we are a membership-based company that brings all the players within the horticulture sector together. And currently we have about 230 members, and we encourage them to produce locally and also encouraging the market to consume. I really love the fact that we need to encourage people to eat what we own, we produce in Ghana.
Eat Ghana.
Eat Ghana. That is the only way that we can be able to be successful.
So hi, AgroKent. Yeah. So what do you have? The long grain and
we have the long grain, then we have the short grain, then we have our cereal as well. This is made with the rice and soya bean and wheat. Yes, please. And then now we have our gari. We have Nane's gari. We started cassava farm, so yeah, we have gari. Okay. We have our spices here as well. We have like natural ginger powder, onion powder, and garlic powder. And then we have our sauces here as well.
This platform that City FM has created for you.
Do you have any other means of letting the Ghanaian people know your products and then patronize?
Yeah, so we use the social media a lot. So when you go on our social media, we take you through all the day-to-day activities on the farm. Even if you are planting rice, we show it on all our social media platforms. And now we have an office at Accra too. And we give
those who are not on social media.
We give so we are in the markets as well. We are in the local markets as well.
Right. So just quickly tell us some of the things that you have here.
Okay. So this is Greenfield, and we basically deal with both exotic and then the local fruit seedlings. So now
these are fruit plants.
Fruit seedlings.
Okay.
Fruit seedlings. When you want fruit seedlings, basically we deal with fruit seedlings. Okay. And then we have some plants, exotic ones that people think it's not working here. Meanwhile, it's doing so well here.
I can see passion fruit.
Yes, you can see passion fruit is doing so well here. And then we have apple. Apples are doing very well here.
Really?
Yeah, apples are doing grapes. I have grapes, varieties of grapes.
They are doing very well.
Everything they are doing very well. Ghana, cause everywhere, Ghana. To me, I stay at Teshi, and it's doing well. So something like the apple, I have mine in a pot. You can also pot it. Just give it a big pot, and you are good to go. And then we have pear, which is not avocado. We have the foreign pear. We have something like peach. We have plum, variety of plums, everything.
Talk about some of the benefits of home gardening. What would you say?
Lots. A lot. So home garden per se, from my experience, one, it really helps me to save money.
Hello. Hi, Pegs. So what do we have on display?
Well, we have granola. That's oats mixed with healthy seeds like pumpkin, coconut, which we source from Ghana here. We import some of the ingredients, but we source some from our local market.
Which ones do you import?
The oats, yes, and then the pumpkin, for instance, yes. The coconut we get from Ghana, from our local market. We get the honey as well. So we've mixed it into a very healthy and convenient. I mean, there's not a snack, a meal in itself. You can snack on it as well. We have shito, also convenient for the office, everything convenient. And we've sealed it.
Your packaging is nice.
Yes, for exports, for your office, when you are traveling. As busy as my minister is, when he's traveling, he's got a very small one like this. He takes it with him. He has his cocoa, what do you call it, kenke, bagu, yes.
So what we see is water. Is this just water? Is there something else?
Yeah, so we are from CSR Water Research. We do research into water-related resources. So for the purpose of this exhibition, we came out with our catfish. And what we have there is our heterotis. And that's what usually they used to do, the momone. Yeah, super cool. Yeah, super, yes.
You know.
And then we also have our catfish. Yeah, so we've moved from just giving it raw like this. We have the process now. We have the smoked catfish at the top, and then we have the fresh catfish, all registered with FDA, and you can find them on our local markets or when you come to CSIR.
So this is a seed we sell to farmers. Okay. These are certified because people are going around selling fake seeds to farmers. So we always want you to come over to the CSIR Farm Research Institute to get your planting material for both the coconut and the oil palm. Right. From the exhibition, the response we are getting, the people are saying, oh, they say it is tall, they say it is short. By the time we go, it's not what we are expecting. Come to the CSIR Farm Research Institute and get your planting materials from us. And we are assured of the quality that we're going to have.
We are responsible for backstopping with all the technologies and the production of seeds for all the farmers that will be engaged in Feed Ghana project. We have most of our high-yielding ones. We are bent on helping Ghana to cap the importation of rice into Ghana. So with most of our rice varieties that we have released under the FSRP, the Food Resilient Project, we are responsible for producing and supplying the Japa seeds for all farmers that would go into rice production and help Ghana to be sustainable in terms of rice production.
Right, so tell us about what you have here.
Okay, so this is CSR Plant Genetics Resources Research Institute. Our mandate is to conserve the plant genetic resources of this world, actually seeing. And so we have a lot of plant resources at the institute. We have seedlings, we have seeds. Mainly these seeds are not for sale. We give it out for free, yes, to help our farmers.
Right, so this is Forestry Research Institute.
Oh, okay.
Yeah.
Oh, the
So the same group?
Yes, this is pure honey from our bees' hives. And it's the qualitiest you can get in the market.
No, do you export?
No, we don't export.
Why?
We haven't scaled it up yet. Maybe we are looking for partners to scale it up. The market is very, very available in the market, in the Ghanaian market.
The European market.
No, I mean locally.
As for the local market, we don't have anywhere. It's the international one we're looking at. This is the first time hearing about it.
Okay. So syrup.
Yeah.
Okay.
So
What do you
extract from the fruit itself, and it is used to manage high blood pressure. It also serves as an antioxidant, and it also works on your blood sugar level issues. So this is one of our products that we are actually looking for partners, to scale it up. Yes, in the market. It's 50 cedis.
So how do you
take it? You put a teaspoon of it in warm water of 250 ml, and then you drink it in the morning. Warm water or lukewarm water.
So you don't like spice?
No.
CSIR is the foremost scientific organization in this country with 13 different institutes. Most people make the error of thinking CSIR is one. We are one, but with 13 different institutes. So if you want scientists, technologists to help you with training, research on animals, for example, CSIR Animal Research Institute is there. Post-harvest processing, CSIR Food Research Institute is there. If you want things to do with the forest, beekeeping training, and honey production training, snail training, things to improve livelihood and also create jobs.
If we're able to do export, then we have to add value to whatever we produce. And I've seen that a lot of farmers are now adding value to their produce. They are packaging very neatly, and so most farmers are now ready for the international market.
Our food import bill is estimated above $2 billion annually. And so every year, we throw away $2 billion to the foreign market to go and buy food to supplement local production. So clearly, our agricultural landscape is a paradox which must be looked at critically. Nature has bestowed on us a lot of agricultural potentials. We have the land in abundance, we have water, we have cheap labor, and we are close to market after it's here. So we have what it takes to use agriculture to engender economic growth.
So we're here, it's day 2 of the Agri Fair 2025, and exciting times. A lot is happening here, and one of our sponsors, DBG, that without whom we will not be here doing this. I'm here with them, and we'll have a conversation right now. Your name, please, and what you do.
My name is Anita Solomon. I'm the head of SDI Lending and Development Bank, Ghana.
Okay. And you are?
My name is Ivona Brafia, and I'm a manager for the Youth Bank Bank.
Okay. And yourself?
My name is Laurentia Abnerura, Head of Strategic Sector Development at DBG.
All right, so you see big, powerful women right here, okay, and doing many mega things. Now, let me just find out from you, why did you choose to come and support, sponsor AgriFair to make it a success?
Thank you. As you know, Development Bank Ghana has a very great interest in anything agri. So we thought this was a good opportunity to partner with City FM to do this fair. It also gives us opportunity to actually meet the SMEs face to face and listen to what their challenges are, what they will want DBG to do, so that when we go back and we are engaging with our partners, the PFIs, we will know what kind of products and programs that we can partner with them to help them solve some of their problems. So we thought this was a great opportunity for us to partner with yourself.
Now, some people say that DBG finances banks. So why not finance a bank to come and support us? Why do it yourself?
That's a good question. I mean, everybody knows DBG as being a wholesale bank, right? So you will not see our branches all over. We work through our partners. But we thought this would be a good opportunity to actually let people know of DBG itself. You understand? You know, and like I said, everybody that has walked through this fair, you know, because of the strategic way we are positioned, they come through and they ask us and we tell them more. So it's a good opportunity to showcase DBG itself. And as you know, we have great support of women businesses as well. So we just thought, you know, it's a no-brainer. You know, let's come here, let's face the SMEs direct, let them know about us, and then we will get to understand their needs, their challenges, so that we can develop programs and products with our PFIs to support them.
Now, the two of you, I want you to share with us your experiences at the fair so far. I mean, Ghana, we like fairs, we do fairs, right? But for us at ChannelOne TV, this is the first agri-specific fair, right? How has it been like for you?
Okay, for me it's been great. From day one, I've seen people trooping in, I've seen the questions coming in, and I think this is something that CTFM needs to repeat. I would really, really applaud you guys for this. It's been perfect.
All right, so far it's been amazing. It's been very educative as well, engaging with the SMEs, and also some of our PFIs are around to speak with the SMEs. So I think it's a very laudable program, and DBG appreciates the fact that we are able to meet most of the SMEs face to face. So I think it's very great.
Well, thank you very much, okay, and thank you very much for speaking to us. Legacy Crop Improvement Center, why did you come on board to sponsor the Agri Fair?
Well, we know, first of all, Agri Fair is a novel platform, and agriculture is playing a very important role in our life. And seed, we are the seed people. Seed is actually the foundation for everything in agriculture. So we have one of the best variety in the country as I speak to you. So we want to associate with you and make sure the farmers and other stakeholders have access to the technologies and the solutions that we have for their problems.
In terms of potential, what do you see as the future for this Agri Fair?
Well, I think it has come to stay. This is more like a proof of concept. Next year, we are looking to have a bigger platform than this. Maybe to have twice a year. Of course, I know you guys are media houses. That's not your profession, but we will want to have it more and more. It's a good platform to talk about.
Farmer Line, hi, your name please.
Hello, my name is Anita. I work with Farmer Line. It's been an exciting day so far. I think it started off yesterday with supporting the various farmers that came here, listening to them and the kind of innovation that they need, and that's what we put in place and we've been showcasing to them. So far it's been impressive, the number of farmers that have reached out to us and the support that they have needed so far is here. So it's nothing different. Farmer Line is a technology company that focuses on giving farmers access to 3 key things: access to information, access to resources like finance, and then access to market. So we are more keen about the knowledge that the farmers need to have to apply on their farm. So we build a technology platform that backs the extension officers supporting them. You know, we don't have a lot of extension officers in Ghana. So our technology implements or supports what they do already by giving the farmers access to information to grow our food well. And then based on the knowledge that they acquire, we finance them as well and connect them to market. So it's been interesting listening to the farmers here and then they accessing the services that they need.
Where can people reach out to you? Where can they find you?
So I think they heard about us on your radio, on the media, with a lot of publication that you did, sensitization. So a few of them heard about us and they approached us. And one amazing thing that you have been doing here is the agri-clinics. So we had opportunity to speak with a group of farmers. So you had poultry farmers, you had various kind of farmers, and then speaking to them, they approached us later on, asking for all the support, interested in downloading the technology and all that. So it's been impressive so far.
After the fair, where can they reach out? Where can anybody watching reach out to you?
So if you want to find Farmerline, the first thing is to look out for us on social media. So all our social media handles, Instagram, LinkedIn, Facebook, you can type Farmerline, the name Farmerline, you can find us. On our website, you can download www.farmerline.co, and also we are at Alajo, near Jowolo.
ABSA is supporting a lot of agric industry. We are supporting the agric to help that the businesses grow, and then we can all benefit as a country. We can employ more people, more youth to work. So we are at the end of the day creating businesses, employing people to work. So what we are doing is that we are supporting agri-businesses. That is why we are sponsoring this program. We are supporting agri-businesses. We are giving loans to them, 2 million at the rate of 10%. It's unsecured, so there is no collateral. Yes, 2 million. I like your wow. So we are giving 2 million, which is unsecured, no collateral. But if it is after 2 million, then that one will demand a collateral. We are supporting a lot of businesses, women-led businesses, fintechs, agribusiness, and a whole lot. So come to ABSA and bank with us.
Ghana Exim Bank is about international trade facilitation. The government of Ghana is saying that how best can we increase exports and then reduce import. So at Ghana Exim Bank, we are saying that if you're a farmer and then you are coming to us, for instance, I want to go into cassava plantation. Our focus is on the end product, and the end product is Gari. We'll then get to export that and be able to make some foreign exchange for the country. So basically, we came on board to support this because most of the people here are GESM funded projects. We have supported a few of businesses here, and so we are still open to supporting more because Exim is for the Ghanaian community. Yeah.
This November, something amazing is coming to Accra. Are you a farmer with fresh produce? Are you into fish farming, poultry or livestock? Then get ready for the November edition of the AgriFair 2025. Yes, AgriFair 2025. It's happening on Friday the 28th to Sunday the 30th of November. It's happening at the A4 Southern Children's Park, and it's 10 a.m. to 6 p.m. each day. It's the ultimate weekend marketplace. From fruits and vegetables to poultry, livestock and fish to agri-inputs and processing machinery, all at unbeatable farm gate prices. Whether you're selling or buying, this is your chance to connect, trade and grow. Enjoy the freshest farm produce, sizzling kebabs, and a vibrant marketplace atmosphere all in one space. Register now and secure your spot. Call 0558-973-973 for more information. AgriFair 2025, where culture meets innovation. The AgriFair 2025 is powered by ChannelOne TV and 97.3 City FM, and is proudly sponsored by Horticulture Business Platform, Development Bank Ghana, Legacy Crop Improvement Center, Judicial, and the Ghana Exim Bank.
Hello and welcome to the Channel One newsroom from our studios at number 5 Ola Hansen Lane at Tesano in Accra. I am Umaru Sanda Amadou. Coming up, Chief Justice nominee Paul Baffoe-Bonnie reveals ongoing plans to introduce 24-hour court operations in selected jurisdictions across the country.
I was telling somebody that maybe the president even stole his the 24-hour idea, economy idea from the Judicial Service, because we have planned for some time now to introduce courts around the
Acting Minister for Defense Dr. Keiselato Forson presents final report on the tragic military helicopter crash that occurred on August 6, 2025 to President John Dramani Mahama. One of 6 school plotters sentenced to death granted bail to the tune of 2.5 million cedis pending hearing of his appeal. Patients bear the brunt as Cape Coast Hospital reverts to manual record keeping following shutdown of the Lightwave Health Information Management System.
So interim, we've gone back to the paper system, and so we are using folders. Some places are using exercise books and other stuff just to be able to, when there are challenges, we don't dwell so much on the challenges. We see how best we'll be able to solve these challenges. So Cape Coast Teaching Hospital went back to paperless.
In Channel One business, stakeholders expectant of bold fiscal measures to stimulate economic growth in budget statements. And in Channel One sports, Ghana's Black Princesses beat host nation Benin to make it 2 wins in ongoing WAFU B Under-20 Girls Cup.